Can I just say something about Andrea?
Well, top of the morning to y'all. Good to be back. Getting ready for some Tyler Robinson hearing today. Okay, I got a warning for you guys already right off the bat. Warning. We're going to be a few IQ points short today. I'm a little short on my sleep from last night, but it's all good. It's all for a good cause. It's because I was busy getting filed my response to old Alice Evans's objection to me getting copies of the trial exhibits in her case. And so that has, I got it done. It's in. I do plan on going ahead and publishing it on my Substack once I get confirmation that everything has been finalized. There's a document, my actual like legal writing, my legal document is like, I've never used their e-filing system before, so I'm not totally sure how it works, but it's sitting in this like review state. So anyway, I don't want to publish stuff until I'm sure that it's been filed. But I will go ahead and get that out to you guys once I get that confirmation, so that y'all can see if you're interested what I've been up to. That's gonna make me a little on the dumber side today, but that's okay because we just have a hearing to watch. And yeah, expecting the bulk of this one to just be the order to show cause on contempt. This is the argument that the prosecutors are in contempt of the gag order because they made public statements to the press about the ATF testing on the bullet fragment that was found during Charlie's autopsy. So we know we're going to get testimony from Jeff Gray. We know we're going to get testimony from Chris Ballard. And we know this because they have been subpoenaed. It's in the court record. They've been subpoenaed for this. There was also, interestingly, a subpoena ducis tecum that was served on Chris Ballard. A subpoena ducis tecum is specifically a request for documents. A normal subpoena is just you got to show up and testify wherever you're supposed to be. Subpoena ducis tecum is for documents. And I saw that and I thought, that's kind of curious because we know that the defense was trying to get their hands on those intra-office communications and the communications with the press and all of that. And Judge Graf denied that. So I do wonder, is this like a little backdoor effort to try to get what he already said that they weren't entitled to? I would think not, but you just never know. So we'll see if we hear anything about that once they get started, what that's all about. There is another hearing that is technically on the record. Judge Graf did say we were going to deal with it today, and that is the defense's motion to preclude the use of quote-unquote reliable hearsay at the preliminary hearing. But I suspect we might actually not deal with this a whole lot. And the reason why is because they have filed a motion to submit it, like on the briefs, basically. And so typically when they do that, it just means the judge is going to decide it without argument. So they may not argue it. And frankly, it's the kind of motion that they don't need to argue. Like literally everybody knows this is pro forma. It is not getting granted. They are bringing it for the sole purpose of making their record for future possible appellate review. And the reason why I say that is because the use of reliable hearsay at a preliminary hearing is in the Utah Constitution. Like it's there. Utah says you get to do this. The Utah Supreme Court has looked at it and said you get to do this, and there's not a legal problem with it. There's not a constitutional problem with it because of the nature of what the preliminary hearing is. And so the defense is arguing, well, but the Sixth Amendment, the Fifth Amendment, federal constitutional standard, the 14th, all that type of thing, they make it a problem. But they might be right, but it's going to take either like the Utah Supreme Court reversing itself and saying, oh, yeah, I guess maybe you're right about these things. Or it's going to take them getting into federal court and getting a federal court to say, yeah, you're right about that. Personally think they are, but whatever. So anyway, the law as it sits right now, it's clear, it's binding on the judge. He is not going to depart from it. That law is they get to use the reliable hearsay at the preliminary hearings. So there's not really a big need to argue that one, but we'll see. Now, a bigger question, I think, is if we're going to get any insight into the scheduling of the preliminary hearing. So some stuff has gone down since the last time we were in court on this case. The defense is appealing. They're at least trying to appeal Judge Graf's order refusing to categorically ban the cameras. And so they have petitioned to the Utah Supreme Court to take it up on what's called interlocutory review, meaning it's interim. The case is still going on. It's not a final judgment, final decision that they are appealing from. It's while the case is still ongoing. So you don't normally get to do that. You have to make a special request and kind of a special showing that it's the kind of issue that warrants putting a pause on the process and dealing with it in the interim. So the Supreme Court has called for a response from the state and from the media, but otherwise we are just sitting there waiting for them to decide that petition. But the defense has also now in Judge Graf's court filed a motion to stay the preliminary hearing while the Supreme Court is doing whatever it's doing. And their argument is pretty straightforward. Look, if we're arguing about the media and you don't stay it, then we're going to go forward with the hearing on July 6th and the cameras are going to be there. And then there's no possible way to remedy this issue that we have, pending in the Utah Supreme Court, which is a fair point. But at the same time, you got to have pretty strong argument that you're right. Typically for interlocutory review to be entertained. So I don't expect that they're going to get it, but we shall see. So that's kind of lurking, and it's not on the calendar. It hasn't been set for hearing or anything like that. But obviously, the preliminary hearing is kind of right around the corner at this point. It's 3 weeks away, so they kind of need some finality. Talked before about how it's like time for witnesses got to travel in and make your arrangements and all that type of thing. And so the logistics of something like this means it's kind of helpful to know more than like the day before if you're going to be going forward with your hearing or not. There's a couple ways that Judge Graf can handle this request. The one that I think is maybe most likely is just wait. Because if the Supreme Court were to deny review, then it's moot. It doesn't matter. If they denied review before the preliminary hearing, it doesn't matter. So that is definitely one option, is just take a little bit of a wait and see approach. Second one is what the state had suggested, which is that defense should perhaps go to the Utah Supreme Court and ask them if the case should be stayed, since they're the ones that are in the better position to know, are we likely to actually grant relief in this case? Are we likely to see this as a potential problem? Then they're going to have maybe a little bit of a better read on whether the time should be called on the preliminary hearing process in Judge Graf's court. You can typically, when you're like wanting to stay things for an interim appeal, you usually can ask both courts. So defense has asked Judge Graf's court, but they haven't asked the Supreme Court. And there might be a reason for that, but at this point, it's just kind of observation that hasn't happened. So the judge could say, you need to ask them. You need to go up and ask them. And if they say it needs to be stayed, then great, we'll stay it. But otherwise, we're not going to stay it. And then, of course, the third option is he could stay it. You could say, yeah, we need to make sure we get this right and all that, yada, yada. And don't want to prejudice his right, so that if we were kind of wrong about the cameras and the possible possible prejudice to him from having those in the courtroom during the preliminary hearing, then we wouldn't want to like make that worse by not simply being patient while the appeal process plays out. To me, that's the least likely. That's the least likely of all of them. I tend to think we're gonna probably get the wait and see, and might not, frankly, hear anything about it at all today. But I don't know. That would be a little bit surprising, I guess. So the main feature for today is going to be this order to show cause on contempt. It is going to be the testimony of these prosecuting attorneys, and I got to tell you, I'm interested to see if the defense has learned from the last time they tried to do this. You'll remember they had Jeff Gray and Chad Grunander on the stand during the motion to disqualify the Utah County Prosecuting Attorney's Office. And I gotta say, it was like super ineffective. I don't mean that in like the technical, legal, ineffective assistance kind of way. I just mean like it's kind of a golden opportunity. Okay. You don't get a prosecutor on the stand very often. And they just made so little of it. Jeff Gray, I thought in particular, like figured out kind of real quick how to play this testimony game, how to answer the question he wants to answer, not necessarily the one that is directly put to him, how to explain himself, and things like that. So they have a second chance now to try cross-examining these prosecutors and see if they can perhaps get a little bit more useful, helpful information out of it. But frankly, with the disqualification motion, it was they added nothing really to what was already in the court record from the declarations that folks had filed and stuff like that. So we'll see. I'm intrigued. I'm intrigued to see if they've learned. Looks like they are over there in court, getting ready to get started. So I'll go ahead and get that on our screen. Yeah, Tyler's there already, so just probably waiting for the court to get in and call things into session. I have seen so many comments and just lots of people brought to my attention. Oh, by the way, because yeah, I'm back on Twitter, guys. I did get the account back. The lesson learned was with two-factor authentication, don't use the text my phone as a passkey. Don't use that as like a method for two-factor authentication, because apparently it's pretty easy to work around. It's like not even really that secure. So use the authenticator app. That's apparently what happened, is they were able to get past my 2FA because I use this SMS method. And so I don't do that. I'm not going to do that anymore. But yeah, I did get the account back. So hopefully third time's a charm now, and I get to stay me for the indefinite future. Fortunately, does seem to be just limited to Twitter. It's not like somebody's in my whole system or anything like that. But anyway, what was I saying? We're back on Twitter. Oh yeah, and so a lot of people have brought to my attention this other case that Judge Graf is involved in, and I don't know, I can't even remember now the names of the people. It just has something to do with Legos and like some YouTuber. The basic outline of this case that I got, because I haven't looked at it at all yet, and I'm just kind of trying to get a little bit oriented, is that there is like this Lego resale commission store. It's like a franchise or something. And so this store took consignment of somebody's Lego collection and then went out of business. And so the Lego collection just basically never got paid for. The owner never got the Lego collection back, never got the money for the Lego collection. Some YouTube person was like talking about this, covering this, but seemingly or allegedly also, I don't know, doing doing stuff like going over the I don't know. I don't know because I haven't watched any of it. I have no idea, but it just for whatever reason, Judge Graf apparently thought that it warranted a at least a temporary gag order or like restraining order, like injunction, kind of almost. So the YouTuber isn't supposed to like make any more videos about this or talk about it or something. This is just the general, like I said, kind of information I've gotten without looking any deeper into the case. But I'm definitely interested in it uh for the Judge Graf angle, right? Not a fan of gag orders. Obviously he's got one in this case. uh don't know kind of what the basis is. Just don't really know a whole lot about what's going on in this other matter. I don't know to what extent like something is kind of appropriate to be done. Like, is this just maybe a bridge too far versus this guy went like super over the edge and needs to be reined in versus like this is literally somebody doing public commentary about a dispute and they shouldn't be under any restrictions at all. I really don't know where it lies because I don't know anything about the facts. So if any of y'all know about that and want to fill me in or like point me to where some of the resources are and stuff like that. I would be interested in kind of just getting oriented. Yes, brick by brick apparently is what it is. I guess that's like the store or something. I don't know. I don't know any of the people involved, any of the the companies or anything like that. I'm vaguely familiar with Lego. No, I'm kidding, of course. Everybody knows Lego. I think I even went to the Lego museum. Isn't there a Lego museum in like Las Vegas or something? I forget. I know I've been to a Lego museum somewhere and it was actually really quite impressive. I mean, the things that you can build with Legos is pretty remarkable. So yeah, no idea how that one is going to flesh out other than just from what I've seen. It's a temporary order at this point in time. And so they will need to have a full hearing on that if it's going to be extended or anything like that. Yeah, in fact, here we are. Afghan Sky Law Mom, have you seen Judge Graf's TRO order in the big Lego drama case? It's so gross and extremely broad, big black mark on his 1A rep to me. Good, good, good feedback. Yeah, I have not seen the order itself. I do want to see the order. I would also really like to see, the request. I want to know like what was the conduct that was alleged that supposedly warranted some type of a gag being placed on this commentator. Because I don't know. So Debbie says Runkle has been covering it. Perfect. Perfect. Then that makes it super easy because I know then that not only is there information out there, but it's going to be good information and it's going to be presented in an awesome and entertaining way. We love our Ian Runkle over here. So yeah, okay. Reckless Ben, Brixon, minifigs, something like that. So that's the Lego case. Anyway, yeah, I got some catching up to do because, like I said, I was sort of occupied in the trenches this week. I'm still kind of refreshing to see. No, my response is still processing, still being reviewed. I don't know what that means. But it just means that my legal memo hasn't gone through the court filing system yet, so I don't want to publish it until that happens.
Thank you. Please be seated.
We've got sound on, but I don't know that court does.
Court is now in session.
Oh, goodness. It's going to be one of those.
Number 251-403-576, State of Utah versus Tyler James Robinson.
Let's
Counsel,
boost
please
this.
enter your appearances.
Oops. Terrible, terrible.
Good morning.
Good morning, Your Honor. Kathy Nestor, Michael Burt, Richard Novak, and Stacy Visser for Mr. Robinson, who is present.
Good morning. Good morning to Mr. Robinson.
Let's see if we can hear with that.
All right. Before addressing today's business, the court takes up a couple of preliminary matters. First, with respect to courtroom protocol to maintain security and decorum, any individual who exits the courtroom during proceedings will not be permitted to re-enter until recess. All counsel are expected to take reasonable measures to safeguard confidential communication. Such measures may include the use of screen protections on electronic devices and care to avoid the inadvertent capture of privileged or private discussions by recording equipment or by those present in the courtroom. In addition, the microphones at counsel table are turned off as a further precaution. And when making arguments, if that occurs, I ask you to approach the lectrum when you do so. Second, the court will address the camera operator and still photographer. And would those individuals please come forward to the lectrum.
Yikes.
Thank you. If you could state your full name, both of you.
I've got it boosted, guys. I can try to boost it like as much as it will let me.
So
I think
the
this
purpose
is it.
to ensure clarity regarding the expectations governing today's proceedings. And could you, have you reviewed the court standing decorum order dated February 24th, 2026? All right. Do you understand the requirements set forth in that order as they apply to your activities today? Do you require any additional time to review the order or to adjust equipment to ensure compliance? And do you anticipate any difficulty complying with the order? All right, I appreciate your cooperation. Thank you. Turning next to defense motion to stay pending interlocutory review, and the court will issue its ruling on this matter.
The stay.
Before the court is defendant's motion to stay pending interlocutory review. Defendant seeks to stay all further proceedings in this capital case, specifically the preliminary hearing scheduled for the week of July 6, 2026, pending the Utah Supreme Court's disposition of his petition for permission to appeal from an interlocutory order. The state filed an objection to the motion, and defendant subsequently filed a reply. Having considered the parties' briefings, the factual record, and the relevant authorities, the court issues the following ruling in order. Defendant is charged with the aggravated murder of Charlie Kirk, a capital felony offense. The media interest in this case is extraordinary within the state of Utah. Due to this intense public interest, defendant previously filed a motion to exclude still photographers, TV cameras, and microphones from the courtroom, seeking a categorical ban on electronic media coverage during all proceedings. On May 8th, 2026, this court issued its camera ruling, denying defendant's request for a blanket ban and concluding that under Utah Rule of Judicial Administration 4-401.01, requests for electronic media coverage must be evaluated on a proceeding by proceeding basis rather than through a categorical prohibition. The court also established procedures designed to provide advance notice of media requests and an opportunity for the parties to be heard before any such request is decided. Subsequently, on May 29th, 2026, defendant filed a petition for permission to appeal from an interlocutory order with the Utah Supreme Court, challenging the camera ruling on state and federal constitutional grounds. On June 6, 2026, the Supreme Court issued an order requesting that the state and various media organizations file responses to defendant's petition within 14 days. Additionally, on June 1st, 2026, this court denied defendant's motion to close portions of the upcoming preliminary hearing and seal exhibits, concluding that defendant had not demonstrated a realistic likelihood of prejudice sufficient to justify closure, particularly where much of the information at issue was already publicly available. The parties dispute the precise legal standard governing a motion to stay pending interlocutory review. Defendant argues that the granting of the stay lies within the inherent and discretionary powers of the court, varying according to the requirements of each individual case. In addition, defense argues Rule 8 of the Utah Rules of Appellate Procedure, which requires him to request a stay in the trial court before seeking a stay from the Utah Supreme Court. Conversely, the state argues that under Rule 8C2 of the Utah Rule of Appellate Procedure, the movement must demonstrate A, a likelihood of prevailing on the appeal, B, a likelihood of irreparable harm to the movement outweighing the harm to any other party, and C, that the stay is not adverse to the public interest. Defendant contends the factors contained in Rule 8C govern the waiver of a bond or security requirement and do not establish the substantive standard for granting a stay itself. The court concludes that regardless of whether the motion is analyzed under the discretionary authority recognized in Lewis or under the factors identified in Rule 8C, the result is the same because defendant has not established either a sufficient concrete threat of irreparable harm or that the balance of equities favor a stay. Defendant argues that proceeding with the July preliminary hearing while his petition remains pending will cause irreparable harm to his constitutional rights to a fair and impartial jury.
Okay.
Specifically, defendant relies upon the expert opinion of Dr. Christine Ruva, who opines that electronic media coverage of the preliminary hearing may expose prospective jurors to inadmissible hearsay evidence and create unconscious bias.
Okay, I'm going to switch over to East Idaho News. Oh, the sound is much better. Let me get over here. Okay. So we'll be a couple
Authority
seconds
recognized in
behind.
Lewis, or under the factors identified, either a sufficient concrete threat of irreparable harm. Argues that the
Basically, defense hasn't met their
proceeding with the
standard.
July preliminary hearing while his petition remains pending will cause irreparable harm to his constitutional rights to a fair and impartial jury. Specifically, defendant relies upon the expert opinion of Dr. Christine Ruva, who opines that electronic media coverage of the preliminary hearing may expose prospective jurors to inadmissible hearsay evidence and create unconscious bias. Defendant further relies on Shepard, James, and Hollingsworth, arguing that once the proceeding is publicly broadcast, any resulting prejudice cannot be undone. The court takes defendant's concerns seriously. The potential impact of extensive media coverage in a capital case is neither hypothetical nor trivial. The court further recognizes, unlike many forms of pretrial prejudice, widespread dissemination of information through modern and electronic media may be difficult or impossible to fully reverse once it occurs. The question presently before the court, however, is whether the record establishes a sufficient concrete and imminent risk of prejudice to justify staying all proceedings while interlocutory review remains pending. The court concludes that the asserted threat of prejudice has not yet been shown on the present record to be sufficiently concrete to justify the extraordinary relief requested. The court does not minimize defendant's concerns regarding publicity in a case of this magnitude. Indeed, the court has previously recognized that media attention surrounding these proceedings is extraordinary and that dissemination of preliminary hearing evidence presents challenges not ordinarily encountered in most criminal cases. Nevertheless, extensive publicity does not, standing alone, establish that an impartial jury cannot ultimately be selected. Courts have long addressed highly publicized prosecutions through established procedural safeguards, including expanded jury pools, detailed jury questionnaires, individualized voir dire, venue-related remedies where appropriate, and careful judicial supervision of the jury selection process. As is United States Supreme Court observed in Nebraska Press Association versus Stewart, pretrial publicity does not inevitably lead to an unfair trial, and predictions regarding its ultimate impact are often uncertain. Likewise, prominence does not necessarily produce prejudice, and jury impartiality does not require ignorance. In its June 1st, 2026 order denying closure, this court concluded that the defendant had not demonstrated a realistic likelihood of prejudice sufficient to justify closure of the portions of the preliminary hearing. Should concerns regarding prejudice arise as the case progresses, this court retains broad authority to employ traditional safeguards to protect defendants' constitutional rights, including expanded voir dire procedures, comprehensive jury questionnaires, individualized voir dire, changes of venue when warranted,
Already said all
and
that,
other remedies authorized by law. Moreover, no media organization has yet filed a request for electronic media coverage of the July preliminary hearing, and the
Well, that
court has
better
not been
change.
called upon to determine whether such coverage will be permitted. Accordingly, the asserted injury presently depends upon future events that have not yet occurred, including whether any request for electronic media coverage will be filed, and if so, how the court will rule on such a request. At this juncture, the court cannot assess those contingencies with sufficient certainty to conclude that a stay is necessary. The court recognizes defendants' arguments that the alleged injuries arise not merely from the possibility of future media requests, but from the operation of the framework established in the court's May 8, 2026 order, while appellate review remains pending. The court has carefully considered that concern. However, because any request for electronic media coverage remains subject to case-specific review, and because no determination regarding coverage of the preliminary hearing has yet been made, the court concludes that the asserted injury remains contingent rather than immediate. On the present record, the possibility of future electronic media coverage does not establish a sufficient concrete basis for staying all proceedings pending interlocutory review. The court's denial of a stay should not be understood as a determination that the defendant's concerns lack merit. Rather, the court concludes only that the current record does not establish that such concerns have matured into a concrete and immediate threat request requiring present intervention. Given the procedural safeguards available to ensure the selection of impartial jury, defendant has not established irreparable harm warranting a stay at this time. In balancing the equities, the court must also consider harm that a stay would impose upon other interested parties. The state argues that delay may impair the orderly presentation of evidence, increase risk of faded memories, and affect witness availability. The court finds those concerns legitimate and entitled to consideration. Additionally, the victim representative has formally asserted her right to a speedy disposition of this matter. Under the Utah Constitution and Utah Code, victims possess important rights to proceedings free from unreasonable delay, and courts are obligated to consider those interests when exercising discretion in criminal cases. The court acknowledges defendant argument concerning victims' rights and defendants' constitutional protections. However, because the court has concluded that the defendant has not demonstrated a sufficiently concrete threat to those protections on the present record, the court finds that interests favoring the continued progression of the case weigh against imposing a stay. The court continues to adhere to the reasoning set forth in its May 8, 2026 camera ruling and its interpretation of Utah Rule of Judicial Administration 4-401.01. At the same time, the court recognizes that reasonable jurists may disagree regarding the proper application of that rule in a case receiving this degree of public attention. The court further recognizes that the Supreme Court's request for responses indicates that defendant's petition presents substantial issues warranting careful appellate consideration. The court does not regard the Supreme Court's request as a routine procedure event and acknowledges that the issues raised are of sufficient significance to merit serious review.
I don't know about that. It's
The
a
court
capital
expresses
case.
no opinion regarding whether the interlocutory review ultimately should be granted. The existence of substantial legal question The existence of a substantial legal question, however, remains distinct from the separate question presently before this court, whether the defendant has demonstrated that a stay is presently necessary pending further review. The court remains persuaded that the procedures established in its May 8th, 2026 order are consistent with Rule 4-401.01. Any future requests for electronic media coverage will be evaluated on the specific record then before the court after affording the parties a full opportunity to be heard pursuant to the procedures previously established. Finally, the court concludes that the public interest presently favors allowing this matter to proceed in the ordinary course. The public possesses a substantial interest in the fair, orderly, and timely administration of criminal justice. The court further recognizes that public confidence in the judicial process depends both upon transparency and upon the preservation of constitutional trial rights. The court remains committed to safeguarding both interests throughout these proceedings, staying the preliminary hearing while the Supreme Court considers whether to grant discretionary interlocutory review would result in additional delay despite the absence of a presently demonstrated need for such relief. The court recognizes the seriousness of defendants' concerns and the significance of the issues presented before the Supreme Court. The court further recognizes that concerns regarding pretrial publicity and electronic media coverage implicate important constitutional values and warrant careful judicial review. Nevertheless, the potential prejudice identified by defendant has not yet matured into a concrete and immediate threat requiring intervention in the form of a stay. Established procedural safeguards remain available to protect defendants' right to a fair trial should further circumstances warrant their use. By contrast, a stay would impose an immediate and concrete burden upon continued progression of this case, including the interests of the state, witnesses, and victim representative, as well as the broader public interest in the timely administration of justice. Nothing in this order should be construed as foreclosing defendant from renewing an appropriate request for relief should further developments materially alter the circumstances presently before the court. Should future developments demonstrate a material difference of level of publicity, media exposure, jury contamination risks, or other circumstances affecting defendants' fair trial rights, the court will not hesitate to revisit appropriate protective measures. Likewise, nothing in this order predetermines how the court will rule on any future requests for electronic media coverage of a particular proceeding. Accordingly, the defendant has not established that a stay of the proceedings is presently necessary or appropriate. It is hereby ordered that defendant's motion to stay pending interlocutory review is respectfully denied. And that concludes the order of the court as it relates to the stay.
That was a long order.
Mr.
We'll
Novak.
have that in writing, and they'll get
On the
posted.
same subject matter and with respect to the timing laid out in the court's May 8th, 2026 order, we have a concern on behalf of Mr. Robinson that for the court to, well, let me just back up. There has been a request for electronic media coverage in every single hearing in this case. So I think it's fair for the court and the parties to anticipate that there will be a timely, under the May 8th ruling, request for electronic media coverage for the preliminary hearing. Mm-hmm. The court set up what I'll call a briefing schedule for how the parties respond to that request for electronic media coverage. But it appears to us that the court wouldn't rule on the request for electronic media, any request to prohibit or limit electronic media coverage until the morning of the preliminary hearing. And I think that creates some problems, at least for Mr. Robinson, because if the court were to disagree with the relief Mr. Robinson seeks, we have no opportunity to seek review of your Honor's order.
You want to,
and the court just laid out
everything.
Its acknowledgement that there are serious constitutional issues which other jurists may disagree with vis-a-vis the court's conclusions. So the request is that the court modify in some way the timing of that litigation so that the parties and the media can have and their counsel can have a ruling sufficiently before the first day of the preliminary hearing, so that if some judicial review is going to be sought, it's not happening after the preliminary hearing
Oh,
has
Lord, he
already
wants to go
begun.
through this cycle with every request for
No, and
electronic
I
media
appreciate
coverage.
that, Mr. Novak. I note your concerns, and it is for that very reason that the court modified what was the procedure before, which, and please correct me if I'm wrong, I'm kind of going off my memory, but the media was required under the rules to give, was it 1 day notice before the hearing?
It was something like that. So the notice.
Hold on, I want to finish. Sorry,
Yeah.
but I appreciate you. And so the court expanded that to allow briefing, where under the current rules, as they're stated now, it wouldn't even allow for briefing. It would create a greater issue that you're proposing, because you wouldn't even be able to file a motion, no response and no reply. The intent of the court was to give the parties sufficient notice or more notice than the rule currently allows, to allow briefing, to allow that to be presented, and for the court to consider that as opposed to making a snap decision the morning of the prelim. So the court's coming in with more information than simply the request for media coverage being filed the day before, and then parties trying to come up with an argument, and then court trying to make that decision on the day of trial. And so that's the difference. And the court anticipated that concern and wanted to give the parties that ability to articulate their concerns and allow the court sufficient time to consider those arguments and weigh those arguments against the constitutional rights of all parties and render the best decision it can.
So I acknowledge all of that. I agree with all of that. I appreciate all of that. What I'm referring to is Mr. Robinson's, or depending upon how the court rules, the state or the media's opportunity to seek interlocutory review if, as Your Honor states, it is true that what has to be shown is the harm under facts that relate specifically to the preliminary hearing. Okay, so the court has denied what I'll call a more general blanket request to preclude electronic media coverage. The court has said it's going to take it up on a hearing by hearing basis. And the court has also said that reasonable jurists may disagree with the court's substantive conclusions and the court's ruling on our request for a stay. And what I'm suggesting respectfully is we may be in the exact same place. One of the parties may be in the exact same place in the moments before the preliminary hearing, at least presently, is scheduled to begin on July 6th. So my question is, can we get a ruling from the court sufficiently before July 6th so that if some party seeks a stay and interlocutory review, we're not doing that on July 6th or July 7th or July 8th, because by that point in time, it's too late. So we could have a ruling by WebEx. We could have argument and ruling by WebEx. I totally respect that the court has a very busy calendar. And I also understand that the preliminary hearing is starting 2 days after the 4th of July, which this year is a big deal. So what I'm trying to just do is plan ahead and think about whether the schedule that the court set, which we agree makes a significant difference in our ability to litigate before Your Honor the issue, a way to resolve this so that we also have the ability to seek review before it's too late.
No, and
I'm literally talking about the last few days of the week before. That's, I think, what we're talking about.
And I appreciate that. And where I'm coming from is the court cannot issue anticipatory rulings. I can't go off hypotheticals. And I understand what you're saying. I recognize that media requests have been filed, but I can't issue a hypothetical ruling. It has to be squarely before me. And I respect what you're saying, but I imagine that you're probably preparing. Well, I'm not going to assume it's not appropriate, but perhaps you are already preparing those motions in
Oh, have your
anticipation of
petition
such
ready.
media requests being filed, and in addition to anything else that you may consider, and rightfully so. And so and there's also sufficient time between now, given the ruling that the stay is not being granted, knowing that the preliminary hearing is moving forward, that it appears that there may be sufficient time for the parties to prepare accordingly. Again, the court needs to wait until it's squarely that media request is been filed. Whether the parties file motions, it's possible that the parties may or may not. I can't anticipate that, but I need to wait until it's actually before me, as opposed to trying to read the tea leaves and guess.
I'm not asking the court for tea leaves, so maybe I've been obtuse. What I'm saying is that the court's order currently provides that it will issue its ruling on any objection to an EMC request the morning of the hearing. And that's the problem. I'm not asking the court to issue a ruling now. I'm not asking the court to assume there will be an EMC request. I can tell the court that if there is an EMC request, we will file an objection to that, which shouldn't be a surprise. And so what I'm just saying is, for the orderly administration of justice, and in light of the possible judicial divergence of opinion that Your Honor has acknowledged, we are asking the court to build into the schedule that it has set for any objections to any EMC request that may be filed, a period of time before the subject hearing at which the parties would receive a ruling. And if I suggested in my statements that we are actually asking the court to assume that there's an EMC request and that we would oppose it and that we're asking for a ruling now, we're not. We think there should be a request.
That's what you just said.
And there should be briefing. We're just asking that the court build into the schedule a ruling moment that allows us, if necessary, or some other party, if necessary, to seek review.
Thank you, Mr. Novak. And the other kind of X factor is how quickly the parties respond. If a motion is filed, and let's say an EMC comes out on day 1, and a motion is filed on day 2, and then the state files on day 3, there may be more time. And so one of the variables is how quickly the parties respond, which the court doesn't control. And so that's a factor that may allow the court additional time to accomplish that. And this court has tried to be very diligent in being in expediting addressing motions and not letting them sit too long, because I know it's important to defense and to the prosecution and to all parties. And so the court is cognizant of that and will respect that and issue its rulings or its analysis as quickly as possible to afford you that ability.
So the court did set deadlines for briefing, and what I will do when there's an appropriate break in today's proceedings is we'll speak with counsel for the state about whether we can agree to modify that briefing schedule that the court set so that the EMC request and the parties' responses to it can be submitted to Your Honor more in advance, further in advance of July 6th than the current schedule allows. And then if we can agree on something, or if we can't, we will let the court know that. And I'm still going to ask the court to look at its calendar and suggest a hearing date, if necessary, on what we, I think, can fairly anticipate will transpire. Again, because the media has requested that their cameras be present at every hearing. And it would seem to me that they would not miss the opportunity from their point of view to broadcast the preliminary hearing.
Thank you, Mr. Novak. I appreciate you addressing those or bringing those concerns.
So we'll bring that back to the court at the appropriate time today.
We know.
Thank you, Mr. Novak. Does the state wish to be heard on this issue?
State, you don't need to say anything.
Yes, thank you, Your Honor. Christopher Ballard on behalf of the state. Just like to point out that even assuming that there's a request for electronic media coverage, which the state fully assumes there will be, and that the court grants that request. The equities, as far as whether or not to stay things to allow the defendant to then appeal that ruling, that's really not going to change. The circumstances that the court's already articulated in its order today, those equities really aren't going to change between now and the preliminary hearing. And the appropriate procedure for reviewing a court's orders on electronic media coverage is not to pause the trial proceedings and allow defendant to seek interlocutory review of every order. The defendant can certainly do that. He has the right to do that, but that's not the appropriate remedy. I just remind the court of the United States Supreme Court statement in Chandler versus Florida, where it said that the appropriate safeguard against potential prejudice from pretrial publicity is the right to demonstrate that the coverage compromised the ability of the particular jury that heard the case to adjudicate it fairly. So defendant's claiming he doesn't have a remedy. He does have a remedy, and the remedy is to challenge the court's media order at the plenary appeal after this case is complete. Thank you.
Thank you, Mr. Ballard. All right, anything further before we move on?
Yes.
Of course.
We can take
Of
this up
course.
whenever the court wishes to take it up. And in addition to the two substantive issues, which the court calendared for today, which is the hearing on the court's issuance of an order to show cause re contempt and the argument of a pending and fully briefed motion concerning the constitutionality of hearsay evidence in a preliminary hearing. Mr. Robinson filed with a motion to classify a document, which I'll just describe as
that
having
was
privately
his.
been filed, seeking certification for an out-of-state subpoena for the preliminary hearing. And the court is nodding, so I understand that the court is aware of it.
I've reviewed that.
Okay, so again, because of timing issues, we would like at some point today to receive from the court a briefing schedule on that, because out-of-state enforcement of a subpoena, if the court certifies it, is obviously something that takes a little bit of time.
Complicated.
And in light of the court's denial of the stay, for the moment, we have to assume that if that certification is granted at our request, and by the way, we've served counsel for the witness with that request as well,
Okay.
that we need time for an out-of-state counsel to appear in the appropriate jurisdiction and get an order
Is this
enforcing that.
Lance?
I can't imagine that if the court granted the certification that there's going to be an issue about serving the witness, but we don't have a valid subpoena unless Your Honor certifies the application and then a court in the appropriate jurisdiction enforces.
Thank you. And I note that that was filed last night around 8:04 p.m. Is
It
that
was.
what you're referring to?
Yes, that's exactly what I'm referring to.
All right. Thank you. The court will take that under advisement and figure out. Court will address that at some point today.
All right,
Thank you for bringing it to the court's attention, Mr. Novak. All right. Let's continue on. Counsel for the state, could you provide a brief status update regarding a discovery?
Discovery update. My
Yes,
favorite.
Discovery continues to roll in and be processed and provided to the defense on Tuesday, June 9th, 2026. We sent 11 additional items to the defense.
Oh, Mr.
Thank you.
McBride, if you wouldn't mind starting over, and yeah, that's where the live mic is.
Thank you.
Understood, thank you. Ryan McBride for the state. As of June 9th, 2026, we sent 11 additional items to the defense. 10 of these items were notebooks that were obtained and requested from the defense in the discovery review. One is an 1102 statement that was provided in preparation for the preliminary hearing. This is everything, essentially everything we have from the investigative agencies to date. The percentage provided to the defense is approximately 100%.
Thank you, Mr. McBride. All right. Turning to the defense motion for an order to show cause for alleged contempt of court. This is set for an evidentiary hearing and arguments. The court has reviewed the briefing submitted, and each side will be afforded 90 minutes to present evidence and argument. If defense intends to reserve time for rebuttal, counsel should plan accordingly. Following argument by defense or a presentation of evidence, the court will take a 10-minute recess and then turn to the state. Because this is the defendant's motion, the defense will proceed first. Mr. Novak.
All right.
Thank you, Your Honor. Mr. Robinson would first ask the court to direct Mr. Ballard to take the witness stand.
All right, Mr. Ballard, if you wouldn't mind coming forward and being sworn in.
Do you solemnly swear that the testimony you shall give in the case happening before the court will be the truth, the whole truth?
Here we go. See how this prosecutor testifies.
All right, Mr. Ballard, if you wouldn't mind getting situated to your left or water bottles, and after you're seated, if you wouldn't mind pulling that microphone close to you to ensure that the record picks up your testimony. Thank you. Mr. Novak, it's your witness.
Thank you, Your Honor. Mr. Ballard, what are your formal titles within the Utah County Attorney's Office?
I am the general counsel and public information officer.
Okay. You're testifying here today because the court has issued an order to show cause regarding contempt of a court order. And so there's a white notebook that I placed up there. Do you have that, sir?
I do have it.
All right. Why don't we first turn in that notebook, and Your Honor should have one as well.
I don't.
I passed it up
Oh,
to
there
the
it
clerk.
is. Thank you. I now have it, Mr. Novak.
All right. Thank you, Your Honor. Mr. Ballard, why don't you turn to Exhibit 8? And just let me know when you've seen it and had a chance to look at it.
I've seen it. Thank you.
Okay, is this the order entered by this court on September 16th of 2025 entitled Protection Order, Re Pretrial and Trial Publicity?
It appears to be yes.
All right. And Your Honor, I understand that a court exhibit doesn't technically need to be received into evidence. Of course, the record is what it is. It could take judicial notice of it, but I just think for completeness of the record, would the court mind if we ask the court to receive Exhibit 8 into evidence?
To the state, any objection? No. All right, and if you wouldn't mind, so if as I turn to both parties, because your microphones are turned off, if you wouldn't just mind projecting a little bit more so the record picks it up.
No objection.
Thank you, Mr. McBride. All right, so is this
Shout.
going to be defense
Shout your
exhibit number?
non-objection.
8.
All right,
They're pre-marked, so we'll just stick.
just sticking with those numbers. All
I
right.
think it's easier for the record than changing the order. And
I appreciate that.
All right,
All right,
thank you.
defense exhibit 8 is admitted and may be published.
I think, and Mr. Ballard, did you read this order either the day it was entered or shortly thereafter?
Yes.
So you were aware of it shortly after it was entered, correct?
Yes.
All right. Why don't we also turn now to Exhibit 9? And same question, please let me know after you've had a chance to look it over.
I've looked at it.
And is this an order clarifying, let me be more clear, an order of this court dated December 15th, 2025, clarifying at the state's request the order that is now Exhibit 8?
Yes.
And could the court receive into evidence, please, Exhibit 9?
No objection.
Thank you, Mr. McBride. With no objection being made, this is entered into evidence as Defense Exhibit 9 and may be published.
And Mr. Ballard, with respect to these two orders, would you agree with me that subject to the clarification, these orders track Supreme Court Rule of Professional Practice 3-3.6?
Yes, they track that rule. They require both parties to abide by that rule.
And would you agree with me that you are a prosecutor also subject to Rule 3-3.8,
Yes,
and that everybody in your office is a prosecutor under the within the meaning of 3-3.8?
the attorneys in our office, yes.
The attorneys in your office, right? And again, Your Honor, these are rules of professional practice, but I am going to ask the court to receive into evidence for purposes of this hearing both Exhibit 10, which is a true and correct copy of Rule 3-3.6 with its comments, and Exhibit 11, which is Rule 3-3.8 with its comments.
No objection.
With no objection from the state, Defense Exhibits 10 and 11 are admitted and may be published.
And Mr. Ballard, were you familiar with these rules prior to the court issuing the orders, which have now been received as Exhibits 8 and 9?
Yes,
So would you agree with me that you knew what was required under the court's pretrial publicity orders?
yes.
Did you have any inability to comply with those orders?
No,
Get to the establishing the violation part. That's kind of important. Sort of what we're here for today. Because he's not going to admit it's a violation, and you know that.
All right, Mr. Ballard, would you look at Exhibit 2, please? And again, please let me know when you've had a chance to look it over and familiarize yourself with it.
I've looked at it.
And do you recognize this to be an email that you sent to counsel for Mr. Robinson on December 22nd, 2025?
Yes,
And the subject of this email was your notice of intent, the state's notice of intent to conduct non-destructive testing, correct?
correct.
All right. Your Honor, before I go any further, could the court please receive into evidence Exhibit 2?
Mr. McBride?
If I can have just a moment.
All right.
No objection, but as it goes to publication, this includes email addresses. If this is made public, those email addresses should be redacted.
All right. Mr. Novak?
We will provide the court with a redacted
Let's
version
redact it
of
right now.
the
Does nobody have a
exhibit
Sharpie?
that masks all of the emails that are email addresses that are listed.
Nobody brought a Sharpie to
at
court.
the top of the exhibit.
All right. Based off the state's not making an objection, but requesting a redacted version with removing emails, Defense Exhibit 2 is admitted.
Thank you. So, Mr. Ballard, just so the court, because the court has probably never seen this email, I want to go over with you the context and the purpose of this email. The state had determined back in this time period, which is December of 25, that it wanted forensic examiners to do some further testing of a bullet, jacket, fragment, and lead fragments, correct?
Yes.
And under a prior order of the court, it was the state's responsibility to notify Mr. Robinson's defense counsel of any testing which may, let's just say, change the nature of the physical evidence.
Correct.
And so what you were doing in late December of 25 was notifying us privately that the state intended to conduct some additional testing, correct?
Correct.
And you state in this email that the reason why you don't want to publicly file this notice of intent to conduct further testing, at least at that time, was because of a comment to Rule 3.6. That's the same Rule 3.6 that the court has received into evidence as Exhibit 10, correct?
Correct.
And what you say is that the comment to Rule 3.6 of the Utah Rule of Professional Responsibility lists, quote, the performance or results of any examination or test, close quote, and, open quote, the identity or nature of physical evidence expected to be presented, close quote, as subjects to avoid in public comments. Those were your words, right?
Correct.
None of this is in dispute.
And then I would also now like to ask you to look at Exhibit 6. And I know I will sound repetitious, but please look it over and let us know when you've reviewed it.
I've reviewed it.
And is this an email that you sent to one member of Mr. Robinson's defense team, and then it appears that it was copied to other attorneys in your office?
Correct.
Your Honor, before I go into the details of it, could the court please receive it into evidence as Exhibit 6 with the same proviso, which is that we will provide the court at a later time with a redacted version that masks the email addresses?
No objection, but the email addresses are not included here, so
Well, there is one at the very bottom,
Oh.
the signature for Mr. Ballard.
thank you. Excuse me.
No worries.
And Ms. Visser's below that as well, Your Honor.
All right.
But I think we're all on the same page about what to do.
It sounds like it. So the defense exhibit 6 is admitted with the following redactions being noted. Thank you.
Okay, so Mr. Ballard, in this email, you're informing us that the state no longer believes that filings concerning this additional testing from the state's point of view should remain private, correct?
I don't recall exactly the question that Ms. Visser had posed to me and that I was responding to, but the general, the email speaks for itself.
Okay, so the email says in the top paragraph, but now that the court is involved, we do not believe that it is necessary to keep court filings private or even file redacted versions on this issue.
That's correct.
And this issue refers to whether the state can proceed with the further testing and Mr. Robinson's objections to the way in which the FBI wanted to do the testing, correct?
Correct.
I mean, basically, okay, So that's that dispute. What you say in the second paragraph is the ethical rules on pretrial publicity apply only to extrajudicial statements, right?
Correct.
And so what you're saying is that if we talk about physical evidence, testing that has been done, testing will be done, what the results of the testing are, if we talk about those, we mean in counsel who are subject to the rules and the court's orders in filings, we're consistent with rule 3.6, right?
Correct.
But if we talk about them extrajudicially, that's prohibited under 3.6.
Correct. Unless we're talking about public records. Unless we're talking about a filing.
I'm not sure what you are modifying with the word unless, and I'm not trying to be difficult. Are you saying that you can make extrajudicial statements about anything you want that's in a public filing without violating Rule 3.6?
Rule
Is that what you
3.
mean?
What I mean is exactly what the rule allows, and that says that a lawyer may state information contained in a public record.
So if you file something that relates to issues that the rule says should not be commented upon extrajudicially, you're saying that that opens the door. The mere filing of something opens the door to making any extrajudicial statement that you want about that subject matter?
No, that's not what I'm trying to.
You've only got 90 minutes, Mr.
Okay,
Novak.
so why don't we let Mr. McBride ask you about that interpretation, because I'm going to move on to my next question. Why don't you turn, please, to Exhibit 1. And this is not an email from you, but it is one that you are copied on. It's actually a series, a couple of emails and a letter all together in Exhibit 1. Do you see all that?
Yes.
Okay, so first, let me ask you if you are familiar with the first 2 pages of Exhibit 1, which are string of emails that basically start with Mr. McBride writing to, I mean, the email addresses are redacted. This is how we received it, but let's just say writing to many people who are in government or in law enforcement. Would you agree with that?
Yes.
All right. And you're copied on that email as well, right?
Yes.
All right. And then if you go to the 3rd page of this exhibit, and I should back up, Mr. McBride's original email to the law enforcement and government individuals I was referring to was September 15th of 2025, right?
Correct.
Oh, Mr. Novak, I love you, but you're
Which is
killing
actually
me.
the day before the court entered its
Boring
first
me to death.
publicity order, correct?
Correct.
They knew the order was going to come. All of this preliminary stuff is so unimportant. Get to whether there was a violation.
So if we go to the 3rd page of this exhibit, this is an email from you also a couple days before the court entered its September 16th, 2025 order. And you're writing to, well, are you familiar with this email?
Yes.
And now let me go ask you to look at pages 4 and 5. Those are the last 2 pages, Your Honor, of this exhibit. This is a letter written by Mr. McBride. Do you see that?
Yes.
Dated also September 12th, 2025.
I'm not going to
Yes.
call him Slovak. I won't get there.
You're familiar with that one as well?
Yes.
All right. So,
Maybe I
Your Honor,
will.
I would ask the court to receive into evidence, subject to any redaction, with Mr. McBride thinks is necessary of emails. Although I think they've all been redacted before produced to us. All 5 pages, we're asking the court to receive into evidence.
No objection.
All right, and this is State Defense Exhibit 1 with no objection from the state will be admitted.
But he's so smart. He
Okay,
just
so let's go back to page 1, Mr. Ballard.
kills me with this stuff.
In his email, well, Mr. Ballard, you know generally who the people are who this email was sent to, right? The names behind the redactions.
Generally, yes.
Can I just refer to them as law enforcement partners?
Yes. I think that's accurate.
Some have email addresses that are local law enforcement agencies,
Correct.
including Utah County, correct?
Correct.
Spanish Fork,
Yes.
Utah Valley University, not a law enforcement entity, of course, but they have a law enforcement department at UVU.
Correct.
And at least a couple recipients are with the FBI, right?
Correct.
And so in this email, Mr. McBride says at the bottom, quoting Rule 3.6, there are certain subjects that are more likely than not to have a material prejudice effect on a proceeding, particularly when they refer to a criminal matter that could result in incarceration. You see that?
Yes.
And then he says these subjects relate to, and then on the next page, I want to draw your attention to Roman numeral 3, the performance or results of any examination or test, or the refusal or failure of a person to submit to an examination or test, or the identity or nature of physical evidence expected to be presented. Do you see that?
Yes.
Do you agree with Mr. McBride's assessment that Rule 3.6 prohibits extrajudicial statements about that topic or those topics?
This isn't in dispute,
Yes,
and
this
it's a legal
email
issue for the judge to
represents our
decide.
efforts, even before the court issued its order, to recognize that we had obligations under Rule 3.6 and that we were careful to abide by those obligations.
You were careful to inform law enforcement partners in the email of their obligations, correct?
Yes.
And then item 4, Roman numeral 4, also on page 2 of the exhibit, says, as another example of subjects that are more likely than not to have material prejudicial effect on a proceeding, any opinion as to the guilt or innocence of a defendant or suspect in a criminal case or proceeding that could result in incarceration.
Yes.
All right, now if we could turn to page 3 of the exhibit. This is an email from you to what I will describe, unless you disagree with me, as law enforcement partners. Do you agree with that?
Yes.
Asking them to carefully review a letter, which is the following page, from Mr. McBride, dated September 12th.
That's correct.
And that letter also, the letter is addressed to all personnel likely to make media statements regarding the Charlie Kirk case.
That's correct.
And the letter says, just below that, the Utah County Attorney's Office has an ethical obligation to, quote, exercise reasonable care to prevent investigators, law enforcement personnel, close quote, and others from making public comments which, quote, have a substantial likelihood of materially prejudicing, close quote, the trial process. That's what Mr. McBride wrote in the letter that you forwarded to chiefs and others, correct?
Correct.
Look, my man is working, okay?
And Mr. McBride's letter also says
It's exhausting
that
to get all those
prosecutors
words
have a
out.
special duty to ensure that law enforcement and other officials adhere to these rules, citing Rule 3.8E, correct?
That's correct.
And then Mr. McBride identifies statements that should be avoided. Or I should say, yes, statements that should be avoided. You see that? Statements should avoid the following, colon.
Yes.
And there are 4 bulleted items there, right?
Yes.
One of them, the third one, is opinions about the defendant's guilt or proper punishment. You agree with that?
Correct.
And do you agree with Mr. McBride that prosecutors have an ethical obligation to both avoid those themselves and to take special care to make sure that law enforcement personnel and others refrain from making such comments?
Yes.
And then the other statement that should be avoided are any other statements which could risk violating the defendant's right to a fair trial.
Correct.
And would you agree with me that the any other statements phrase by Mr. McBride in this letter would include the more specific prohibition on extrajudicial statements about the performance or results of examinations,
Yes.
tests? Yes? I'm sorry for interrupting you. The answer was yes.
Correct. Yes.
All right, I'm now going to turn your attention, please, to Exhibit 3.
Are you going to turn our attention to a violation? 'Cause this is the same shit that happened with the disqualification. It's like they just sort of
And I
assumed
want you
that
to
it
take a moment to
happened,
look at
never
that.
proved it did.
Tell me if you've seen it before, if you recognize it.
Yes. I recognize this.
Okay. Do you recognize this as an article published online by TMZ concerning this matter in which
Hard
you are
not to agree.
quoted?
Yes.
Okay. And my first question is, how is it that you came to be quoted? Well, actually, let me ask you this question. If you look on the second page of this exhibit, down toward the bottom, underneath the image of a black screen, the paragraph starts, Attorney Christopher Ballard tells us, comma, quote, and then there's a very lengthy, well, there's a few sentences in quotes. Do you see that?
Yes, I do.
Okay. Did you tell TMZ that?
Yes, I did.
All right. So my question is, was that over the telephone? Was it an email? Was it a face-to-face meeting? How is it that your quote was communicated to a representative, a media representative of TMZ?
It was a telephone conversation.
And did you only have one telephone conversation with TMZ?
Yes.
And how was it that the telephone conversation came to be set up?
After the defense filed its motion to continue the preliminary hearing, there was a statement in that motion that garnered quite a bit of media attention. I came to be aware of that media attention and the headlines that statement had generated. And there were quite a few media inquiries to our office based on the statement in the defense's pleading and the media stories that statement had generated. TMZ was one of the media entities that called our office. I received an email from someone else in the office. I can't remember who it was exactly, that said, I got a call. They received a voicemail from a reporter at TMZ. That employee in our office forwarded me that voicemail, and the voicemail just basically said, we have some questions about these issues that statement in the motion to continue had generated. And so I returned the phone call.
Before you returned the phone call, did you have any discussions in your office concerning whether there should be extrajudicial statements about the issues that you're describing?
Yes,
Okay, and did you discuss that with Mr. Gray before you returned that phone call?
yes,
Did you discuss that with Mr. McBride before you returned that phone call?
no,
Did you discuss that with anybody other than Mr. Gray before you returned the phone call?
I know for certain that Mr. Gray and I discussed it. I have a vague memory that Mr. Grunander was involved at some point. But my memory is that Mr. Grunander was out of the office the day that all of this was breaking. And so he may have just been informed, brought into the loop after the fact by telephone. But I do recall that very early in the morning, I think it was of March 31st, because my memory is that the media story that launched all of this interest was posted, I think, late Monday afternoon, Mountain Time. And so by Tuesday morning, I was getting a lot of media inquiries. And I think Mr. Gray had also, my memory is that Mr. Gray received a phone call from Turning Point USA asking us if there was any merit to these media stories. And that's when Mr. Gray came into my office. My recollection, it was first thing Tuesday morning, and we discussed these media stories.
So Turning Point USA reached out to Mr. Gray, and Mr. Gray came to speak with you all about the same time that you received this forwarded voicemail from a TMZ reporter.
The voicemail from TMZ came later in the day. It was before noon, but it was a busy morning. There were a lot of media inquiries that
I bet.
were coming in that morning. And I know Mr. Gray and I met, I would say first thing Tuesday morning to discuss this issue.
And you and Mr. Gray had a conversation which led to a decision to return the phone call and make a statement to TMZ?
I did not discuss every media inquiry with Mr. Gray. I think I just generally told him, he brought up the issue that there were concerning media reports out there, potentially prejudicial media reports. I confirmed to him that I was getting media inquiries, and we generally discussed whether it would be appropriate to respond to those.
Okay. So did Mr. Gray know that you were going to call TMZ back?
No, I didn't discuss with him every media inquiry. Our conversation was general. We reviewed the requirements of Rule 3.6. I don't recall that we actually pulled the rule and read it, but we were familiar with the rule, and it's what it prohibits and what it allows. And we believed that under, I think it's subsection C, and also under the court's order, which specifically references subsection C of the rule, that we could respond, that this was potentially prejudicial media stories that we did not generate, and that the rule allowed us to be able to respond to those.
Were you aware of any extrajudicial statements by the defense which generated that media
It doesn't
coverage?
matter.
No, and nor does the rule require that.
Well, that's your legal interpretation of the rule, right?
It's
No,
the
that's not
language
my
of the
legal
rule.
I
interpretation. of the
mean,
rule.
you were here when Mr. McBride argued to this court at the last in-person hearing that as long as there's some negative coverage out there, regardless of the source, that the state has leave to make extrajudicial statements on the same subject matter.
I heard that argument, yes.
And that's a legal argument, right?
Yes.
All right, so here's my question. The information in the TMZ article, which purports to quote you on the second page of Exhibit 3, is that an accurate quote? Is that what you
Yes.
said?
Yes, it's accurate. I don't know that it's word for word for what I said, but it accurately captures my statements to the reporter.
Okay.
Mr.
That's why
Novak,
you do these things in
and I don't mean
writing.
to interrupt you, but are you intending to admit exhibit number 3?
Yes, now that Mr. Ballard has said it's an accurate recitation of what he told TMZ, I would now ask the court to receive it into evidence.
Thank
No
you.
objection.
All right.
So in that quote, you tell this TMZ reporter what your views are on bullet fragment analysis, correct?
I wouldn't characterize it as my views, although I guess you could say it's my understanding in general of how bullet fragment analysis works.
And you're also commenting on the contents of the results of the testing when you say the fragment didn't contain enough detail for the examiner to say one way or the other. That's you basically commenting on the content of the results of the examination as you understand them, correct?
What I'm commenting, if you look at the first word, I say generally. And generally, when you have an inconclusive result, the reason that you get that inconclusive result is you do not have enough detail.
Okay, but now you're again testifying about your understanding of bullet fragment analysis. And I'm just asking you, if you told this reporter, it's an extrajudicial statement, what your views are on bullet fragment analysis. And
It's a terrible question. Your views on it?
you're
I'm opposed.
reiterating the conclusions
Bullet
in a
fragment testing for
report about
everyone.
bullet fragment analysis.
Objection. The statement speaks for itself.
Would you like to respond to that objection, Mr. Novak?
Well, I don't think that the answer to the last question was responsive, so I was trying to go back to the question. I guess I could have moved the court to strike the answer as non-responsive.
I'll sustain the objection.
And then in the same quote, Mr. Ballard, after talking about bullet fragment analysis, you say, there's just not enough there to determine whether the bullet was fired by a particular firearm. That's you telling a reporter what you believe the forensic testimony in a proceeding will be.
No, what I'm referring to is generally the types of circumstances that could produce an inconclusive result.
Okay, but you say there's just not enough there to determine whether the bullet was fired by a particular firearm.
The bullet
You're
in the test.
referring to the fragments recovered, correct?
No. What I'm
Talking
referring
generally.
to, you got to read that in context with the first sentence.
I'd like to read it in context of the next sentence, which talks about the evidence, in your view, being sufficient to prove that Mr. Robinson committed the murder. You're commenting on the bullet, and then you're commenting on your opinion about the sufficiency of the evidence.
So here's how the quotes came about. The reporter first asked me about these, the media reports and the misleading statement in the defense's motion that the bullet that was recovered did not match the rifle. And I responded to that and said, generally, when you have an inconclusive result, it can be caused by these general types of circumstances. The reporter then asked me, well, do you still have a case? And focused specifically on whether the additional media reports out there that the supposed inability to match the bullet to the gun was a bombshell finding for our case, and that it completely undermined the foundation of our case. So that next statement was responding specifically to that question as to how does this specific, how do these specific reports and the representation in the defense's motion, how does that affect our ability to proceed with this case?
I'm going to move to strike portions of the statement which mischaracterize the defense pleading as misleading. This court has never made such a finding. And we had argument about Mr. McBride's interpretation of what is and is not exculpatory evidence. I think we all remember the court's comments on that. So I think without trying to parse it too much, I just asked the court to strike the portion of the statement which characterizes the defense pleading as misleading.
Mr. McBride.
I think the court can take this statement, the testimony, for the value it deems appropriate. Testimony is asking about Mr. Ballard's perceptions, and that's what he's testified about. The statement in defense counsel's pleading is a matter of public record, and what we're really talking about here are the reports that were generated from that statement. So I would ask the court not to strike it, but to take it for the value it sees appropriate.
All right. The court recognizes first that it has not made a finding that the defense's what defense presented in their motion was misleading, but also notes that this is the personal opinion of Mr. Ballard and makes that distinction. Thank you.
Thank you, Your Honor. So, Mr. Ballard, what you're saying is that you had, how long was the conversation with the TMZ reporter?
I think it was less than 10 minutes. It might have been just about 5 minutes.
And so the quote is a compilation of your statements over the course of the 5 or 10 minutes, right?
Right, and strictly in response to the questions that the reporter was asking me.
But you certainly had the discretion to not answer the questions, right?
Of course.
Yes.
You could have said, I can't comment on specific evidence or what I think the quantum of evidence is, right? You could have said that.
Yes, and I didn't comment on any specific evidence.
Well, when you refer to the bullet, you're not talking about the bullet fragment removed from Mr. Kirk's body?
No, I'm talking about general circumstances
General
that can
bullets.
produce an
Interesting.
inconclusive result.
And isn't it fair, wouldn't you agree with me that one of the reasons why extrajudicial statements in many circumstances, and we assert in these, are prohibited is for exactly that reason, that reporters may, for either innocent or other reasons, take statements out of context or misconstrue things, and there's nothing you can do about it. Because once it's published, it's published.
Don't
Right.
give him ideas.
Once something's published, it's published, yes.
We don't need to turn
Okay.
this into a Clinton deposition.
Why don't we turn to Exhibit 4, please? And again, let me know when you had an opportunity to look at that.
I've reviewed that. Thank you.
Okay. And did you have a separate conversation with a reporter from USA Today?
Yes, that was an email conversation.
So a reporter from USA Today wrote you an email and you responded.
Correct.
Did you preview your response with Mr. Gray?
No, again, we just had a general conversation about whether Rule 3.6 allowed us to respond to the prejudicial media stories that were circulating. And Mr. Gray and I agreed that it would be appropriate to respond under subsection C, and he left it to me to handle the responses.
Okay. So have you looked at the statements attributed to you in Exhibit 4?
Yes,
Are they accurate?
yes.
Did the court receive into evidence Exhibit 4?
Mr. McBride?
No objection.
Right, with no objection, defense exhibit 4 is admitted.
Thank you, Your Honor. The third page, Mr. Ballard, of Exhibit 4, which is a total of 3 pages, so it's the last page. There's some paragraphs down at the bottom of the third page. On your copy, are they highlighted in sort of purple?
Yes,
And is the court's copy highlighted in purple?
It is.
All right. So, Mr. Ballard, you see the statement, I'm sorry, the paragraph, the second to last paragraph that says Ballard confirmed.
yes,
Ballard confirmed the FBI and ATF are adding information to the initial reports, which prosecutors expect will include data supporting the initial conclusions. Do you see that?
yes,
All right. Is that an accurate recitation or summary of what you? You're telling this reporter is something that you understand the FBI and ATF will be doing in the future?
yes,
And you're also telling this reporter what you think those reports will conclude?
yes. This was in response to statements in the defense's motion to continue the preliminary hearing, where the defense represented that they did not have the supporting data, the underlying data that supported the initial conclusions. And the reporter asked me whether that had been produced, and I was responding that I anticipated that the FBI would produce the data that the defense was requesting.
Was that a matter of public record at that time that the FBI and ATF were, quote, adding information to the initial reports?
I don't believe it was a matter of public record, other than the defense had requested additional information, and I was confirming that we were facilitating that request.
You were telling a reporter that we had made a discovery request and that you were complying with it.
Correct.
But you were characterizing what the FBI and ATF were doing with their examination reports, right?
No,
It says the FBI and ATF are adding information to the initial reports. That doesn't sound to me like producing additional discovery. That sounds like,
Objection. Counsel's testifying.
Counsel, would you like to respond?
I'll rephrase the question.
All right, so I'll
Would-
sustain the objection. You may continue.
Thank you. Wouldn't you agree with me that what you are telling this reporter is that forensic examiners are changing their reports or adding information to their reports, as opposed to your office is obtaining additional background materials related to the testing?
no.
Let's go to Exhibit 5, please.
Oh man, come on. Exhibit 4 was the one where it's at. That was the one where it's really the closest to the line, in my opinion.
Exhibit 5, are you familiar with that?
Going to be more
Yes,
testing.
I've seen this article.
Did you have a conversation of any type with somebody associated with PolitiFact, PolitiFact?
Yes, again, this was an email conversation with the reporter that's credited with the story in Exhibit 5.
If anybody wants these emails, I'd expect they'd be discoverable under grandma. Prosecutor to the to the media. Just putting that out there if anybody cares. We already know what he said because they published it, but I know some people like to go down rabbit
And on
holes.
page 2, about a third of the way down, there's a paragraph that starts with quotation marks, when the results of a bullet fragment. Do you see that?
Yes,
And that's a quote attributed to you, correct?
correct.
And then after identifying you, there's another quote attributed to you.
Yes,
And are those accurate reiterations of the email you sent?
yes,
Could this exhibit please be received into evidence as Defense Exhibit 5?
No objection.
Defense Exhibit 5 is admitted.
And in this second quote in this paragraph, your quote is saying there just aren't enough marks on the fragment to make a conclusion one way or the other, whether the bullet fragment was fired by the particular rifle.
that's what that quote says, but you have to read it in context with the previous sentence.
He's so
So
hung
it's
up on
your
the bullet.
testimony that you're not referring to the rifle found by law enforcement at UVU, and you're not referring to the bullet fragment taken from the decedent's body? You're making a general statement about bullet fragment analysis?
Correct.
Yes, he is.
How did you end up appearing on Fox and Friends News and being interviewed?
Like many other media organizations, Claudia Cowan from Fox News emailed me, asked if I had any comment about the defense representation and its motion to continue and the media stories surrounding that. And I agreed to do a Zoom interview with Fox.
And did you discuss that with Mr. Gray before you did?
Not that specific. Again, I didn't discuss any of the specific media requests with Mr. Gray. We had the understanding that I should respond to the media requests as they came in.
How many media requests were there?
My memory is 8 or 9.
Okay, so you had a telephone call with TMZ, correct?
Yes,
And you had email communications with USA Today and PolitiFact,
yes,
and you were asked to appear for a video interview by Fox and Friends.
yes.
Are there any other media entities who you communicated with directly
CH
in
doing
any
the
of those
countdown.
ways? Parenthetically, because we're only aware of these 4.
Like I said, I think there were at least 8.
8 requests.
Yes, and I responded to all of those. I had a telephone conversation with a correspondent for NBC. I can't remember exactly all of the other news organizations that had contacted me.
Did you in any way collect the resulting news stories in which you are quoted?
No, I have some of them. I didn't make a search to find everywhere that I was quoted and collect those.
Okay, we would like, Your Honor, to show Mr. Ballard Exhibit 7, which is a video. And Ms. Visser is going to help us. Thank you. May we publish Exhibit 7?
Well, not before it's admitted.
Okay, so-
if you want
So we'll
to
show it to Mr.
wait for
Ballard.
motion, Sure.
We'll show it to Mr. Ballard, and maybe if the clerk could just show the, show it to the witness before it's published. Mr. Ballard, can you look at the screen, actually?
It's going to take a few seconds. It's flickering while it syncs.
Thank you for your patience, Your Honor. Should we, silent for a moment.
All right, looks like
Without
it's
sound.
on. the screens.
Okay, so we're going to actually, because of the court's ruling on publishing it, we're going to show it without the audio and ask Mr. Ballard if he recognizes it.
All right. Looks like our screens went off here, so.
Mr. Ballard, is your screen on?
now
It's
it
on
is.
Okay.
and it's playing.
Can Your Honor see it?
Yes, thank you.
It's going to be a famous blue raincoat by the end of the day. There's a song I haven't thought of in a million years.
All right, why don't we stop for a
Good one.
second? Mr. Ballard, is that you?
Yes, it is.
All right, do you recall doing this interview?
Yes,
Did you watch this interview after you participated in it?
I watched this story. Yes.
Okay. Is this, as best as you can tell, an accurate digital copy of that broadcast where you were interviewed by Fox and Friends?
I haven't heard the audio, but I believe it is based on what I've seen.
Okay, well, I'm going to ask the court to receive it into evidence. And if Mr. Ballard thinks that the audio is inconsistent with what he previously said, we'll withdraw the exhibit.
With that proviso, no objection.
All right. Defense Exhibit 7 is admitted and may be published.
Thank you. We'd now like to play it. And just so Your Honor knows, the entire thing is about 2 minutes and 12 seconds.
All right, thank you.
Rather than trying to cut it up, we'll just play the whole thing. With audio. Maybe.
Well,
Actually, and now we can publish it, so all the screens can be on, right?
it's on the screen. It's just the audio isn't coming through.
It says it's connected to the HDMI.
This is always the tricky part with technology. Okay.
Piece of evidence, the bullet that killed the
Do you want to
conservative
restart it now?
icon. In a new defense filing, attorneys for Tyler
Charlie Kirk are pushing to delay an upcoming trial hearing as new details come out surrounding the ballistics report.
Claudia Cowan joins us now with the latest. Good morning, Claudia.
Good morning, Lawrence and Brian, and also to you, Rachel. Nearly 7 months after Charlie Kirk was assassinated, lawyers for his accused killer are attempting to cast doubt on a critical piece of evidence, the bullet that killed the conservative icon. In a new defense filing, attorneys for Tyler Robinson say an ATF summary report, quote, was unable to identify the bullet recovered at autopsy to the rifle allegedly tied to Mr. Robinson. But prosecutors say that report is inconclusive and doesn't rule out a ballistics match to the rifle Robinson allegedly used or to any other firearm.
The examiners were not able to find enough detail on the fragments to be able to make a determination as to whether or not they can tie the bullet to the rifle.
Law enforcement sources tell Fox that when the bullet hit Kirk, it struck.
Well, that seemed edited.
Mr. Ballard, was that your statement on Fox and Friends?
That was the statement that they chose to play.
Is that the statement you chose to make?
Yes.
And aren't you talking in that statement about the bullet fragment at issue in this case?
I prefaced that statement with the preface that I put on my other statements was that I'm not going to talk specifically about specific test results, but generally when there is a inconclusive result, these are the circumstances that could produce an inconclusive result.
So your testimony is that the statement that you just made to Fox and Friends is not referring to the bullet fragment in this case.
Right.
That's your testimony.
Right.
They took his statement and edited it. No, the media.
So obviously
wouldn't do
your
that.
office, Mr. Ballard, and apparently TPUSA were concerned with what I'm going to refer to as the media spin on the contents of the motion to continue, correct?
Can you
Your
rephrase
office
that?
was concerned, and TPUSA expressed concern about the way the media was, I'm just going to use the word spinning. I think we all know what that means. The contents of the motion to continue.
I can't speak for TPUSA because I wasn't privy to that phone call. But our office was concerned, yes, about the prejudicial media reports.
So my question is whether the goal of these interviews was to influence the reporting, or was it to change the public, what you were concerned was the public perception of the case?
The goal of these interviews was to respond to the specific media inquiries that were being generated by the misinformation that was circulating about the bullet testing.
But there's a reason why counsel who are subject to the rules we're talking about here, and especially prosecutors subject to these rules and the court orders, choose to engage in extrajudicial statements. I understand your position is it's an
Objection, argument
extrajudicial
is, and
statement,
that's
which
not a
is
question.
permissible under the court order and the rules. I don't agree with you, but I understand that's your position. So what I'm just asking you about is what you hoped to accomplish. Was it to change the media content, or was it to
Objection, false dichotomy.
influence the public perception
It's not an
of
objection,
the
but
evidence
like
in
it
this
should
case?
be.
Objection asked and answered.
Mr. Novak,
I don't think I asked that question. Or if I did, the answer wasn't responsive. Mr. Ballard's response to the last question was the goal was to respond to media inquiries. Was that the only goal, just to respond to media inquiries? I'm sorry.
Counsel, I need to rule on the objection before
Absolutely.
we move forward. I'm going to overrule the objection and allow that question to be answered.
The goal was to respond to the substantial undue prejudicial effect of the media stories.
What evidence do you have that there was undue prejudice? We haven't picked a jury yet.
The evidence that the reason that we were concerned about those statements is that it was producing we were concerned about the media stories that were saying, first of all, that the bullet in fact did not match, and that therefore we had no case, that we had brought a groundless prosecution. That was our concern.
Which is an issue that can be addressed through jury selection, correct?
That's one way. Yes.
It's an issue that could be addressed through an expanded jury questionnaire, correct? It's an issue that could be expanded through additional peremptory challenges if the court deems it appropriate, correct?
That's another way.
It's
Yes.
an issue that could be addressed through individualized voir dire, correct?
Yes.
It's an issue that could be addressed under the appropriate circumstances through a change of venue, correct?
Perhaps.
A couple more questions, and then if I have any more time, I'll reserve it.
You have 28 minutes remaining.
Oh, wow.
So-
28 minutes. Look at that.
This or scared me.
CH on the money. Math queen over here.
Before you decided to return these phone calls, answer these emails, and accept an invitation to appear on Fox and Friends, did you ask this court to clarify its order in light of the way the media was interpreting the motion to continue?
No.
Did you reach out to anybody in Mr. Robinson's defense team and say, you know, whether you guys did this intentionally or unintentionally, the media has misinterpreted your pleading. Can we do something about that judicially,
No.
as opposed to extrajudicially?
No.
I have no further questions for Mr. Ballard.
Thank you, Mr. Novak. Mr. McBride.
Oh, Lord. Vibes of the motion to disqualify. That was a very pointless 68 minutes. We already knew all this.
Oh, yeah, sure.
Not a single thing we didn't know.
I think I've got everything anyway.
Hey, Mr. Ballard, I wanted to ask you a little bit of follow-up from what defense asked you. First off, I want to ask you, did you intend to violate the court's order in this case?
No,
Do you believe you violated the court's order in this case?
no,
Did you take actions to avoid violating the court's order in this case?
yes,
And do some of those actions include being familiar with the order,
yes,
being familiar with Rule 3.6,
yes,
limiting your statements to the media to those necessary to address the issues prejudicing your client?
yes,
Did you include a statement in some of your statements that the defendant was entitled to a presumption of innocence,
yes,
and a statement that the jury would decide the defendant's guilt as the finder of fact in this case?
yes,
On March 30th, at about 4:43 our time, did the Daily Mail run a story entitled "Bullet Used to Kill Charlie Kirk Did Not Match the Rifle Allegedly Used by the Suspect Tyler Robinson"?
yes,
I'm showing you on the screen. Can you see on the screen?
yes.
Exhibit 22.
22.
Yes. Excuse me, Exhibit B.
Okay, yes, I see exhibit.
And is this Exhibit B to the filing, the state's opposition to the motion to continue? What's the title of this?
I assume that. Let me see the first page.
State's opposition to the motion for an order to show cause for alleged contempt of court in this case?
Yes,
And is Exhibit B that Daily Mail story that you referred to just now?
yes,
Was this the first story that that generated all the media that has brought us to this stage in this case?
that's my understanding.
And after that story was published by the Daily Mail, are you aware of whether other outlets published similar stories?
Yes,
I'd like to turn to Exhibit C in that same pleading.
okay,
And for the court's record, this is docket 510, Exhibit C. And this is a USA Today article, is that right?
yes,
They're going to be
The
disappointed.
title is,
in,
"Does the bullet match? Key issues
in
emerges
Utah."
in Charlie Kirk murder case," correct?
correct.
And I now want to turn to Exhibit D to this pleading. And this is an article by People, is that correct?
Correct.
Also published on March 31st of 2026.
Yes,
And the title here, will you read that title?
bullet that killed Charlie Kirk doesn't match Tyler Robinson's rifle, his lawyers claim.
Right, I now want to turn to Exhibit E to the pleading. And this is a CBS News article also published March 31st, 2026, correct?
Yes,
And will you read the title there?
Charlie Kirk's accused assassin's lawyers question link between bullet from autopsy and rifle found near scene.
I now want to turn to Exhibit A to your pleading, or to the pleading that we've been talking about. First, updated the next day, April 1st. Will you read the headline there?
How one headline shaped the narrative.
What happened to our sound? Sound is train wreck today. They stopped talking and like literally nobody even notices. Doesn't matter at all. The sound guy in the courtroom is asleep already also. Come on, dude. You can do it. You can fix it. I feel like the funny lip reading version of this hearing is going to be way more entertaining than the actual hearing. Probably more substantively valuable too.
Way that we were relying on that was there was no grounds for us to be able to rely on that piece of evidence, that evidence didn't support our case. And because it was a key piece of evidence, that we did not have the evidence to be able to proceed in this case.
And did that make you concerned your client might be your client's
Mr.
right
McBride, excuse me, let me stop you. There may be an issue with the audio being transmitted, so I just want to make
Judge,
sure that's
thank
remedied.
you. Judge is going to
and
police
then we can
the feed
continue
for us.
once we confirm it's functioning as it should.
Thank you.
This shit is awesome. He already did it with the mics, dude. Talk into your mic so that the feed can pick it up. I don't care what Judge Graf does about Legos, okay? He's awesome in this case.
All right, do you want to?
Testing, 1, 2, 3, testing.
I want more of the strike calls from Mr. McBride. He's over there calling the strikes. Nope, that one caught the corner, Judge.
Mr. McBride, we can continue.
Thank you. Were these reports that we've gone over in the last couple of minutes, these news stories, were they accurately reporting what the evidence was in this case?
No.
And did that cause you concern about whether it would affect your client's right to a fair trial?
Yes, it did, because not only were those.
Man, they just can't. They can't get it. They can't get it, can they?
In those other articles.
When you received those calls, you testified that you and Mr. Gray had spoken about this. You'd spoken about Rule 3.6 in the court's order. But when you received those calls, you had the option, as you testified in direct examination, of just saying no comment, correct?
Right.
Would a no comment, how do you believe that response would be received by the public if the media states, we reached out to the Utah County Attorney's Office when they were asked for comment, they responded, no comment?
Objection calls for speculation, relevance.
Mr. McBride?
The question here is whether or not Mr. Ballard responded as a reasonable attorney would under Rule 3.6C.
Could you repeat the question? I just want to make sure I'm processing it properly.
How do you believe the press would, or how do you believe the public would receive a story that had the response from the Utah County Attorney's Office as no comment?
I'm going to sustain the objection because it's asking for him to perceive what the public would perceive, and that does go to speculation.
I'll attempt to lay more foundation. Does the public's perception matter as it relates to your client's right to a fair trial?
It can, yes.
And is the public's perception ultimately what the public's, and even more particularly the potential jury pool's perception, what matters when we're talking about prejudicing your client's rights?
Yes.
And so isn't it true that you have to make a judgment about how the public is perceiving the media statements?
Leading.
This is
Well, it's
cross-examination.
cross-examination, so I'm going to overrule that objection.
Yes.
Did you believe a no comment response would cure the prejudicial effect of the media stories?
No.
Did you believe it would actually potentially increase the prejudicial effect of these stories?
Yes, especially given the kinds of stories that were circulating there, like that our case has a fundamental problem, that this is a bombshell, and for us to,
It's true, it
to
would.
say no comment
No
or to
comment would
not
be a
give a
whole
response
new story.
would feed the, my concern was that that would
cycle.
feed this idea that the state really does not have sufficient evidence to proceed.
Okay, thank you. You mentioned before responding to these requests, you spoke with Mr. Gray about the requests and about the media that was out there at the time. Why did you speak with Mr. Gray about that?
Because we recognized that this was a significant issue and that we needed to figure out how we were going to respond to that.
And was part of that to determine whether you could ethically respond?
Yes, I think that the conversation was, should we, and can we, and should we?
I want to refer you to the court's order, the pretrial publicity order, and that's published on the screen in front of you. Do you see that?
Yes.
Will you read the last sentence of that order? This is the order dated September 16th, 2025.
It says this order does not prohibit lawyers from making statements permitted by Rule 3.6. C, Utah Rule of Professional Conduct 3.6 sub B sub C.
Based on the language of this order, did you believe that it prohibited you from making public statements?
No.
Did you believe it prohibited you from making public statements that were allowed by 3.6B?
No, it allowed me to do that.
And same question with regard to 3.6C. Did it prohibit you from making statements under 3.6C?
Objection, he's asking witness for a legal.
Did you want to respond, Mr. McBride?
No. I disagree with that objection, but I think the court can rule on that without response.
Well, I'm going to overrule the objection because that was fodder for the direct examination. It was addressed. He was asked about that. And so this is cross-examination and that door has been opened.
Okay, let's look at 3.6, Rule 3.6. And that's up on the screen in front of you. I want to go through those particular statements or particular subsections referred to by the order, 3.6B and C. There's a couple of highlights here on the screen in front of you. Is that up on the screen in front of you?
Yes, I see those.
If you look at 3.6B, will you read those two highlighted portions? That's B, basically B and B2.
Yes. It says, notwithstanding paragraph A lawyer may state information contained in a public record.
Okay. Now, before going to 3.6C, let me ask you, on direct examination, defense counsel had a line of questioning about whether you can talk about anything that's in the public record extrajudicially to the media. You began to answer that question, but you weren't given the chance to finish your answer. Under 3.6B, will you talk about your understanding of what you can talk about that is in the public record?
My understanding of that, the language of the rule is that if there is something that's contained in a public court filing, that that I can comment on that extrajudicially.
In this circumstance, was the statement that generated this in defense counsel's pleading, that the ATF was unable to tie the bullet to the gun, was that in a public pleading?
Yes.
And the report that they made that statement from, the ATF ballistics report is what I will call it, was that in a public pleading?
It was. The defense attached that report to their motion to prohibit testing, and the court had ordered that to be made public.
Yep.
And that report was attached to a pleading in docket number 284. Is that your understanding?
I don't know the exact docket number, but it concerned, I think it was their
284, I
January
remember.
9th motion.
Okay.
Because I got it from the
And
court.
for reference, the court's order making that docket number public is docket 460, March 12, 2026. I want to go to the next subparagraph. Okay, actually, before I do, notwithstanding that this report was public by this time, the ATF ballistics report, did you specifically comment about the ATF ballistic report and its findings in your statements to the media?
No, in fact, if you look at Exhibit 4, the highlighted portion there, I say, when I'm responding to the USA Today reporter, I say, the ethical rules prohibit, well, it says ethical rules prohibit him from speaking publicly about forensic testing and results. And then I go on to say, but I can say generally that when you have an inconclusive result, these are the types of circumstances that might produce an inconclusive result.
Okay. Let's move to subparagraph C, 3.6C, which is up on the screen. Will you read the highlighted portion of subparagraph C?
Yeah, actually, it's not up.
It's
For
going to
some
take a
reason.
few seconds for it to render itself on the screen. Not just yet.
I could read it from the exhibit.
Let's go ahead and do that, if you don't mind. So the first full sentence of subparagraph C.
This is from Exhibit 10. It says, notwithstanding paragraph A, a lawyer may make a statement that a reasonable lawyer would believe is required to protect a client from the substantial, undue prejudicial effect of recent publicity not initiated by the lawyer or the lawyer's client. Want me to continue?
No, that's fine. So as you read that, is there anything, do you see any language in subparagraph C that requires that any other public undue prejudicial, substantial undue prejudicial effect of recent publicity must be generated by a defense counsel or opposing counsel?
No.
Okay, I now want to turn to your particular responses. So after you met with all these responses or all these media inquiries were coming in, you meet with Mr. Gray and talk about whether you should and could respond. The answer is yes, we're going to respond, we should respond. Then you actually make the responses, correct?
Correct.
I'm going to turn back to the pleading that we'd referred to, where we had attached many of the news stories. We have here exhibit, let's see if this is the right one, exhibit F. And this is, I think this also appears in defense counsel's binder.
Is it the USA Today story?
This is the New York Post story. I'm going to ask you to read the first two paragraphs here on this page. Actually, let me jump to page 46 here of the pleading. Will you read the first paragraph on page 46 of the pleading, Utah County Attorney's Office?
Yeah. Utah County Attorney's Office Prosecutor Christopher Ballard said he can't comment on forensic testing and results, but he said, quote, when the results of a bullet fragment analysis come back as inconclusive, that means only that the fragment did not contain enough detail for the examiner to determine whether the characteristics on the fragment were consistent with having been fired by a particular firearm, end quote.
And is that consistent with how you attempted to respond to all the media outlets that made inquiries?
Yes.
And is that in fact your statement?
Yes, I can't say that it's exactly word for word, but that accurately captures what I was trying to convey to the reporter.
Okay. I want to go to Exhibit G to the pleading. This is a PolitiFact article entitled, Does a Bullet Analysis Clear Charlie Kirk Suspected Killer? What an Inconclusive Result Means. I'd ask you to read that first full paragraph, starting with when. Will you read that, please?
When the results of a bullet fragment analysis come back as quote, inconclusive, unquote, that does not mean that the rifle did not fire the bullet. Christopher Ballard, a spokesman for the Utah County Attorney's Office and part of the prosecution team, wrote in an email to PolitiFact.
Thank you. Again, is that accurate?
Yes.
Same answer. You can't say word for word, but in essence, it's accurate.
Right.
I want to jump to the TMZ article. And is this TMZ article here, this Exhibit I to the pleading, an article that quotes you?
Yes.
So let's go to page 58. And we talked about this quote previously. Defense counsel asked you about this. And the statement beginning with Attorney Christopher Ballard tells us, that paragraph, is that the same? Is that quote starts with generally and ends with trial? Do you know if that is, if that quote is exactly how you said it to them?
The quote again comes from, I'm answering two different questions from the reporter. First, the reporter asked me about these claims that the bullet didn't match. And then he asked me, so do you still have a case? Basically, do you have enough evidence to proceed? And so I was first addressing the specific question about the bullet, the claim that the bullet didn't match. And then second, I was responding to this idea that because of the forensic testing, we couldn't proceed with this case.
Okay, thank you. I'll go to the next page, 59. And I'd like to ask you to read the first two paragraphs here on page 59.
As we reported, Tyler's defense team argued there's a discrepancy between the ballistic evidence and the weapon prosecutors say is connected to Robinson. In a filed motion, they wrote, quote, "The defense may very well decide to offer the testimony of the ATF firearm analyst as exculpatory evidence," unquote.
And then will you read that next line as well?
Yes. It says, but Ballard says this isn't expected to derail their case against Robinson.
Thank you. Now I'll go to page 60 of the same article, the TMZ article, and ask you to read these two paragraphs as well.
It says, he told us, quote, "Can't speak about specific evidence, but the evidence that we detailed in the charging document is a general summary of the evidence that shows Tyler Robinson committed this crime," unquote, end quote. And it says, Ballard added, quote, "He is presumed innocent. The ultimate decision will be up to the jury. We believe we will be able to overcome his presumption of innocence," end quote.
Thank you. Now, defense counsel in one of their motions, they quoted the Standard, which is a Hong Kong agency, and did you look at that quotation to the Hong Kong or to the Standard?
Yes, when I saw that in the defense pleading.
Okay. And I've got that up on the page on the monitor in front of you. It's page 8 of defense counsel's motion for the order to show cause. And this, there's the double indent here. Do you see that?
Yes.
Did you talk to the Standard?
No, they did not contact me.
And it looks like they included some of your statements, but not all of them. Is that accurate?
It looks like they're referring to the TMZ article, and yes, they took some of the quotes, but not all of them.
Okay, thank you. If I can have just a moment.
Oh, do we all have to wake up? Is it time? Not enough coffee in the world today.
Okay, I wanted to refer you to Exhibit 4 in defense counsel's binder.
Okay.
Let's see, in that purple highlighted portion on the last page,
Exhibit 4.
the second to last
is-
paragraph, this was discussed a little bit earlier, but I wanted to make sure that this was clear. Will you tell us what you were referring to in this second to last paragraph? It reads, Ballard confirmed the ATF or FBI and ATF are adding information to the initial report. The prosecutor expected will include data supporting the initial conclusions. Will you explain what that's referring to?
Yeah, my recollection is that the defense is part of their motion to continue the preliminary hearing. As part of the justification for that motion, they had argued that they hadn't received all of the underlying data that supported the conclusions in the initial reports. And so the reporter was asking me about whether had that data already been produced or whether it would be forthcoming. And I was confirming that the FBI was gathering that and would be providing that, the information that the defense requested.
Did you personally appear on Fox and Friends?
No, I did a Zoom interview that they used as part of that program.
And the video we watched earlier, is that the entirety of this portion of your interview that they used on that program?
Yes.
You didn't go to New York and sit down with them?
Nope.
Did you actually ever leave the office and go on a media speaking tour?
No, all I did was respond as the media inquiries came in.
Okay.
So that's interesting. The whole extra data and stuff. That's the statement I was most concerned about, because I'm like, you're telling them the FBI is going to have more evidence. But his explanation is, no, we were talking about the DNA stuff. The DNA and the ballistics with the underlying data that the defense was complaining about.
Mr. Ballard, isn't it correct that there was a point in time with respect to the pleadings in this case that the defense's motion to prohibit the additional testing without some safeguards to document it, record it, monitor it, was a private filing?
Yes, the defense filed it as a private filing.
And you initially agreed, meaning you on behalf of your office, that it should be a private filing because it dealt directly with
A way to incentivize
forensic
them
examinations.
to not agree in the future.
No, we opposed the motion to keep that filing private.
But as you said in exhibits 6 and second, Your Honor.
Yeah, he did. He said 90 minutes aside, inclusive of witnesses and argument.
Make sure I'm setting the
And we
correct
haven't heard from
exhibit.
Mr. Gray yet.
In exhibit 6, that you initially hoped that the dispute over the testing could be resolved between the parties, right?
Yes.
Okay. And then we filed, meaning Mr. Robinson filed, a motion to get some control over that FBI testing because the FBI had basically said, we won't let a defense ballistic expert watch and we won't videotape it, right?
I wasn't privy to what the defense was saying, or the FBI lab was saying.
But you're aware of the dispute.
There was a dispute, yes.
The FBI wanted to do further testing on bullet fragments, and
What do they want
we
to
were
do? Tell us.
concerned that
Come
it
on,
would
tell
have
us.
a destructive effect on the evidence. And so we asked to have a ballistics expert observe the
specific.
FBI testing, correct?
I know that you filed a motion.
We asked your office to arrange with the FBI for an outside expert to observe. Aren't you aware of that?
I know that you were requesting certain procedures.
Right, was to either be present or videotape it. Or maybe you don't know what the procedures were.
That sounds correct to me. I wasn't part of those negotiations.
Okay.
That
And
discussion.
when the FBI didn't agree to let there be light on whatever they were going to be doing, as opposed to darkness, we filed a motion for judicial intervention,
So
right?
dramatic.
Yes, you filed a motion.
And we filed it privately.
Yes.
And we argued to this court that it should be private because it addressed forensic testing not yet received into evidence and future forensic testing not yet received into evidence. And the state opposed that.
Counsel's testifying.
Didn't we file that?
Oh, counsel, there's an
I did
objection.
it again.
Would
Sorry.
you like to respond?
I can rephrase it in the form of a question.
All right, I'll go ahead and sustain the objection maybe rephrased.
Are you familiar with the reasons why we thought the forensic testing documents and the dispute should be filed and litigated privately?
I think I generally understand why you wanted that private.
And the state decided it should be public.
We decided to oppose that motion.
It was your position that it should be public.
Yes,
And then the court overruled or denied the motion to keep it private, correct?
yes,
And so that then became a matter of public record, which you believe you could make extrajudicial statements about.
I believe the rule allowed that, yes.
Now, your testimony is that you only intended to communicate to the media generally how bullet fragment analysis works, correct?
Yes, I was responding to those inquiries and being careful to stay within the confines of Rule 3.6.
But the media inquiries were not generally how is bullet fragment analysis conducted and what are the findings and what are the conclusions. The questions were about the bullet fragment analysis in this case, correct?
Yes,
Would you agree with this following statement? In the first few weeks of this case, there were many media stories emphasizing evidence of Mr. Robinson's guilt.
yes.
So your interpretation of Rule 3.6, because of that, is that I could go on Fox and Friends or send emails to media entities or have telephonic interviews where I say on multiple occasions, it's my opinion that my client is innocent.
Objection, relevance.
Do you wish to respond?
Mr. Ballard has testified that
So
he
what's your-
doesn't
what's
think
your name?
that his
So what you're
public
saying
his
is,
extrajudicial statements,
who was that nasty
violate
British lady that interviewed Jordan
rule.
Peterson?
and he specifically referred to comment 4,
That's what
which
this
says
question
any
is.
opinion as to the guilt or innocence of a defendant
So
or
you're saying
suspect
your
in a
opinion
criminal
is,
case is not prohibited because of what he says is prejudicial pretrial publicity. And so I'm asking the obverse, which is whether he agrees that that means that I or somebody I hire could go on a speaking
Thank
tour.
you.
I'm not saying you went on a speaking tour, but and
thank you, Chad.
and proclaim my opinion
I knew you'd know.
that Mr. Robinson is innocent without violating this court's order or without violating the rules of professional responsibility.
All right. I understand the objection and the response. I'm going to overrule the objection as it's within the nexus of what's being addressed in this hearing and what's been brought up in both direct and cross-examination.
What I understand the rule to allow is for a lawyer to make statements that the lawyer believes are necessary to protect their client from substantial undue prejudice of media stories.
So if I think in good faith that my client has been, that there is already
There's a
proof of
reasonable
undue
lawyer
prejudice
standard.
against Mr. Robinson because of all of the media stories,
Oh, Lord help us.
without seeking any judicial intervention, without seeking an ethics opinion from the state bar, I can schedule media interviews. I can issue press releases saying it's my opinion that he's innocent.
I think your interpretation of Rule 3.6 is up to you.
I'm asking you if you agree with that hypothetical.
Repeat the hypothetical.
Without any findings by anybody at this point of undue prejudice, And based on the media coverage to date, which we are all familiar with, do you agree? Well, is it your opinion that the rule permits me to go on Fox and Friends or have telephone calls or send emails, issue a press release that says it's my opinion that Mr. Robinson is innocent? And that if I did that, I would not be in violation of this court's order or
No, but you
the
could say, I
ethical
believe
rules
he
that
will
we've
be
been
found innocent by
discussing.
the jury.
I don't see anything in the rule that requires previous findings about prejudice.
It's just your conclusion that there is prejudice. That's enough?
I believe that what's required is what the rule says.
It's a reasonable lawyer standard. Of course,
Thank
it's
you.
not enough.
Appreciate the court's time.
Thank you.
Oh, brother.
Anything further for this witness?
It's excruciating.
No.
Mr. Ballard, you may step down. Thank you.
So much avoiding the point.
All right, to defense, looks like you have about 20 minutes left. I didn't include the cross-examination against your time. We'll go to the state's time.
That was
but,
generous.
how would you like to proceed next?
I have a few questions for Mr. Gray, since he was mentioned in the testimony from Mr. Ballard, and the OSC was returned against Mr. Gray as well.
Would you prefer to take a 10-minute break, or do you want to keep going? I'll defer to you.
I think a 10-minute break would be great.
All right.
Thank you.
Court will be in
No
recess
way.
for 10 minutes. We'll come back at approximately 11:35.
Oh man. We are watching the motion to disqualify all over again, which is basically all they're doing is just calling testimony to establish what was already in the briefs and not get anywhere with it. I'm just going to leave the screen on so that we can see when they go back. Oh, brother. Well, so we started off today. Of course, we had our little media struggle session, but I'm so entertained by that whole calling the media up to put them on the spot about doing their jobs with the cameras, and now he's also going to ride them on the sound. Thank you, Judge Graf. We appreciate that so much. But after the media struggle session, then we had his ruling on the stay, the request for stay. It's been fully briefed. They submitted it. Nobody requested argument on it. So he has gone ahead and issued his ruling. It was an extremely long ruling, and it will be in writing. It's probably already up on Exchange. So I will, get that in and get that up pretty soon. But the bottom line is he is not staying the preliminary hearing while the defense tries to appeal to the Utah Supreme Court, because he says there is no two things: either harm, like there's no showing of significant harm, or alternatively, even if you kind of assume that there sort of is, like hypothetically, then the balance of the equities does not favor a stay. There's too much downside from delay, too much consequence from delay under the circumstances. And so basically the judge, his main concern is like, this is all hypothetical at this point, because we don't even have the media. We don't even have a request yet to do electronic media coverage. You haven't opposed it or not. So there hasn't really, there's no live issue before the judge is kind of what the problem is. And normally, there wouldn't be a live issue at all, because it's like an ex parte thing that goes to the judge the day before the hearing sometimes, about whether the cameras can be there or not. He, like, on his own decided to extend this process so that the defense can litigate it. But nevertheless, we're still not at the point yet where there is any indication. There's no ruling. Like, we can all anticipate, of course we can all anticipate, somebody is going to file an electronic media coverage request for the preliminary hearing. That's a no-brainer. But there's nothing You know, for what reason would the defense be objecting and stuff like that? It's just not, you know, they could have a good reason. They could have a good reason, or, you know, they could have more information about like how the hearing is going to go. And so here's why it would be prejudicial. And the judge could say, oh yeah, you know, based on that, you're right. This particular hearing shouldn't have the camera in it. So that's possible. We're not at that point. And that's the primary concern that the judge has, is we're not going to stay everything while you appeal this, when we don't even know yet. We're not even at the point of knowing that there's cameras in the courtroom. So this is kind of a cross between the two possibilities that I talked about at the top here before we got started: the kick the can down the road, the like wait and see what happens, with the just flat out deny it because, you know, they're not going to get on interlocutory review, guys. Highly unlikely. Highly, highly, highly unlikely. The judge did make that comment about the calling for the response. It's unusual. It calls for it indicates there's a significant legal question. They're taking it very seriously. Due respect for the judge and his familiarity with his jurisdiction. Can't argue with that. But I can't agree. I just really can't. Like, and I don't think it's a really jurisdictional thing that matters when you're talking about a capital case. Everybody is bending over backwards to let the record be made here because this is a capital case. That's why. So they're giving everybody the benefit of the doubt. That's how I see it anyway. But you know, his view is, well, yeah, it's an important issue. Possible the Supreme Court's going to take it up, but even if they did, it still doesn't justify putting a stay on the process that they have moving forward. So after the judge gave his ruling, his very long ruling, we had a little conversation with Mr. Novak because he's concerned about the judge set up this special process for the defense to be able to object to these specific requests for electronic media coverage that normally only have to be filed the day before and just get kind of rubber stamped by the judge. He set up this whole process where they got to do it ahead of time. The defense has an opportunity to object. They have an opportunity to respond, and then there will be a ruling on it. And the defense is like, your schedule doesn't work here because we're going to need to do the same thing that we did with the denial of the categorical ban of the cameras. We're going to need to seek interlocutory review. We're going to want to ask the Supreme Court to review your ruling on electronic media coverage for the preliminary hearing. And so if you don't give us the ruling enough ahead of time, then we won't be able to do that in a time frame that is meaningful, because you know, we won't have time to go up to the Supreme Court and get them to maybe put the brakes on the situation before it goes forward. I am so, like, not just kind of skeptical of this argument, right? And the sort of implicit entitlement to interlocutory appeal. You certainly have the right to seek it, but your likelihood of actually getting it is extraordinarily low. It always is. It always is. But just in this particular situation, I feel like the defense is kind of starting to clue everybody else in this courtroom in that being generous with them, being like overly fair with them, they are just going to take that and turn it against you and run with it as hard as they can. There's just like a sort of judgment issue here that I'm really kind of questioning. The judge himself is like, I gave you this proceeding. I bent over backwards to give you more say and more process than you're entitled to. And here you are saying that's not good enough. And the judge is like, and so Mr. Novak's whole thing is like, well, we just want the ruling before July 6th, so we have time, if you rule against us, that we can file for interlocutory review. The judge is like, I can't know what I'm ruling on until I have stuff. I don't know. I don't know when any of this is going to come down. I don't know what's going to come down. I don't know how it's going to be handled. And you're asking me to like predetermine the procedure. And the judge says, I don't control a lot of these variables. Like how long does it take for people to respond and stuff like that? Judge doesn't control that. And he's not going to issue a decision before everybody has had the opportunity to have their say. So this is just like, they're really showing the judge that the more say that you give, the more complicated this whole thing is going to become. And that really, how does that not disincentivize the judge from giving you these opportunities and these benefits of the doubt? You know, I don't think in practical terms it's going to change like how he rules or how he allows the parties to make their cases and the kinds of protection and leeway he's giving to the defense. Here it is a capital case. But it's just, it seems very imprudent. They have a very polite and congenial court system here, like shockingly so. We spent so much time at the last hearing kind of talking about that this is Mormon country. This is the heart of Mormon country. That it really kind of does mean something. And I don't mean that in a conspiratorial way. I mean it in a cultural way. You know, the culture of this court, it comes across as so congenial, so cooperative. Everybody is like bending over polite to each other. The judge is saying things like he denies your motion, but he's like, I'm respectfully denying your motion. The judge doesn't have to respectfully deny anything. It's like the parties that respectfully submit things, but they have these little, I don't know, these things that they do. And the defense is not playing by that rule. You know, they're not returning the grace, I guess, that the other parties are giving them. Now, they're not required to. Sometimes it's your job to not, to have to push things and stuff like that. But it's just if it's not necessary, I don't know why you would bring something up that potentially jeopardizes all of this. What I see is extremely bending over backwards to be fair over the course of this process. Also, couldn't help but wonder if the defense is saying, remember when we got that ruling on the electronic media coverage, the categorical ban. Judge says, no, we're not going to do a categorical ban. We got to consider these things case by case, and I'm going to set up this new process for you to be able to evaluate it and have your say in everything. And I talked about what that might mean from an issue preservation standpoint, that if this issue of having the media in the courtroom, the cameras in the courtroom, they very much seem to be focused on this as something they are preserving for future review. Not just in the state court, but federal habeas and stuff like that. They want to be able to make due process arguments. They want to be able to make some big law about cameras in criminal courtrooms. But for them to then preserve that issue, given the way that that Judge Graf ruled, it's kind of possible they might need to object every single time. If the judge is saying, hey, you know, rules don't allow me to do this categorically, we got to consider it case by case, then if you want to object to the presence of a camera, you have to object when somebody is asking for the camera to be present. So we talked about that when that ruling came down, that like this might put the defense in a situation where, yeah, they have to object every single time. And so I wonder if this is a little bit of I feel like Mr. Novak is on the same page with me on that. I expect we're going to see objections to every single request for electronic media coverage. And he's also doubling down. By the way, Judge, we're also going to seek interlocutory appeal on all of these. Well, maybe he's not going to bend the rules to let you do extra briefing next time if that's what you're going to do with it. Oh, brother. So that was the ceiling. We then moved on to the defense brought up that they had filed a motion. It's classified. They want it private. It is currently private on the docket, but they are trying to subpoena an out-of-state witness for the preliminary hearing. Out-of-state subpoenas are super obnoxious because the territorial jurisdiction of this court is only in Idaho. Idaho courts have no power over anybody in any other state. So if you want to compel a witness into court in Utah, did I say Idaho? I probably did. Utah. If you want to compel a witness into court there and they live in Los Angeles, then you got to get the California court to order them to go to Utah, because California is the only court that has jurisdiction over that person. So there's lots of different ways that it happens. There is a uniform, like a multi-state process that many states are parties to, but not all. So you got to know what is my state where I'm litigating this case require to compel an out of court witness? What does the state where the witness lives require to compel them into court? You got to follow all these processes. And so it sounds like Utah uses the uniform system. You get a certification from the court that just basically is saying, you know, this isn't like there's decent cause to require this person to have to come in and appear. That then goes to, they have to go file that in the receiving court, the receiving jurisdiction, with a request for that court to issue the subpoena to the witness. So that's the process that we're going through. It's super annoying. Mr. Novak is just saying they want to address that soon because it takes time to go through these processes. Yes, it does, which is why it's a little weird that it's less than a month to preliminary hearing and you're doing out-of-state subpoenas. No, you need a big time buffer to get this kind of thing done. But that's the situation. Gotta wonder who it is. Definitely gotta wonder who it is, because I have a strong suspicion that the name starts with L and ends with Twigs. I got a strong suspicion that's the out-of-state witness that we're talking about. But we'll see. Because we did hear, right, that he's moved out of state. There was the whole thing about like he's disappeared for a long time. He had been under federal protective supervision, but then wasn't, and is like staying with relatives out of state or something like that. So that seems to me like pretty good odds of what we're dealing with. Discovery update, 11 new items. 10 of them are notebooks. One is an 1102 statement for the preliminary hearing. That is the sworn testimony in lieu of live testimony. Looks like they're going to be doing a lot of that for authenticating exhibits and stuff. So you don't have to actually bring in, you know, somebody from Turning Point USA to say, yes, you know, I can authenticate this video that was taken on our cameras and stuff like that. They just do that with a written statement in the preliminary hearing. But at trial, unless everybody stipulates that it's admissible, they have to bring in the witness to do that. Nothing still so far about FBI DNA files, ATF DNA files. Still kind of unclear about the status of that DNA disclosure and all that. But we also don't have a motion to compel. We don't have any litigation yet. So not really sure where that one sits at the moment. We then moved on to the order to show cause for contempt and promptly like fell into a black hole of boredom. Each side, judge says, gets 90 minutes. That's inclusive of their witnesses and their argument. And then the court's going to take a 10-minute recess, which is what we are doing right now. So we spent most of the morning listening to Mr. Novak call to question Chris Ballard, the prosecutor who made these statements. We admitted a lot of stuff that is like already in the record, some of it multiple times. The articles that they're complaining about, the rules, basically just getting on the record the specific statements, although we already kind of had them on the record. But a lot of this, I mean, we spent like 30 minutes maybe just doing preliminary stuff. Yes, this is the rule. Here's what the rule says. And It kind of only started really getting interesting when we got to the TMZ article and wanted to know how did this come about? TMZ has quotes in there from him. How did that come about? So then we started to get a little bit of information about what the prosecuting attorney's office did. So Mr. Ballard's account is that after the defense had filed the motion to continue the preliminary hearing, it had included that statement in it about not being able to identify the bullet fragment as being fired from Tyler's rifle. State has argued that's misleading because it's not identify or exclude. But anyway, it garnered lots of media because lots of people ran with this interpretation of the bullet doesn't match, and that's not accurate. So they had received a whole bunch of media inquiries. TMZ had called the office and left a voicemail. It got forwarded to him. So he returned the phone call. He also had a conversation with Mr. Gray, the elected prosecutor, about how they were going to respond. Grunander might have been involved at some point, but they think that was maybe after the fact. So Mr. Gray had also gotten a call from Turning Point USA asking if there was any merit to these media stories. So it was a very busy morning with lots of conversation and concern about the media coverage. This, he says, was like a general topic of conversation, generally talking about the stories that are out there, the rule that applies as far as the order, and can they or should they respond. So they didn't like sit and discuss or strategize every specific media inquiry. How were they going to respond or anything like that? Ultimately, they just, it was general about whether they believed they had a right to respond, whether they believed that the media coverage was prejudicial, and concluded that they did. And then Mr. Gray left it to him to kind of decide, what the appropriate response would be. So then we had a lot of seizing on, quote, the bullet. Like anytime he said the bullet or the bullet fragment.
Thank you, Your Honor. I'd ask the court to invite Mr. Gray to the witness stand.
Mr. Gray, if you wouldn't mind coming forward and being sworn in.
The bullet, when he was talking about generally speaking, when you get an inconclusive, it means the bullet. And Novak's like, you mean Charlie Kirk's bullet? He's like, no, I mean the general bullet. He's like, but you said the bullet. And we're like, yes, because you need to read the sentence, like the bullet in the testing, the hypothetical testing we're talking about.
Mr. Gray, as you get situated, there's a bottle of water to your left. And after you're seated, if you wouldn't mind pulling the microphone to you so the record picks up your testimony. Mr. Novak, your witness.
Thank you, Your Honor. Mr. Gray, you're the elected county attorney for Utah County, correct, sir? Yes, sir. All right. And so you are responsible for essentially everything that happens in and through your office, correct? Yeah. All right. And is Mr. Ballard still your chief of staff? Yes. Does that mean he reports to you in the sense of an organizational structure? Yeah. All right. And he's also the public affairs officer for your office? Yeah. And he's also an attorney? Public information officer. I'm sorry, public information officer. Yes. And he's also a prosecutor? He's general counsel.
Pull the mic closer.
And he's one of the prosecutors in this case? Yes. All right. Mr. Ballard testified that you and he had some general conversations about media inquiries concerning the contents of Mr. Robinson's motion to continue the preliminary hearing. Is that correct that you had some general conversations?
Yes.
Did you ever suggest to Mr. Ballard that one approach to these inquiries would be to confer with Mr. Robinson's defense counsel concerning the media's misinterpretation of what we had filed?
No, because the rules don't require it.
Okay. Did discuss with Mr. Ballard whether the state should approach the court concerning what, if anything, the court would permit the state to do in light of your concerns.
Again, no, because the rules don't require it.
Do the rules prohibit it?
They do not prohibit it, but neither did his order require it, the judge's order in this case.
Nor did the rules prohibit you
No.
from, I'm
No.
sorry. Nor did the rules prohibit you from reaching out to defense counsel and say, hey, you know, the media is spinning this in a certain way. We need to discuss correcting the record.
No.
Or clarifying media misinterpretations.
No.
All right. What about having a conversation with Mr. Ballard that went like this? Why don't we draft a statement, a single statement that we can send out to media entities and just be done with it?
I don't know that we had that conversation. I might have thought about that, but then you're getting even wider dissemination. I was unaware of how many inquiries there were. That actually might have the effect of going beyond who was inquiring.
But would you agree with me that
It was
one
bound to
approach
be done.
could have been to issue a
Found
statement
irrefutable.
which says the state stands by the allegations in the information and the significance of any evidence will be established in court proceedings?
I don't think that that would be sufficient.
It wouldn't have been sufficient to change the media spins. Is that what you mean?
Yes, I mean, what we're concerned about is prejudice to a prospective jury. And so that could be very damaging to our ability to do that. And so we wanted to ameliorate that prejudice.
And so is it the number of media stories and the content of the media stories which led you to conclude that the state was being prejudiced?
That there was a potential to prejudice a fair trial. Yes,
Based on
based on misinformation.
in the media?
Yes.
But if it were accurate information, that would be okay with you?
I would not be correcting anything if it was accurate information.
Did you consult the, so we have the binding rule of professional responsibility here in Utah. Did you consult the ABA rules on this same issue?
No.
Are you familiar with them?
Yes.
Are you familiar with the ABA rule that basically says extrajudicial statements by one party are only permissible where there have been extrajudicial statements by another party?
Objection, Your Honor. Relevance. What we're dealing with here is whether or
Doesn't
not
matter.
Mr. Gray, Mr. Ballard violated the court's order. It does not refer to the ABA rule.
I think it just goes to the state of mind of both of the individuals against whom the court has already returned to the order to show cause.
Well, help me understand the relevance as it relates. to
Well, we
the
have an
ABA.
ABA rule, which we cited in our reply brief,
Uh-huh.
called Fair Trial and Public Discourse, cited at pages 4 and 5 of 6 pages in our reply brief at footnote 1, which points out that the ABA guidelines limit extrajudicial statements to those circumstances where an opposing party has already made extrajudicial statements. Whereas here, what the state is saying is that it can basically correct the record or make any public statements it wants as long as there's something in the public record, regardless of where it came from.
Why my concern as it relates to relevancy is whether that's binding and whether that's even applicable. I mean, there may be like a best practices, and I'm not saying it is or it is not, but as it relates to the issue before me, I don't see how that's relevant to help me with my finding in regards to the ABA.
Okay, so I think that so far Mr. Gray has said he's aware of it. And I think that's fine.
All right, thank you. So
Is
I'll
that-
sustain the objection. We'll move on.
Is that correct, Mr. Gray? You're aware of that
I
standard?
am aware of the ABA standard.
Nobody cares about ABA anything really.
I'm just going to ask you the same question I asked Mr. Ballard toward the end. Would you agree with me that in the first few weeks, especially, and continuing throughout this case, there has been substantial media coverage commenting upon Mr. Robinson's guilt?
Both guilt and innocence, yes.
Including, okay. And would you agree with me that he is entitled constitutionally to a presumption of innocence?
Absolutely.
Until the matter is submitted to the jury for deliberation?
Absolutely.
And so, do you agree with Mr. Ballard that in light of all of what Mr. Robinson's defense counsel view as prejudicial media coverage, prejudicing his right to a fair trial, that I can make public statements as to my opinion about his innocence without violating this court's order?
No, you cannot make an opinion about innocence or guilt, but I don't think that's what happened here.
Good call, Mr. Gray. That was the trap, and Mr. Ballard didn't seem to be quite able to like gnaw his foot off to get out of it. I wasn't giving an opinion of guilt.
Would you agree that the point of Mr. Ballard being interviewed over the telephone and sending emails and then appearing visually on Fox and Friends was to address media inquiries concerning specific forensic evidence in this case?
It was to ameliorate the prejudice resulting from misinformation from the media.
About a specific piece of evidence in this case?
Yes.
And you think that by crafting that Mr. Ballard's efforts to control the conversation with the media by, as he testifies, just talking about forensic testing generally avoids the prohibitions in the rule?
Whether I believe that avoids the general prohibitions, I
Yeah.
think that's one way to do it.
I know that you did not seek any guidance from the court on this issue. Did you consider filing some sort of a motion or a request asking for clarification on how the court's pretrial publicity order governs this situation?
No, I thought the court's order was quite clear.
Because there was another point in time where the state did seek clarification of the court's order, right?
Yes,
And the court clarified it.
yes.
Thank you, Your Honor. I have no further questions.
Thank you. Mr. McBride.
Mr. Gray, do you believe that the presumption of innocence means that an attorney can never respond to prejudicial media?
No,
Did you intend to violate the court's order in this case?
no,
Do you believe you violated the court's order in this case?
no,
Did you take actions to avoid violating the court's order in this case,
yes.
such as you are familiar with the court's order?
I'm familiar with it, yes.
You're familiar with Rule 3.6, correct?
Yes,
And you expected Mr. Ballard to limit the statements to the media to those necessary to address the issues prejudicing your client.
yes,
Now, you've been present for the testimony about the, what I'll call kind of a media frenzy about this claim that the bullet didn't match the gun,
yes,
right? As that media came out, did you meet with Mr. Ballard and discuss what to do about it?
Yes, my recollection is a little bit different from Mr. Ballard's recollection of it. What I recall is he came to me, told me that he was getting several media requests for that, and whether or not we should or could respond to those inquiries. So I spoke with him about it. I know I spoke with Chad. We discussed Rule 3.6, specifically subsection C, that indicates that we can, where we believe that there's a substantial likelihood of material prejudice. And so I ultimately told Mr. Ballard that yes, he could respond to inquiries regarding that. And specifically our concerns. The media had reported, based on the motion to stay the preliminary hearing, it indicated only that it didn't indicate on the bullet, the defendant's motion, and didn't say anything about the actual report that said it didn't indicate or exclude that it came from Tyler Robinson's rifle and was therefore inconclusive. So based on our reading of that, we could correct that. This wasn't a matter of, deciding whether it's exculpatory or inculpatory. This was a matter of correcting what that ATF report actually said.
And particularly to your client's right of a fair trial, right?
That's right.
Okay. You said you're aware of the rule. You're aware of the court's order. Were you aware of any cases dealing with media and attorneys correcting misrepresentations by the media?
I was.
For example, do you have?
The Kouri Richins case, actually, where lead counsel in this case was also lead counsel in the Kouri Richins case. I was aware of their interview that they conducted before trial to correct what they perceived as misinformation.
Okay, so let me get that clear. Lead counsel in this case, Kathy Nestor, is that right?
Yes.
She went to the media in the Kouri Richins case, is that right?
Yes.
And with the purpose of correcting what she perceived to be misinformation in that case?
Yes, from the media.
And did she make any comment about prosecution's duty to correct misinformation in that interview?
There were the entire team there, or at least 3 members of that team in that report.
Of the defense team?
Of the defense team.
Okay.
And between her and her other co-counsel, they indicated that they had hoped, I believe Ms. Nestor actually stated that she had hoped that the prosecutor would come forward to correct that misinformation, but because they didn't, they came forward.
And were you aware of that case and that interview on March 31st of this year?
Yes, I was.
When did you become aware of that interview by Ms. Nestor?
Back in October of 2025.
Okay.
Yeah, a lot of y'all brought that one up. Wasn't that Kathy Nestor's reason?
Have there been other
the Kouri Richins interview? He is so pleased with himself. I mean, that's good.
Have there been other circumstances in this case where
like
you have declined and your office has declined to speak with the media?
Yes.
And if you declined in other circumstances, why did you not decline in this circumstance?
Because it was media reports where they were saying that they were misrepresenting the actual report that's in the record. And, that it did not match. That's not what the report said. Again, I'm not getting into whether it's exculpatory or inculpatory. What the report said was that the testing did not identify or exclude the bullet fragment as coming from the rifle, and therefore was inconclusive. And so we got those reports. And in those other circumstances, we had persons concerned about what they perceived as misinformation. And my conclusion was, we're not going to go out there and talk about those things because quite frankly, I didn't know whether or not how the defense would use that information. And so I decided, no, we're not going to comment on that kind of stuff.
Okay, so there have been other circumstances where you said, nope, we're not going to talk to the media about X, Y, and Z.
That's right.
But in this case, you made an analysis and said, yes, we're going to talk to the media in this case because of how important the issue is.
Yes.
Nothing else.
All right.
That's plenty. That's
Novak.
plenty.
Mr. Gray, I don't know anything about the Kouri Richins case, so let me just ask you a couple questions. You had watched some sort of a media interview that you say that Ms. Richins' counsel conducted before trial.
Yes.
And did you think that was appropriate under the rules?
I think they went beyond what they could do, but I think it is appropriate under Rule 3.6 under the right circumstances like this case.
So it really depends what it is you say that puts you close to the line or over the line set by Rule 3.6 in the court.
Sure. I mean, you have to be careful in what you say. I mean, we do our very best to be careful.
And was your office prosecuting that case?
No.
Okay. Did the county attorney file anything with the court concerning those public statements to your knowledge?
I'm not aware of that. I talked with her. She was the one that advised me of that, and that's why I became aware of it. But I don't know whether or not they decided to or not. There are many reasons why you may or may not file something. I know that she wasn't happy with it.
When you say she, you're referring to the county attorney?
Burt Olson from Summit County.
I see. And you don't know if Summit County sought any judicial review of those extrajudicial statements?
I do not know.
Understood. Thank you. I don't have any further questions.
Thank you. Anything further for this witness?
No.
Mr. Gray, thank you.
It won't
All
be
right.
the judge's ruling, but it
Mr.
should
Novak.
be.
No further
What's good for the goose is good for the gander.
To the state.
No witnesses, Your Honor.
All right. We can proceed to, I'll defer to the parties. Mr. Novak, you have about 8 minutes for argument. The state has a little bit more than that. So as the parties wish to proceed.
I'm prepared to do it now if the court wants to continue.
Yes, my intent is we'll do that. Then that will conclude this particular as it relates to the OSC, and then we'll turn to the motion in Limine as it relates to hearsay, giving the parties time to argue that as the court has reviewed in detail the motions, which were detailed, and the court appreciates that. So we'll have a brief oral argument on that, and then we'll go to the last issue that Mr. Novak brought up and address that as well. All right, turning to Mr. Novak.
Thank you, Your Honor. And I want to be careful to be clear, at least from our perspective, that there are two issues here. One is whether the evidence supports a finding of violation of the court order by Mr. Ballard and or Mr. Gray. And then the question, if the court does make that finding, is what are the consequences? So
Why
I'm
don't
going to
you get to the
really deal with
violation
the
first?
first part first and the second part second, unless the court wants to bifurcate it and issue its findings on whether or not there's been a violation, in which case, if the court finds that there has been a violation of the court order, then we can address the remedies.
We can address that today. Thank you. In regards to your argument and what you are advocating for.
All right, so the court would like to hear all of it at once. That's why I'm here. Okay. So first of all,
you're not gonna get another
the
bite.
court's order concluding that there was a preliminary finding that we had made a preliminary showing identifies 3 elements to the contempt. And Mr. Ballard essentially admitted to the first 2 elements. He was aware of the orders, and there was no reason why he was unable to comply with them. So the third element is whether the order was violated. Now, I acknowledge that the court's order uses the word intentional, but I would ask the court to look again at our pleadings concerning whether intentionality is an element of the offense. And the reason why that's important is because many courts, as I cited in the brief, so I'm not going to cite all those cases again, say that where the order is in the nature of an injunction, the court doesn't need to make a finding of intent. Every order is different. This is an order enjoining conduct. And so if somebody violates, knows of, and has the ability to comply with an order enjoining conduct, and the order is violated, there is no need to show intent. However, what I will argue to the court is whether or not the court is going to add that element of intentionality. I think the evidence is clear that the violation was intentional, or it was so reckless, and I will use the legal phrase extreme recklessness, that there's a very fair inference of intentionality. And I don't say this lightly, and this is one of those situations where lawyers and judicial officers sometimes cringe, but sometimes
We're cringing.
the cover-up is worse than the original conduct. I know we've all heard that before, and we all know what that means.
What does that have to do with this?
But I find no credibility in Mr. Ballard's sworn testimony that he only intended to communicate with the media generally about bullet fragment analysis.
Well, that's the
He
words
used
we
phrases
gave him.
like this bullet. He's responding to
He
misconceptions
didn't say
in the
this
media
bullet. It was the bullet.
about what the defense said in its filing. He's talking about the bullet fragment analysis in this case. And
It applies.
have
to the
trouble
analysis in this
accepting
case.
Mr. Ballard's explanation that he really never said anything about the bullet fragment analysis in this case. Especially, I mean, the most clear example, frankly, is his statement in Exhibit 7, which is his statement on Fox and Friends. Because he talks about this bullet, the bullet, the bullet. He's
It's
not
the bullet,
talking
it's not
in
this bullet.
general terms. He's not talking in generic terms. He's not a ballistics
Gray is
expert,
pissed.
although in some of these exhibits
Look
you
at
see
him.
that
He knows he
the
didn't say
journalists
this bullet.
interviewed ballistics experts. Mr. Ballard is trying to influence public perception about examinations in this case. And I think to say, oh, I'm not talking about this
Well, that's
case,
right,
I'm only
because
talking
we're
about
correcting
ballistics
misinformation.
generally, is
Should we not have a
belied by
correct perception
the
of the test?
context in which the statements were made, the motive that Mr. Ballard and Mr. Gray admit they had in engaging in extrajudicial statements, and the content of those statements. Mr. Ballard also acknowledges that he made statements about future examinations and his expectations about what future FBI and ATF reports would say in this case. So even if Mr. Ballard
Look how
has
love
this,
lasts through hardship.
what he thinks is a safe harbor, oh, I was just talking about bullet fragment
only when
analysis
it's been
generally,
tested
he
that
is
you know
then
it's
saying,
really
oh,
love.
and we'll have some more reports in this case soon that will clarify this. So he's actually talking about what he believes forensic experts will do and say in the future,
That was the key.
which
I
I
don't know
think
why you didn't focus
not
on
only
that.
violates the rule in and of itself, but shows the overall problem with his excuse. The reason why we asked Mr. Ballard and Mr. Gray if you can turn this around and say, since there's been all of this negative media coverage, can I go on a public relations tour and state, in my opinion, Mr. Robinson is innocent extrajudicially, beyond the fact that he has a constitutional right to
example.
the presumption of innocence, which the prosecution has an obligation to embrace and uphold, is because if I can do that in response to media coverage, then this court's order and the rule are completely swallowed up. In other words, in a case where there is media coverage, which is not the result of interviews by the defense, I can go do those things, then this court's order has very, very little meaning. And Rule 3.6 has very little meaning. And that just can't be the way it works. So at a minimum, their conduct was extremely reckless. And that in the law is the same as intent. But again, I don't believe that that's what this court has to make a finding in order to confirm the court's initial preliminary finding of a violation of this court's rules. It's interesting, Your Honor, that the state's attorneys have already decided that the recent media coverage about the bullet fragment analysis has prejudiced their case, because they've been saying in this courtroom and in pleadings that we can't prove that any of the media coverage in this case has prejudiced Mr. Robinson.
No, that's a good
They've been
point.
saying, pick a better jury, have a better questionnaire. Maybe there's a venue issue, more peremptory challenges,
That is a very good point.
individualized voir dire. And this court has said the same thing.
That's a good
But
point.
when it suits them, they say they've already determined that their case is prejudiced. And so they need to correct the perception in the jury pool so that they can have a right to a fair trial. And it's offensive to me, but it's deeply ironic that when it suits the state, we can't prove prejudice. And when it suits the state, they've already concluded that there's prejudice, without even taking a moment to say to this court, we're very concerned about this. We weren't concerned before about all of the negative media coverage about Mr. Robinson and his life, but now we're concerned about the media coverage concerning this piece. And so, Judge, what are we going to do about this? I am confident that if the court received an inquiry from counsel that said, there's an urgent matter here, we'd really like to have a conversation with the court about what is acceptable under this court's order, this court would have convened a hearing. This court convened, as I recall, a conference call on like 6 hours notice back in September when the court wanted to manage this case quickly because things were happening. And the court's staff got everybody on the phone, and the court made some decisions, and then those decisions were docketed. There's nothing that stopped the state from asking this court to either clarify its order or approve some press release, even if it was over the defense's objection, that would be consistent with Rule 0.6 and the court's orders and Rule 3.8. So now in my remaining time, I'm going to go to the remedies. I think that the number one remedy in this case, Your Honor, is for this court to preclude the state from seeking the death penalty against Mr. Robinson.
Of course. There it
The
is.
court said at an earlier time that if the court found there were violations of its orders, that it could order somebody to do continuing
Well, that's not
education,
gonna
it could
happen.
impose fines, it could do all kinds of things under the civil remedies. That is true. But what we are talking about is the state, without any guidance from this court, going out and trying to influence the public perception of this case, so that when people come into this courtroom, and they may be jurors in this case, they have been exposed to the state's extrajudicial statements about what the evidence will or will not show before the first witness is ever sworn to testify in the trial, before any exhibits are ever received into evidence. And as Mr. Ballard said, the media spin will never change. The media will do whatever the media wants to do. I'm going to return to that as well. What was going on here was an
How much time
attempt
do you
to
have left?
influence the jury pool. Because that's the only thing that cures the prejudice, is correcting what the state is concerned are the perceptions of potential jurors. And so that is the remedy that is commensurate with the extreme recklessness and the motives of the state. We asked this court to compel some discovery, but Mr. Ballard was quite frank. We need to change public perception of what the evidence is or might be before we ever pick a jury. There are other lesser remedies, but we've already been through proceedings concerning how to remedy the pretrial publicity, the electronic publication of these proceedings. And the court has already said in other contexts, we're going to have a more thorough jury questionnaire. We're going to have more voir dire. We're going to have individualized voir dire. We're going to have venue issues. I'm not saying that the court has promised to change a venue. That's not what I'm saying. But the court this morning said there may be an appropriate venue issue here. So there's no additional consequence for the state's misconduct here. We're already at the point where we've got to pick we have to much more carefully pick a jury because of what has happened in this case over the last 9 months. And now the state has compounded it horribly. We can't wait until we start picking the jury to find out what harm has been caused. So we think that's the first remedy. The others are the remedies that the court has already said are probably necessary in this case. I don't want to be flippant, but I don't really care whether Mr. Ballard attends a continuing education program or not. All I care about is my client's constitutional rights. And referring Mr. Ballard or Mr. Gray to the state bar, as Mr. McBride referenced, I'm not saying he suggested that, at the argument on the motion, doesn't protect Mr. Robinson's constitutional rights. Mr. Levitt's sanctions weren't affirmed by the Supreme Court until years after that case ended. That doesn't protect Mr. Robinson's rights in this case. I just want to say one other thing, Your Honor. One of the reasons why extrajudicial statements are strictly controlled is because lawyers can't control the media. We can send them an email, we can make statements on the phone, we can sit for a 15-minute interview. Journalists will cut and paste and shape articles to fit their purposes. And that's why it's extremely reckless to do what Mr. Ballard and Mr. Gray did. If they had put out a press release, especially one approved by this court, that said the state stands by the allegations and the information, evidence will be presented at trial, Mr. Robinson has the right to the presumption of innocence until the trial has concluded, we wouldn't have this problem at all, because the media, all they could do is cut and paste pieces of a press release that would be totally in conformity with this court's order and rules 3.6 and 3.8. And so they let Fox and TMZ and other media entities cut and paste whatever was important to them. But that doesn't relieve them of the responsibility, and it also does not undermine what I think this court unfortunately needs to find to be true, which is that Mr. Ballard's attempt to say he wasn't talking about the ballistic testing in this case is simply lacking in credibility. Thank you, Your Honor.
And counsel, I do have a question for you. So hypothetically, if the court finds a violation, do the interests of justice require proportionate sanction?
Yes.
Yes. And I think in light of the remedies that this court has already said are going to be necessary in this case, the sanction that I've suggested is proportionate, and it's in the interest of justice.
Thank you, Mr. Novak.
Thank you, Your Honor.
Turning to the state.
Well, you're not going to get that. He's not going to nuke the death penalty because Mr. Ballard told the press what inconclusive means.
And I'll start with defense counsel's assertion about credibility of Mr. Ballard. I view the evidence completely different. It seems to me that Mr. Ballard was extremely credible. His statements that were reported through several media entities all said the same thing, which were, I'm not going to talk about specifics of this case, but in general, when you have an inconclusive report, it means this. Did he say the bullet? Yeah, because he was referring to the bullet reference in the previous sentence.
And
that was consistent throughout all of the media that we looked at. And the Fox News story, when you see that, you can tell it cut off the last word when it begins his next sentence. That's how quickly it starts. And so and that's consistent. His testimony that he was referring to a general inconclusive result is consistent throughout all media entities here. But the reality is it doesn't matter anyway, because Rule 3.6b says attorneys can reference matters in the public record. And this report was in fact in the public record by this time because defense counsel attached it to one of their pleadings. The court ordered that it would be public, and it was public. What Mr. Ballard's efforts at being general rather than specific show is a measured and thoughtful effort to correct the unfair prejudice that faced his client, not an effort to prejudice defense or the defendant. That shows a measured and thoughtful, deliberate approach, not an intent to violate the court's order. The statement about what future FBI reports would say, that's misleading. That is not what the testimony was. Mr. Ballard testified, I talked about what the future FBI and ATF reports may say, and that was in reference to the motion to continue the preliminary hearing that talked about the lack of discovery of underlying data supporting the scientific reports.
That's the clarity I needed.
That's what the testimony was.
That's what I was
Despite
concerned
what
about.
Mr. Novak may want to say here, we're limited to what the testimony is here, and that's what the testimony was. The hypothetical, where defense says, well, taking the state's position at face value, then defense counsel could get up and say, I believe my client's innocent. That's comparing two completely different things. Rule 3.6, the comment to Rule 3.6 says, attorneys should not be saying they believe someone is guilty or innocent, right? That's not what Mr. Ballard said. He didn't come up and say, I believe defendant is guilty. That's
right,
not what he
did
said.
Did lean a little into it.
And with regard to the prejudice to the case, right?
But it's gray area.
Mr. Novak talked about, well, it's not consistent that when it's the defendant being prejudiced, then we can handle all this through voir dire and expanded veneer and all those things. But when it's the state being prejudiced, you can't. You have to actually correct the record. Well, there's a difference here. Well, the first question is, are they being prejudiced unduly? Under 3.6, that's the language. Undue prejudice. Well, is it undue prejudice? When the evidence, and we all know this, everyone in this courtroom knows that media was misrepresenting the evidence here.
That's true.
That's what
Everyone
makes
does
the
know that.
prejudice undue.
It's the Daily Mail.
Right.
What else is new?
If there are
The day ending in Y.
if there's a false narrative that's being pushed, that's undue prejudice. Under 3.6, that's when you step in and correct it. Now, that's why the comment to 3.5 or 3.6, comment 5 to Rule 3.6 is helpful, is because there are certain things that can create undue prejudice, such as an attorney's opinion on guilt. So if Mr. Gray had stood up at the initial press conference in this case and said, trust me, I am your elected county attorney, I believe the defendant is guilty. To correct that undue prejudice, yes, defense counsel could have got up and said, members of the public, it doesn't matter what the county attorney said, what the county attorney believes. What matters is the presumption of innocence, and we've got to wait for a jury and all of those things, right? But that would be undue prejudice, right? Not the fact that he's been charged with a crime, not that there's an affidavit of probable cause and the contents of that, not that there's pleadings in the case and the contents of those pleadings. And that brings me to the point of, this is why it's so important that attorneys satisfy the duty of candor to the court, is because when an attorney files something with the court, we all know an attorney has a duty to this court to have candor and to be honest in what they represent. Why? Because then when the media reports on it, there's some assurance that there's some validity to those statements. That's why some of this, what we're dealing with, is so upsetting, is because it generates from a pleading that claims that frankly was misleading, I think. And obviously the media all thought it meant what they said it meant. All right, with that, let me turn to, I think, what really is the crux of the issue here. You got to start with the standard. The standard of proof is clear and convincing evidence.
Oof.
In order to find Mr. Ballard or Mr. Gray in contempt, the court has to find by clear and convincing evidence that Jeff Gray and or Chris Ballard intentionally violated the court order. Now, defense counsel has taken issue with that intentionally language.
Not going to meet the standard.
The issue they take generally comes from a case and a line of cases that predates the Von Hackey v. Thomas case, which is a Utah Supreme Court 1988 case, which promulgates the intentional standard. That same standard was reiterated in Sumner v. Sumner, a 2012 Utah Appellate Court case. These are cited in the state's brief, I should mention, as well as the Kohler v. Allen 2020 Utah Appellate Court case. That's the standard. Proof by clear and convincing evidence that these attorneys intentionally violated your order. In this circumstance, the defense can't prove, and I don't think the court can find, the actus reus, much less the mens rea, which is much more difficult to prove. When you look at the actus reus, these statements did not violate the order, which explicitly refers to Rule 3.6. That last line of the order says, right, This order does not preclude the attorneys from speaking to the media. See Rule 3.6b, right? 3.6b allows attorneys to talk about material in the public record. And 3.6c, which allows attorney to correct extrajudicial statements that prejudice their client's rights. It did not violate the rule because the reference to the test, the report from the ATF, was a matter of public record, docket 284, which is specifically allowed by the rule. But Mr. Ballard, in demonstrating his measured response, took an additional step to avoid potentially prejudicing the defendant's rights. Rather than saying, I'm going to read to you the report, media, that talks about this case, the bullet in this case, and the results. I'm going to read to you the report that says not only the part that the defense included in their pleading, that they could not tie the bullet, that they could not identify that bullet as having been fired from that gun, but they could not exclude it. And not only that, but they could tell this is a 30 caliber class round. Mr. Ballard did not do that. He could have under 3.6b, but he didn't. Why didn't he? Because he was taking a measured and deliberate approach to avoid violating this court's order, to avoid violating his ethical duties. Under 3.6c, he was correcting an unduly prejudicial media to protect his client's right. Why is it unduly prejudicial? Because it was false, right? This narrative that the bullet didn't match was false. Everybody in this courtroom knows that that narrative was false, and he was correcting that narrative. It's hard for me to think of a circumstance where 3.6c would be more directly at issue. We have here perhaps the most high-profile murder case in the world. Certainly one of the most high-profile murder cases in Utah's history.
%1,000,000% not
that has
going to
generated
happen.
extraordinary attention from the media and from the public.
He doesn't
We
have the
have
power
here,
to do that.
not only that, we have here reports that are that are misrepresenting the evidence and claiming that it completely exonerates the defendant. And those reports are false, right? Hard to see a circumstance where 3.6c would not be more at issue. So, Your Honor, I don't think the court can even find the actus reus here. I don't think the court can find that the statements that were made by Mr. Ballard violated 3.6b or 3.6c and therefore violated the court's order, much less that Mr. Ballard and Mr. Gray intended to violate the court's order. When it comes to the mens rea, the intent, you can see by the statements, by the testimony, that both Mr. Ballard and Mr. Gray were deliberate. They talked about Rule 3.6. They were aware of 3.6, 3.6c. They were aware of other cases where corrections of the record had been brought up, including by lead defense counsel here, where she corrected the public statements and said the prosecutor should too. And they made measured statements, Mr. Ballard made measured statements to the media that were deliberate and did not go beyond what the rule allowed. He did not say, I believe he's guilty. He did not say, like Mr. Levitt did, I believe my witness. We believe the witness. He did not refer to evidence that would not be admissible. He referred to evidence that was in the public record. Finally, Your Honor, I think in conclusion, the defense has not shown and the court cannot find proof by clear and convincing evidence that Jeff Gray or Chris Ballard intentionally violated the court order or violated the court order at all. As I mentioned before, we've taken this matter seriously. At the very outset, you can see that the state, the day the defendant was arrested, was sending out letters to the media, to police chiefs and the law enforcement agencies saying, be aware of these rules. If you talk to the media, you have to abide by these rules. We suggest you don't talk to the media. If you have questions, talk to us. You can see that we've taken this very seriously from the outset. We've taken it very seriously up until this date. We have a duty to justice and to our client to make sure that our client gets a fair trial and that the truth is out there. And this, of course, this issue has brought the issue front and center to us, and we've discussed it, and we've discussed how we can be absolutely certain that we do not cross the line. We don't want to cross the line. We want to stay as far away from that as possible. We believe we want the state, we want Mr. Kirk, we want his family, we want everyone, including the defendant, to receive a fair trial. We don't want to do this again. We want to do this right the first time. We believe we've done right this far, and we will exercise extreme care to continue to do right here, even if that means revising some of our protocols in interacting with the media.
Thank you, Mr. McBride. I do have one question for you. With reference to the final page of Exhibit 3 and in the context of correcting the record and evaluating undue prejudice, how does the state contend that Mr. Ballard's statement, and I'm quoting, "He is presumed innocent. The ultimate decision will be up to the jury. We believe we will be able to overcome his presumption of innocence."
Thank you. Yes, first off, we don't know the exact order in which the statement was received. But I think there's two things that are important here. One is the reference to "he is presumed innocence," right? That shows that Mr. Ballard was intentional about making that clear, right? The jury will find guilt. That last statement, "we believe we will be able to overcome the presumption of innocence." This is a reaffirmation of the state's certification under Rule 11 that we have the evidence to proceed with the case. In good faith, we believe we have the evidence to proceed with the case. Every attorney that files a pleading in this courtroom certifies that they believe the matters contained in that pleading are supported by evidence. And that's what this is. It's a recertification. We believe we have the evidence to prove this case. All of these media reports do not undermine that good faith certification that we made when we filed the case. And I think this is where it's helpful to look at. I have this here. We cited a case, Kansas, State v. Wright, 583 Pacific 3rd, 174, where the prosecutor in that case in jury selection. So this is a much more direct, this is right to the jury pool who's going to try the case, right? In that case, the prosecutor says to them, let's see if I can find this quote.
Oops. Indeed, I will.
Oh, I've got the wrong pleading up.
Taking the notes, I will give you the recap.
I had it on the page. Thank you for asking that question. I meant to cover this. In State v. Wright, 583 Pacific 3rd, 174 on 194, this is a Kansas Supreme Court case from 2026. The county attorney speaking to the veneer, the jury panel for jury selection, says this. So as the county attorney, my job is to prosecute cases that are brought to my office that I feel we can prove beyond a reasonable doubt. Then he continued, that is the burden that the state willingly accepts when it filed charges and brings cases forward. So the state understands this burden and intends to prove that through the course of evidence this week. And the Supreme Court ruled as follows. Rather than an improper personal opinion on Wright's guilt, the prosecutor's comment here simply explained the prosecutor's role in the proceedings and reiterated the state's burden of proving guilt beyond a reasonable doubt. A prosecutor in a criminal case cannot ethically prosecute a charge that the prosecutor knows is unsupported by the evidence. That's what was happening here, Your Honor, is saying Mr. Ballard testified. This answer was in response to the question, do you still have a case, right? Does your case fall apart here with the evidence? And his opinion was not, I believe he's guilty. It was an opinion directly tied to the evidence. We believe we have the evidence to prove this case. And it's nothing more than a certification that all attorneys make when they make filings and that the county attorney made when filing the information in this case. It's much less prejudicial than anything the attorney said in State v. Wright, because it's directed to the media rather than the jury veneer. And it's not prejudicial anyway. I don't think anyone would be surprised to learn that the prosecutors in this case believe they're going to be able to prove it. In fact, I think if the public thought we were prosecuting cases we did not believe we could prove, that would be frankly shocking, because it wouldn't make any sense. I think everybody knows that we believe we can prove this case.
No,
and we
sometimes you
intend
just
to do
talk
so
yourselves into believing
through
what
the
you can prove,
evidence,
but
not based on personal opinions that are endowed on us through our authority as prosecutors, which seems to be what Levitt claimed in that case.
Thank you, Mr. McBride. All right.
Can I beg the court's indulgence for 90 seconds?
I will give you 90 seconds, Mr. Novak.
90
Your
seconds,
Honor. I
watch it
think-
turn into 8 minutes.
We all want the court to be clear on the law with respect to the third element and intentionality. And Mr. McBride is not correct when he says that all of the cases that we cite for the proposition that violation of an order enjoining conduct requires proof of intent predate Von Hake. That is not true. And so what I want to just remind the court is that in 2019, the United States Supreme Court said, and this is at the bottom of page 10 of our reply, the United States Supreme Court said, quote, "We have explained before that a party's subjective belief that she was complying with an order ordinarily will not insulate her from civil contempt if that belief was objectively unreasonable." That's Taggart v. Lorenzen, a 2019 Supreme Court case. And in the same year that Von Hake was published, the United States District Court for the District of Utah said that civil contempt for violation of a court order need not be willful. And now I'm going to quote from the District of Utah opinion. "In order for a party to be
But are
cited
these
for
under a
civil
federal
contempt,
rule?
a court must find that the party violated a specific and definite court order and that the party had knowledge of the order sufficient to put him on notice of the prescribed conduct. Nevertheless, the disobedience in a civil contempt need not be willful because the purpose of civil contempt sanctions is remedial." That's In re Skinner, a 1988 published decision in Bankruptcy Reports, District of Utah.
Thank you, Mr.
A
Novak.
bankruptcy case.
And I have nothing further unless the
I
court
feel like
wanted
there's probably a different
to
legal
inquire of
rule
me
for that.
concerning anything Mr. McBride said.
No, thank you.
Thank you.
All right, we're switching gears, going to the motion in limine to exclude hearsay statements as mentioned in the briefing. Again, I will note that the court has examined those briefings in detail, and so the court wishes for limited argument as the briefing provides a lot of guidance from both sides on the parties' positions.
You can
And
just
so
say we
if-
all
if
know
the
it's
parties
pro
would like to
forma.
take up to 15 minutes to argue that, you certainly can, and then we'll go to the final issue that Mr. Novak brought up in the beginning. And as this is defense's motion, we'll turn to defense. Mr. Burt.
Mr. Burt, Jeff got his wish. Mr. Burt.
Morning, Your Honor.
Good morning. Well, afternoon now.
Afternoon, I guess. Judge, as the court knows, and as you've just noted, there's been extensive briefing here. I'm not going to get into all the technical arguments, and there are many here. But the briefing outlines 6 different bases for the court to find here that the use of hearsay evidence in this particular preliminary hearing in this death penalty case is unconstitutional under the federal constitution. State constitution has separate rules, as we
Indeed,
outlined
and
in
they
the brief,
explicitly
and I know
say
the
the
court's
hearsay is
familiar with
okay.
those. But the constitutional issues raised under the federal constitution are unique. For the most part, they have not been addressed by any Utah court, with one exception, and that's the confrontation clause subjection that is addressed in Timmerman. But as to our other arguments, procedural due process, equal protection, the Sixth Amendment right to counsel, those issues have not been addressed. And there's, of course, one issue, separation of powers, that's a state law issue. That has also not been addressed by any Utah court. But I wanted to take just a few minutes for the court, if I could, to outline why this motion is important in this particular case. I don't think that's really outlined in the motion, but I think it's important for the court to consider. And I know the court has not reviewed the exhibits that have been submitted to the defense from the prosecution in terms of what they're going to present at the preliminary hearing. But I'll represent to the court that for the most part, the state, and I'm sure they'll correct me if I'm wrong on this, intends to rely almost exclusively on hearsay evidence at this preliminary hearing to make out the elements of the charges and allegations, and especially the death penalty eligible allegations against Mr. Robinson. And probably most problematic from our standpoint is that the central witness who's going to be presented against Mr. Robinson is a witness who the prosecution and the federal government have given promises of immunity to. And in lieu of putting that witness on the stand and subjecting him to cross-examination, they met with this witness outside the presence of the defense, asked a series of leading questions that the witness was asked to agree to, videotaped it, and the state proposes to introduce that into evidence. In addition, a prominent feature of the evidence at the prelim will be a number of forensic reports by federal and possibly some state law enforcement forensic examination examiners. And those reports, for the most part, are simply conclusory opinions about certain findings that were made. There's no indication on the face of the report as to the methodology that was used or the reliability of those methods. The reports are simply going to present the court with conclusions. And then the state is going to rely on Section 1102 of the Rules of Evidence to urge this court that those statements by law are reliable evidence. And that's the gist of the problem here, because 1102 in combination with Article 1, Section 12 essentially removes what was supposed to be this court's function at the preliminary hearing, which is to assess the reliability and the credibility of the evidence. And the intent of Article 1, Section 12, if the court goes back into the legislative history, was specifically to remove the court's discretion to decide whether certain evidence was reliable. And that's where the separation of power issue comes into play. Now, that we say violates the federal constitution in a number of respects, and also the state separation of powers provision. But I wanted to point out to the court that the state's position on this issue is really contrary to the position they've taken on almost every other procedural issue that has been raised in this case. And the prime example is the one just presented to the court in connection with the OSC. One of the things that Mr. McBride said was, we have a duty to make sure the truth gets out there. And similarly, the defense has a duty to make sure the truth gets out there. And how they do that in this system, traditionally and historically, has been through the use of cross-examination, confronting adverse witnesses. Another example of the inconsistency that's being urged upon the court in the state's opposition to this motion. The court will recall the state's position on our motion to exclude cameras from the courtroom. And Mr. Grunander began his argument to the court with this statement: Your Honor, mischief lurks in the dark or in secret, or that's at least how many people view the workings of government, even the courts. And while this is primarily the media's fight here, we do not represent the media. We strongly support open and transparent proceedings in this case so that the public will trust the process here. There are conspiracy theories that abound. There are questions being raised, and the best antidote
Conspiracy theories
for
again.
falsehood is the truth, is accuracy, is the actual real proceedings. And that's at page 214 of the hearing on April 14th. And similarly here, Your Honor, the defense's right to cross-examine and confront adverse witnesses, immunized witnesses in this case. We're going to provide the bulk of the evidence against Mr. Robinson. The purpose of our doing so is to get at the truth, to lead to transparency. And one of the articles that the state has cited to the court as indicative of an analysis that's relevant to this issue is an article by a former district attorney who, this is the Bowden article that the state cites. And one of the things that Mr. Bowden, former prosecutor, says in his article that the state cites is he's addressing the issue of why it's important to have adversary proceedings at pretrial proceedings such as preliminary hearings. And he says, this is at page 1148 of his article, a system without adjudication lacks transparency. The public normally has no way of learning why prosecutors make the offers they do or why certain cases reach certain outcomes. The opacity prevents the public from understanding how criminal courts function. It frustrates journalists and scholars who wish to study criminal courts, and it distorts democratic feedback as voters are left with little idea of how these institutions work. And the court, in its rulings on public access, and even this morning, you have also emphasized transparency as a goal of the criminal justice system. So this motion asks the court, how can we further transparency by relying exclusively, or almost exclusively in this case, on hearsay evidence that implicates Mr. Robinson in a death penalty case? And we say to the court that if the court looks carefully at the cases we've cited on the federal constitutionality of this practice, the court should determine that it's simply unfair to proceed on the basis of hearsay in a case where Mr. Robinson's life is at stake. The federal constitution requires that people who are facing parole revocations have the right to confront and cross-examine witnesses. The U.S. Supreme Court has determined that people facing probation violations have a right to confront and cross-examine witnesses. The state Supreme Court has determined that people at suppression hearings have the right to confront and cross-examine witnesses. The state Supreme Court has determined that people who face sentencing have a right to confront and cross-examine witnesses. And we say that due process, equal protection, and the other provisions we cite all point in the same direction, which is that the court should not allow the use of hearsay to make the determination in this case that Mr. Robinson should or should not be bound over for trial. And I'll be glad to answer any questions the court may have. I know the briefing's fairly extensive, so if the court does have questions, I'm prepared to address them.
I do. I have one question. I'll be asking both sides this question.
Sure.
In the court previously indicated, and you noted it, that it wasn't reviewing the exhibits ahead of the preliminary hearing in order to go in with an open mind and weigh it accordingly. Is it your request that the court review the proposed state's exhibits that relate to this motion prior to the preliminary hearing?
Your Honor, I think it would be helpful to the court to do that because I think the court would then have a better context of just how central hearsay is going to play in this case. And also, especially in regard to the crucial witness, the immunized witness, how the state structured that hearsay. And I think if the court did that, it would clearly see the importance of cross-examination and confrontation. So I would have no objection to, and I would urge the court to do that.
And do you have those exhibits, those exhibit numbers? And if you need time to confer with your team as I go to the other side, I don't expect you to just come off with those numbers off the top of your head.
Sure. I know the court, the state provided those to the court. I think there was some email traffic about how the court then gave them back to the clerk, but I think they're still in the clerk's possession. The state will correct me if I'm wrong on that.
Right.
But they're the state's exhibits. So
No, you're right. I know, but I'm wondering if there's specific ones that you want to identify that relate directly to your motion that you wish the court to review.
yeah, sure. And if I could have a minute, I'll identify what those exhibit numbers are.
All right, so I'll turn to the state and
Great.
and again, I'm not trying to put you on the spot there. All right, Mr. Ballard.
Thank you, Your Honor. The Utah Supreme Court has already rejected the defendant's argument in State versus Timmerman.
So let's
This
go
court
home.
can't overrule the Supreme Court.
That's correct.
And I think it's fundamental, or it's important to think about the fundamental reason why the court held in Timmerman
We're done.
that
We
the
can argue
Sixth
it more
Amendment
in
right to
federal court in 10
confrontation does
years.
not apply at preliminary hearings. And it's because of the very, very low burden and low standard that the state has to meet at a preliminary hearing. All we have to show is probable cause. The magistrate at a preliminary hearing isn't making any factual findings. The issue is just whether there is a reasonable probability of that an offense was committed and that the defendant committed it. And in making that decision, as Your Honor well knows, you have to draw all of the inferences in favor of the state. You can't weigh conflicting evidence. You can make only very, very limited credibility determinations. So even if the defense could impeach a witness to some degree through cross-examination, like the fact that this witness has been granted immunity, it doesn't matter at the preliminary hearing because the magistrate's duty bound to ignore those blemishes and draw all reasonable inferences in favor of the state. So even if the state's only witness to a robbery was a convicted forger who wasn't wearing his glasses when he saw the robbery and who had a grudge against the defendant, even if the defense could bring all of that out on cross-examination, it's irrelevant to the probable cause finding because it's such a low burden. That's an extreme example. I don't think the state would ever bring charges in a case like that, but we do have an example that is similar in scope to that, and that's State versus Drozbecki. That I think is how you pronounce the name, Droesbeke. That's 2010 Utah App 275. In that case, you had a child victim of sexual abuse who reported the sexual abuse to law enforcement, reported it during a CJC interview, but then took the stand at the preliminary hearing and recanted those allegations. That there was still sufficient evidence under that situation to bind the defendant over, even though the witness recanted those allegations, because there was a reasonable explanation as to why the witness might have been telling the truth when she reported to the police and during the CJC interview, and why she might have recanted at the preliminary hearing. So that's the standard that the court is applying. And so defense talks about we have to have reliable evidence. And the state absolutely agrees that we have to have reliable evidence, but reliability, the degree of reliability depends upon the circumstances of the proceeding. So is hearsay sufficiently reliable for a conviction beyond a reasonable doubt at trial? Certainly not. But is hearsay reliable
So do
enough
you get
to be able to
use
make this
junk
low
science?
probable cause finding? Yes,
surely
it
a limit.
is. And that's why Timmerman held that the Sixth Amendment right to confrontation does not apply
Oh, well.
at preliminary hearings. And that's why nearly every other state court that has examined this issue has found that the Sixth Amendment right to confrontation does not apply. Timmerman collected those cases as of 2009. You've also got the Ninth Circuit in Peterson versus California, and we've included all of these cases in our brief. In fact, if this court granted the defendant's motion, it would be going where no other court has gone before. This court would be the first court to find that the Sixth Amendment right to confrontation applies at a preliminary hearing. Because Timmerman is clear that the Sixth Amendment right to confrontation doesn't apply at a preliminary hearing, defendants trying to rely on other federal constitutional provisions. But defendants' attempt to do that violates the rules of constitutional construction, legal interpretation, because it would create contradictory constitutional provisions. What defendant is trying to say is, even though the Sixth Amendment right to confrontation, which we know would provide the right to cross-examination and therefore prevent the state from relying on hearsay, even though that right doesn't apply at the preliminary hearing, there is some other constitutional right that could somehow indirectly provide that right. But then we would have two conflicting constitutional provisions. And that's not how we read the Constitution. That's not how we read statutes. We read them to be in harmony with each other, different provisions to be in harmony with each other, and to not render a different provision superfluous. If you could provide the right to confrontation through the Sixth Amendment right to counsel or 14th Amendment right to due process, then what work is the Sixth Amendment right to confrontation doing? It just doesn't make sense to do that. So that's exactly why the Ninth Circuit in Peterson versus California said it's illogical to conclude that the substitute for a grand jury indictment, which is the state preliminary hearing procedure, must contain greater protections than the grand jury provides for itself in the federal system. So if the federal system, the equivalent to the state preliminary hearing is a grand jury proceeding. The grand jury proceeding allows the federal system to determine probable cause to require a defendant to stand trial. The defendant doesn't have a right to be present in those proceedings, doesn't have a right to representation, doesn't have a right to cross-examination, or even to present exculpatory evidence. If that type of a procedure is constitutional, then Utah's preliminary hearing procedure is certainly constitutional. I could go through each of the different constitutional provisions that defendant has relied on. I'll do that very briefly, just summarize the reasons why we don't believe those apply. The Sixth Amendment, even assuming the defendant could rely on some other provision, which we don't believe he can, but the Sixth Amendment right to counsel, it doesn't create additional rights. What it does is it evaluates counsel's performance under the circumstances as they existed at the time. Now, defendant brought up the fact that there is a right to confront witnesses at suppression hearings and at sentencing hearings and at parole revocation hearings. That's a procedural right to cross-examination. It's not a Sixth Amendment right to confrontation. We know from Crawford versus Washington, the Sixth Amendment right means that the state cannot rely on hearsay evidence that a defendant has not had a prior opportunity to cross-examine. And so it's the Sixth Amendment right that prevents the state from relying on hearsay. That's completely different from saying the defendant has the right to be able to cross-examine any witnesses that the state calls. And in fact, at a preliminary hearing, the defendant will have the right to cross-examine. I think we're planning on calling 4 witnesses. Defendant will have a right to cross-examine those witnesses. But a procedural right to cross-examination doesn't mean that the Sixth Amendment right, as interpreted in Crawford, applies and precludes the reliance on hearsay. With respect to due process and the 14th Amendment, again, you have to look at what process is due under the circumstances. And here, again, we've got a very low standard. And the state's process here gives the defendant far more protections than the federal grand jury proceeding does. Both of them determine probable cause as to whether the defendant can go to trial. And so due process doesn't supply some sort of right to confrontation that the Sixth Amendment right doesn't supply. The equal protection argument is interesting because defendant has not shown that he's similarly situated. Well, let me back up. What defendant relies on is Morrissey versus Brewer, which is the case that says defendants have a right to confront and cross-examine witnesses at a parole revocation hearing. But that's a defendant who has been convicted at trial and who is facing reimposition of a criminal sentence to serve out the remainder of his sentence. Defendant here isn't similarly situated to that type of a defendant. So he can't make an equal protection challenge based on that situation. And again, Morrissey versus Brewer does not say that the Sixth Amendment right to confrontation applies. It merely says as a matter of due process, if the state is calling the witness, the defendant has the right to cross-examine them at the proceeding, just like defendant does at this preliminary hearing. As far as the Eighth Amendment goes, the state doesn't have any qualms with the idea that the Eighth Amendment, if we get to the point of whether or not the death penalty is an appropriate penalty here, certainly the Eighth Amendment heightened protections apply there. But we're not at that point, and defendant hasn't cited any case that would extend those Eighth Amendment protections beyond the decision to impose the death penalty, or they do cite Beck versus Alabama, which talks about instructing the jury at the guilt phase. We're not at that point. You can't use the Eighth Amendment and say, well, because this is a death case, there's super due process or there's additional rules that apply above and beyond the procedural and evidentiary rules that apply at every other stage of this proceeding. And then finally, as to separation of powers, I don't see anywhere in the federal Constitution that dictates any particular separation of powers principles to the states. And so it's completely up to the state of Utah to determine how it wants to divide the powers between its various branches of government. And the constitutional provision that's at issue here clearly says that that reliable hearsay can be defined as by statute or by rule. So the Constitution itself is giving the legislature and the courts the ability to define what constitutes reliable hearsay. As far as Your Honor's question about what the state would like you to review as far as the exhibits go, we just renew our request that the court review all of the exhibits in preparation for the preliminary hearing.
Thank you, Mr. Ballard.
Any other questions?
No, thank you.
Okay.
Mr. Burt.
Wasn't me, it's the feed.
Court, I've circled the exhibits we're asking the court to review. They are exhibits 11, 16, 30, 31, 32, 33, and 34. I have a copy for the court with those highlighted if the court would like it.
Burt. Yes, and if you'd like to approach, you may. I appreciate it. All right. Thank you to both parties.
And Judge, could I just briefly respond to
of
the
course.
arguments that were made by the state? Just quickly to run through them. The state emphasizes there's a low burden at the prelim. Granted, it's a low burden, but as the State versus Virgin, VIRGIN case said, low burden does not mean no burden. And the U.S. Supreme Court in Coleman versus Alabama recognized that the burden of proof at the prelim is very low. they nevertheless held that the defendant has a Sixth Amendment right to the effective assistance of counsel. So the fact that it's a low burden does not govern whether procedural rights should be applied. And the Coleman case holds exactly that. The state says that the degree of reliability depends on the nature of the proceedings. That's true. But this is a case where the state of Utah has provided procedural rights at the preliminary hearing, unlike grand jury proceedings. There are rights granted by statute to counsel. There's constitutional right to counsel. There is a right by statute to call defense witnesses, to subpoena witnesses. So the court has to take those procedural indicia into account in determining what other rights might be applicable. And both the U.S. Supreme Court and the Utah Supreme Court has said that the preliminary hearing is a critical stage of the proceedings. The state says that, citing this Ninth Circuit brief opinion, the Peterson case, that it's illogical that the preliminary hearing must have greater protection than grand jury proceedings. It might be illogical, but the reality is that defendants are accorded greater rights in preliminary hearings than at grand jury proceedings. There is no right to counsel at grand jury proceedings. There is no right to subpoena defense witnesses at a grand jury proceeding. And yet in Utah, as elsewhere, defendants do enjoy those rights to certain protections. And once having defined that it's an adversary critical proceeding, the state has an obligation to provide the tools necessary to make that confrontation meaningful. State emphasizes that the defense has a right to call witnesses. Theoretically true, but irrelevant in this case because, as the court will see from reviewing the exhibits, how the state proposes to make its case in this case is exclusively through the use of hearsay. So calling a record custodian or a police officer who has no knowledge about the essential elements of the offense, the defense could cross-examine that person on some chain of custody issues, but it's got nothing to do with the critical issues before the court, which are the essential elements shown by probable cause. And in this case, those elements are going to be satisfied by hearsay alone. The defense says that, or the state says that there's no equal protection problem here because we're not similarly situated to probation or parole violators. In all three of those cases, the interest at stake is whether the defendant should be confined for prolonged periods of time pending the outcome of this hearing. So a parole revocation hearing, especially the preliminary parole revocation hearing, is very, and in fact, it's indistinguishable from a preliminary hearing. The goal is the same, to determine whether there's cause to hold the person, deprive that person of liberty pending further proceedings. So there is an equal protection violation here. The state says that the court can only look to the Sixth Amendment. As I understand the argument, the court cannot look to procedural due process as guaranteed by the 14th Amendment. It cannot look to equal protection. It cannot look to the 8th Amendment. It cannot look to any other doctrines beside the Sixth Amendment to determine confrontation. And we've pointed to the court a long line of cases in both the U.S. Supreme Court and the Utah Supreme Court, which refute that contention. It's clear the court has an obligation to look at whatever constitutional provisions are implicated by the procedure in question.
Well, that's a good
and
point.
The Utah Supreme Court, when it was looking at the subpoena powers case, looked at whether the act violated confrontation rights, equal protection, separation of powers. No one ever suggested that the court had no power to look at various constitutional theories. That theory is not supported by the case law. And then lastly, the state says that we cited no cases to the court saying that the 8th Amendment applies to the preliminary hearing procedure in this case. And that's simply not true. Gregg versus Georgia said that every procedural protection every procedural protection must be observed in a capital case, not at a capital trial, in a capital case. And as charged right now, this is a capital case. And we've also cited to the court the Ford case, Ford versus Wainwright, also along the same lines, saying that in capital proceedings, there's a heightened need for reliability. And then lastly, in our reply, we cited a whole string of state court cases, which hold that at the preliminary hearing, not the trial, the preliminary hearing, the court has an obligation to employ a heightened standard of reliability. Thank you.
Thank you. All right, thank you to the parties. We're turning to the last item, and just cutting to the chase, does the state oppose defendant's request on docket 593?
Can I have just a moment?
And there is also the scheduling of the responses to an EMC request, which we discussed.
Okay, well,
We need
thank you
to
for
deal with that as
reminding
well.
that. Thank you, Mr. Novak.
He's really still pushing on that. Judge says I can't do that. He already said. We don't know yet. Variables are out of my control. Hasn't even been a request for electronic media coverage yet. So this is interesting because, you know, there's a whole issue with the defense having a limited right to subpoena witnesses into a preliminary hearing. That's been part of the problem. That's why the defense, one of the reasons why the defense has this issue with hearsay.
Your Honor,
If you would like to approach the lectrum, Mr. McBride.
So it's possible they wouldn't be able to, but the state may or may
Your
not
Honor,
object.
so this is basically a motion to begin the process of compelling and of getting a subpoena for an out-of-state witness.
This sounds like an
Yes.
objection.
Here's the issue is, we know that from the pleading that the out-of-state witness's attorney has declined to accept service for their client. And this witness has appeared by 1102. We believe that that's appropriate and satisfies probable cause. The rule requires defense counsel to certify that this witness is necessary and material to the probable cause determination. Under State v. Lopez, we don't believe it is. We got this at 8:03 last night. I looked at it for the first time just moments ago. What I'd really like to do is have a couple of days to respond to this. I know time is of the essence, but that's where we're at. So I really don't want to respond right now. If I did, I'd probably submit on what I've said right now.
I see. Thank you. To defense, is there any additional briefing needed in addition to what you've submitted on docket 593? And so I'm just seeing if there is, trying to create an expedited.
Only to respond expeditiously to whatever the state files. So for example, and again, we're both going off the fly. I'm now responding to Mr. McBride's statement. This is not a Lopez situation. The witness is not the victim in this case, as Your Honor knows. So it's not a Lopez situation. It's a question of whether the witness is a material witness. So I think to squarely answer the court's question, we need a very short period of time after the state responds, and if the witness's counsel wants to respond, to file, I guess, what we would call a reply. But we are moving as we can move as quickly as the court requires.
Thank you. To the state, how much time? And again, I realize that this appeared on the horizon.
We can have till Tuesday close of business.
All right, so we're looking at Tuesday, the 16th of June.
Yeah.
All right, close of business. Mr. Novak, with that information.
I think Thursday, the 18th.
All right. I close of business as well.
And actually, in some ways, this may or may not sync. Anyway, go ahead. I'm sorry.
Well, and I know where you're going. Does that sync pretty closely with the last remaining issue? Briefing on the potential. Well, the problem with that is until it's filed, the request for an EMC, that starts the time. My lawyer math doesn't get me to how close we are to the prelim off the fly, but that's the trigger point.
I was an economist before I was a lawyer, so
Okay,
my
that'll
math
allow
might
you.
help. So you just want to hold that there for a second and move on to the other one and then see if they're in sync, or what did you want to
Well, and I'm fine. It sounds like we have a good understanding for the briefing on that particular docket 593. So that's been resolved. Turning to the last issue is in regards to the EMC. When would the 14 days?
So right now, the court's order from May says that media requests need to be filed 14 days before the proceeding. 14 days before the proceeding, which is on July 6th, is June 22nd.
So
Which
a
would
week
not
from Monday.
Pardon?
A week from this coming Monday.
So this is what I was going to propose, and we did meet and confer about this. And my understanding of the state's position is they don't want the court to change its order. Okay, so I understand that's their position, but here's our proposal. We propose that for purposes of the preliminary hearing of July 6th, if it proceeds on that date, that the court adopt the following schedule. Any request for electronic media coverage should be filed next Wednesday.
Okay, the
June
media's not
17th.
here, dude. He's
And
not
we
gonna
will
do
take it
this.
upon ourselves, meaning Mr. Robinson's defense counsel, to personally notify counsel who've entered their appearances on behalf of the media entities
Oh,
of any new deadline that the court sets today. So we will notify them so that the court doesn't have to rush into publishing an amended order unless the court wants to do so. But we can notify them, copy the state, copy the court staff. It's a form, as I understand it. This is the event. This is who's going to be behind the cameras. It's submitted. Okay, it's not a complicated document. So this is my suggestion, is that we will notify the media representatives today that any request for EMC needs to be filed with the court by the 17th, which is Wednesday. Today's Friday. We have an issue which is a small delay between when it's filed and when it's docketed. And so what I'm going to suggest is that 2 court days after it's docketed, we will file, anybody who's opposing it will file a response. And then 2 more court days for anybody who wants to respond to that, and 2 more court days for a reply. The court's already set page limits, which are very modest. I think it's 4 pages and 3 pages. That's fine. The court has said there won't be any oral argument. That's fine. But if my schedule plays out correctly, and we got a docketed EMC request on the 17th, and we filed our response on the 19th, and the state filed any response to our papers on Monday, the 22nd, and then we filed a reply on the 24th, it would be fully briefed by the 24th, which gives us 6 + 6, 12 days before the prelim.
All right. Thank you, Mr. Novak. The state wishes to be heard on this issue.
somebody tell us what 14 days before July 6th is.
Yes, Your Honor, thank you. I think we're not discounting the importance of and the significance of the media issues in this case. But I think it's significant, as Your Honors already noted earlier this morning, that you granted a very generous opportunity to deal with these electronic media requests, that it's far more generous than what the rule requires. It appears to me that what the defense wants is an opportunity to get a ruling from this court on electronic media requests, so that then if it's a ruling that they don't agree with, that then they can seek yet another interlocutory appeal and perhaps file a motion to stay this case. And if you look at the procedure that the rule has already established, the controlling rule 4-401 The rule does not contemplate appellate review of every electronic media coverage order. And that's clear from the fact that the rule only allows 1 day notice for a request for electronic media coverage. And in fact, it says that the court on good cause can grant a request for electronic media coverage. It can shorten the 1 day time. I think it could be, as the hearing commences, if there was good cause. So as the court has already established its schedule, it allows 14 days before the hearing for the request. Under that current schedule, the court could have a ruling on the request by July 2nd, which would be before the hearing. So we don't believe that this procedure, which presumes that electronic media coverage, those requests will be granted, that it needs to be set up so that there can be the potential for appellate review of every one of those orders.
Thank you. All right. Thank you to the parties. I appreciate you conferring with each other and trying to find a solution. I'm going to respectfully decline to adopt what Mr. Novak presented. And here's why. There's nothing that precludes the media from filing today. That request and being ahead of the deadline. And again, that's outside of my purview. It's their choice if they choose to file or if they choose to file one at all. And so the court will rely upon the previously set schedule. Again, if the media files early, that doesn't preclude the parties from filing as soon as they can or they wish to, and the court still having sufficient time to do its duties. And so that's the ruling of the court as it relates to a different schedule as it relates to media requests for coverage, EMC, of the preliminary hearing on July 6th. It goes to the very last issue, which is the court is taking these two issues argued today under advisement. And as this court typically does, I always like to review everything. And I appreciate the quality of the arguments, the quality of the briefing, and what is clear to me, the hard work of both defense and prosecution and the seriousness applied to these important issues. If you wouldn't mind taking a look at your calendars, the court has an opening on June 22nd at 9:30 a.m. to issue rulings on both of these matters. And as is traditionally has happened, it's done on WebEx, but of course I'll hear from the parties on their preference as well as the attendance of Mr. Robinson at that hearing.
That's Monday.
Works for the court, and we would prefer WebEx for the state. Sorry.
It's okay. 9:30 in the morning.
That's fine with Mr. Robinson's counsel, and we will ask that Mr. Robinson appear by WebEx audio only from the jail.
All right. Thank you to the parties. Anything further? Any party needs the benefit of the record before we go into adjournment? All right. Thank you all. And court is now adjourned.
That's it. Now you can kill the sound. Sound guy. Well. Gotta go find my place in my notes here. My chair has I don't know, collapsed or something. Anyway, obvious takeaway of this post-recess session, guys, pretty much explicitly told us everything except the name that we can obviously infer they're talking about Lance Twiggs, guys. They're talking about Lance. He got immunity. This was, a kind of a question out there, something that some of us might have been a little suspicious about, wondered about, certainly has been out there as a possibility. Seems like it's confirmed. And so Mr. Burt described a situation where the investigators set this witness down, gave them immunity, asked them a series of leading questions, did this in front of Tyler Robinson, asked him to simply agree or disagree with the questions that he was asked. They recorded it, and then they want to use that recording at the preliminary hearing. Fascinating. Fascinating. So I wonder if Tyler Robinson shows on the recording. I wonder. Oh boy. And then simultaneously, we also have going on this. So this just got filed late last night, and I saw it on the exchange, but I haven't updated my archive yet because there wasn't like anything that was like there was nothing filed that like I'm going to buy and post. So I just kind of waited to update. But very late last night, there's a new motion to seal and or motion to classify. You know, to classify it as private or whatever. I don't even remember their levels there. And it relates to certification for an out-of-state witness, certification to subpoena an out-of-state witness. That's all that we know about it. And already kind of suspected that was going to be Lance too, but kind of sounds like that also. Like that's what the situation is. And so the defense wants Lance to have to be live. It also doesn't really sound like Lance is on side with the defense because number one, you wouldn't have his lawyer refusing your subpoena. No, I'm not going to do that. But two, you probably wouldn't need the subpoena at all. I mean, you're going to do it just to CYA, even with a super friendly witness. But the lack of cooperation from the attorney suggests to me this is not something like they've chit-chatted with him ahead of time and he's totally on board with coming in to testify at the preliminary hearing. So interesting little insight into the state of the affairs there. And you know, I've kind of been thinking, I'm not the only one, from day one of this case, you know, when the evidence came out, you know, the prisoner's dilemma issue here was always kind of going to be front and center. You know, the issue is if you have two people potentially implicated in a crime, you know, both of them have to kind of gamble that the other one is going to shut up and not put their own self-interest in front of, you know, the interest in the conspiracy or the crime or whatever. Because the problem is that silence only works if both people maintain it, but one of you is going to get an incentive for not maintaining it. So it's just a very, very tempting situation, which is why having lots of co-conspirators for your crimes is generally not a good idea. But this kind of puts a little bit of a new cast on things. He got immunity, so we don't know why he got immunity, what he got immunity for, how broad the immunity is. There's different types of immunity. There's use immunity, and then there's what's the thing I'm thinking of? I can't remember the name for it now off the top of my head. This is that IQ point thing I was saying earlier. But basically, use immunity means I will agree to talk to you, and you can't use my statements against me. But it doesn't mean that you can't still prosecute me if you come up with other evidence to show that I'm complicit. The broader category of immunity, whose name I'm spacing right now, is literally straight up, you can't be prosecuted at all. Like, can't be charged with a crime based on your cooperation. So we don't know what he got, but I'd suspect it's the broader one. Because he already knows, you know, if they're investigating Tyler, they're going to get into his communications and yada yada. And so if they have evidence against you, you better, I don't know, be as cooperative as possible. But so we don't know how broad this immunity is. We don't know if this immunity is for complicity in the actual crime or cover up. I tend to suspect cover up, and the clue for that. Burned note. Burned note is some cover-up stuff. We saw Tyler encouraging Lance, don't talk, delete all the messages, et cetera, et cetera. So we know there was at least kind of conversation about that. And then the last little piece that kind of hints to cover up stuff, perhaps, is there's a reference in the probable cause statement. Pretty sure it's the PC affidavit, but it might be the information. I forget. It's one of the probable cause documents where they describe interviewing the roommate, and he says something to the, if they like ask, I don't remember the exact context, but anyway, the point of it is that the roommate made a statement about Tyler had made a joke on Discord. He'd made a joke on Discord. So he's like minimizing the Discord, trying to excuse the Discord. Like, sounds like the kind of statement somebody might make when they're like still on side at the cover up before they maybe get convinced that it's perhaps not in their best interest to do that. That was by far the most interesting thing that happened all day. What I'm going to do, I didn't finish my recap of what happened before the recess, before we got to the recess, but I'm going to go ahead and skip ahead to just this argument that they did on the hearsay and kind of these other issues, and then we'll circle back to kind of wrap up what happened with the contempt. So as far as the motion in limine to exclude the hearsay, the judge is like, I've read your stuff. Limited argument, please. Gives them both 15 minutes. Everybody knows this is pro forma. It's like literally the first thing that the state says. But that's okay. Defense acknowledges it too. They're like, it's federally unconstitutional. It's federally unconstitutional. We are not here in federal court. We are here in state court. And so if the state court disagrees, Judge Graf is bound by the state court. And until the state court corrects itself or the federal court comes along and corrects the state court, then that's just how it is. So everybody knows. We're making this argument for purposes of a future like habeas process. And so Mr. Burt is arguing that the state, he argues we've raised all of these constitutional objections. The only one that the state of Utah has specifically addressed is the Confrontation Clause. The Utah Supreme Court has looked at this, says the Confrontation Clause under the Sixth Amendment to the U.S. Constitution does not preclude the use of this reliable hearsay testimony at the preliminary hearing. Does not require it. So that is controlling, directly on point. That's what what Judge Graf is going to have to follow. But Mr. Burt is arguing we raised all of these other constitutional issues as well. We argued this under the Due Process Clause, the Right to Counsel Clause, under separation of powers principles, and none of that has ever been addressed in Utah. He says the state is going to rely almost exclusively on hearsay to make its case at the preliminary hearing. From what we can see from the exhibit list and the witness list, that's, I think, sort of true. I mean, I think it's definitely directionally true. Yeah, they're definitely going to use a lot of hearsay. That said, they're going to show videos and stuff. They're going to show videos. They're going to introduce testing, examinations and stuff like that, which I suppose the reports themselves are hearsay. So this is not going to be like a trial where every cop who took a statement from a witness has to come in and personally testify about their particular role in the process. For example, they can have the cops testify about what they learned from the other cops. They could have the lead detective on all of this just come in and testify about, here's everything I learned from the FBI and the other people out in the field. There's I don't know, I forget how many law enforcement agencies they identified as being involved in this case, but it's a lot. It's a lot. In the trial, they're going to have to call anybody who did something material in the case to testify about it themselves. Got to do it all on personal knowledge. The preliminary hearing doesn't require that. I saw a lot of people in the chat asking, why would they not just do that? The main reason is the expense of it. This isn't the trial. This isn't the trial. This trial is going to cost millions. It's going to cost millions to get all of this done, to fly in all of the witnesses, to present the live testimony, you know, all that, hire the experts, all that stuff. I would frankly suspect that's probably the main reason why. I have a little bit of a reaction to that as well. That's like, it's kind of similar to my reaction to, you know, Judge Graf giving them this different schedule, this additional benefit to be able to handle the electronic media coverage, and the defense kind of taking that and like slapping them across the face with it. That's a little bit how I feel about what's happening with this situation with the witnesses. And that's because you know, okay, on the one hand, yes, you definitely get to present under the Utah law. You definitely get to present the reliable hearsay to establish the probable cause. But this really seems to me like a situation where the defense doesn't actually want what they're asking for. Okay, they've been complaining. They've been complaining from the outset about like too much information being out there in the public. And so it works much better for the defense to have this general silence that they can then trickle things selectively into the ether, like, hey, guess what? Lance Twiggs got immunity. And then there's going to be focus on that because it's the only thing that's out there. It's, you know, it's coming from the defense. They're getting influence over how all that unfolds. If we spent Provo, Utah County is like, yeah, let's bite the bullet. Let's spend $2 million on this preliminary hearing and do it all live. You absolutely know the defense would be complaining about that. And that goes to that comment that somebody made in the chat. I need to turn my banner off. One sec here. It goes to that comment they made that, yeah, the defense actually wants the live witnesses because it helps their argument against the cameras in the courtroom. Kinda, but Judge Graf hasn't been real receptive to that, has he? And so that's, what if you end up with a situation where you've got the $2 million preliminary hearing with everybody showing up live, polished, spit curled, everything. And Judge Graf is like, yeah, we're going to let the cameras in and people are going to get to see everything. The defense doesn't actually want that. By the same token, just because the prosecution can use reliable hearsay doesn't mean that it's like the best idea to use that for everything. I mean, I can absolutely see why, strategically, I can see both sides of this one. I can see why the state doesn't want Lance testifying live. They did this statement, if it is as Mr. Burt described, where it's just this sort of leading confirm or deny, you know, XYZ. They did that for a very specific purpose, to minimize the possibility of saying the wrong thing. It's to kind of take the control of the statement out of the witness's hands, have it crafted by law enforcement, and then just endorsed by the witness. And so it's the difference between somebody writing their own story and somebody writing it for you and asking you to sign off. They did that on purpose. I get it. That's why they want to use it, but it's a really freaking bad look. Isn't that a bad look? Isn't that a pretty bad look with somebody like Lance? Isn't that a pretty bad look? I mean, we're all going to find out Lance has immunity. It's not a shocker to me, honestly. It's really not a shocker. But if Mr. Burt hadn't told us that, let's just entertain this hypothetical. Mr. Burt hadn't spilled all this for us. Then we go through the preliminary hearing, and let's say, because it's not clear that we're going to get to see any of this evidence, but let's say, yes, we have this this interview and it's published, and it's kind of like we had with the hearing today, where we might be able to hear it, you know, don't necessarily get to see it on the screen, but we can hear it. What's that going to be like? Well, we're going to hear this kind of structural issue that the defense has pointed out. It's leading. It's the feds offering, volunteering the words and him saying yes, and pretty obvious why one might think an immunity deal creates a little bit of issues with like the incentives to say no under this circumstance. Doesn't that make it pretty clear? But that, may not matter for legal purposes. That may not matter for the determination of probable cause. But I think for common sense, for most people, it would matter a great deal. I think learning after the fact that all of this testimony, even if you might have like little red flags, like, which probably most people, like especially lay people, aren't necessarily going to catch on that there's anything amiss with interviews being conducted in this way. The lawyer's going to spot it right away. Ooh, this is really super leading. If the witness literally is just saying yes or no, that's textbook. That's the definition of leading, and is also going to, notice kind of not the way that you would prefer things to be done. Generally prefer people to tell their own stories. So there might be a little bit of suspicion about that, but I think by and large it wouldn't be. But then if it comes out, you go through this preliminary hearing, you have this Lance Twigg saying yes to all of these different things that the FBI, I'm assuming it's the FBI, is asking him about. All these claims that they're making, and Lance is saying, yeah, that's right, that's what happened. And then you find out he got the immunity deal after the fact. It looks real bad, I think. I don't know, maybe you guys disagree, but I think that looks real bad to find that out after the fact. So I don't know that I think that's necessarily a great call on the prosecution's part. But there's a lot of moving pieces with decisions like these, in terms of, what do you present live? What do you present by hearsay? What are the weak points in your case that might make it better, to go one way or the other? Yeah. I don't know about all this. I really don't. It's going to be very interesting to see how all this unfolds. So anyway, back to the recap. The defense, we were talking about, they're going to make, state's going to make the case almost exclusively based on the reliable hearsay. That's legal, but maybe not the most prudent thing ever. Defense, again, with the conspiracy theories are abounding, and the defense taking the mantle of, we want the truth here. We want the truth. It's always fun when you get to turn the tables, isn't it? It was super fun, which we'll get back to when Mr. Gray got to turn the tables on Kathy Nestor. But this was the defense gets to turn the tables on the prosecution, on the state, for all this time that the state has been, if not the best advocate for transparency, at least like generally in favor of open court and stuff. And so that's been, that's just been part of the dynamic of the case is the defense wants everything quiet. They're the ones trying to seal everything. They're the ones trying to close the hearings. Why wouldn't they want us to just know? But now they get to take this mantle, and they're not wrong. I certainly want to know if a critical witness offering evidence has immunity. It very much matters. There's a huge incentive there that you can't overlook. Now, that doesn't mean that anything, a witness says with immunity is false or anything like that, or that they're free to make stuff up. I mean, the issue is that there's probably lots of ways to corroborate or disprove a lot of this stuff. But either way, it's definitely the kind of thing you want to know about. So they get to take that on. We just want the truth here. They argued that the right to confront applies in all of these other non-trial proceedings like probation revocation, suppression hearings, sentencings, and stuff like that. And that would not be meaningful if it didn't require personal testimony. So then Mr. Ballard just responded, Utah Supreme Court's already ruled on this. Both of them like literally kind of start off letting the judge know it's pro forma. It's federal issue. Utah Supreme Court's already said no go. So that's what we're stuck with, but we're still going to go ahead and make our record. The state's argument is that because the probable cause determination is a low standard and it's limited in terms of what the judge is actually allowed to do with the evidence anyway, they have to interpret everything in the state's favor, basically. They got to assume that the state's witnesses are credible, except for limited circumstances. If there's conflicts in the evidence, they have to assume the interpretation that's favorable to the state. So because of that, the actual value of cross-examination is far more minimal for this specific determination. And it's just the difference between we suspect this person of a crime versus we've proven it. We've established it. We have demonstrated it to the degree of probability that we require for criminal cases in general and capital cases very, very specifically. That's why the standards are different in these different processes. And so he points out, yeah, okay, maybe you want to cross an immunized witness on their credibility, but that doesn't matter. It's not going to, from a legal standpoint, that can't affect the probable cause determination because the judge is not allowed to consider at the probable cause stage the possibility that the witness is lying because the witness was offered an incentive to tell the investigators whatever the investigators wanted to hear. He cited a case where the witness recanted. Witness took their testimony back, said, never mind, that's not it. And that was not enough to overcome the probable cause determination because there was an explanation. And I haven't even looked at the case. I already know what it is. It's a domestic violence case. The victim recanted and they put on some testimony to explain how freaking common that is and why it happens and how the abuse dynamics work and all that stuff. So as long as, I guess the testimony isn't like completely undermined, it doesn't matter. They can go with the initial statement. Super, super common thing in domestic violence cases where, there's an acute situation that is dangerous and, people recognize that and they need help and they call the police and they get that immediate help. But then as soon as that kind of immediate threat has been taken care of, now we get back in the whole abuse cycle and the codependency and the just everything. And so very, very difficult, very common for domestic violence victims to recant for a whole different variety of reasons, but just part of the nature of that kind of relationship. He made what I thought was a good, this is when you can say something like this, it's good. This would be the first court to find that there is a right of confrontation at the preliminary hearing. When you can say something like that, no court in the country has ever done it. It's a good argument to make. It's kind of a fun one to make, but it's also a little bit of a risky one to make because you better be sure. I've had to do this in cases where like, for me, it came up in the Eighth Amendment kind of context, cruel and unusual punishment, because part of the standard is like, what's the norm? What does the rest of the country do? What does the rest of the world do? So you got to be able to compare what happened in your particular case or what's allowed in your state with the broader trend. So I remember one case where I had to go through and do a nationwide like research project of life without parole and juvenile. I was challenging life without parole, mandatory life without parole under the 3 strikes law for juvenile, like things that you did as a juvenile but were tried as an adult. So I had to do this big, like, comprehensive, here's what Ohio does with, here's a standard conviction. Here's, how they handle juvenile, all this kind of stuff like that. It can be very complicated, but the whole reason why you go to that effort is because it's really powerful when you get to say, we're like one of the only states in the country that would put people in jail for life for this. That's a powerful thing for the judge to know. So I approved of that. I don't know if he's right, but nobody established he was wrong. So first court to find a right of confrontation at the preliminary hearing. And then he argues these other, arguing other rights doesn't work because these are more general. You don't get to, like, if the right of confrontation, the Sixth Amendment doesn't give you a right of confrontation at the preliminary hearing, then how could the due process clause get you there? Due process is kind of just this general thing. How could the due process clause give you a confrontation right that the confrontation clause doesn't give you? It wouldn't make any sense. So that's, I think, a pretty good argument too. They're going to call 4 witnesses. They said they're anticipating at this point 4 witnesses. And of course, the defendant can cross them to the extent that it's, helpful to cross-examine the person who doesn't have any personal knowledge of anything. Yeah, they do get to do that. But I suppose that is still more than they get to do with the grand jury. So, and then the separation of powers issue. This one is actually kind of the most interesting one to me because it's an issue that I never had the opportunity to litigate. I don't think. But I've definitely seen it and thought about it a lot because you have this kind of complicated relationship in criminal law between what the legislature gets to do and what the courts get to do. And sometimes that can come into conflict. Like the legislature will want the court to handle child abuse victim testimony in a certain way. They get a call from a constituent, or there's a high profile case that gets a lot of attention. Somebody was really traumatized. They want to do something about it. So they want to pass a law to change that. But the problem is that traditionally, at least at the common law, how things happen in court procedures and stuff like that, the court gets to decide. It's not up to the legislature. And so for the legislature to come in and tell the court, here's how you're going to handle these types of witnesses, that is implicating, if nothing else, if not kind of dramatically violating the separation of powers. And so it is kind of an interesting idea, I guess, about whether the legislature, through the Constitution and the statute and stuff like that, is in the position to tell the courts what evidence they can and can't hear at the preliminary hearing. I think the challenge with this particular argument, is that the way that the Utah Constitution is written, the reliable hearsay is in the Utah Constitution. Let me find it because I just posted it not all that long ago. I just have to dig in my replies for half a second here, and I will be able to find it. Here it is. Nothing in this Constitution shall preclude the use of reliable hearsay evidence as defined by statute or rule in whole or in part at any preliminary examination to determine probable cause. That's the part of it that matters to us. So it's not saying you get to do this. It's saying it doesn't prohibit it. And so then if somebody with the authority to decide if we get to do it or not says we get to do it, then the Constitution doesn't prohibit that from happening. So then the reliable hearsay rule itself is a rule. It is a rule. It is Rule 1102. That means the court adopted it. And so if the court adopted a rule that the Constitution says, you don't have to adopt this, but you can if you want to, and they do, that's not a separation of powers problem. That's the court acting within the court's purview. The constitutional piece is kind of an aside almost. So interesting kind of in theory, but as far as how it's going to apply in this particular case, I don't see it being a great issue. Mr. Burt identified certain exhibits that he wants the court to review relating to this objection to hearsay. And so we have exhibits 11, 16, 30, 31, 32, 33, and 34. Should we go ahead and take a look at that? Let me see if I can find those fairly quickly. Exhibit list. Swear I just saw it and now I can't find it. Oh, good Lord. Okay, state's witness and exhibit list for the preliminary hearing. Let me go ahead and bring this up. Here it is. All right, let me get back my notes I dropped too. Exhibits 11. 11, the medical examiner report. Yeah, the autopsy report, definitely hearsay. 16, recorded statement of Lance Twiggs, definitely hearsay. 30, all of these, yeah, all of these ballistics reports and things like that. So these are the main things that they're taking issue with. I get it. I'm not, I guess, quite as concerned about things like who took the photo of the rifle and whatever. Is any of that evidence misleading or inauthentic? Not really questioning any of that. But so those are the specific things that they are concerned about. Autopsy report, recorded statement of Lance Twiggs, and then all of the testing, all the testing report. They want these people to have to testify in person. He argues that, you know, this isn't a grand jury. The legislature gave the defense rights, procedural rights that they don't have at a grand jury. And so those have to be meaningful. Points out, yeah, great. It's great that we can cross the witnesses that show up, but if that's just a records custodian who's going to say, yes, this is a true and correct copy of the medical examiner report, then it doesn't help you cross-examine the basis and the conclusions and the opinions that are contained in the medical examiner report. And the state's response to that is going to be, it doesn't matter, because even if you challenge it, the judge has to take it at face value. But I get it. I get where the defense is coming from on this one. And then, as always, this is a capital case. Everything has to be done more carefully, more protectively, because of the nature of what is at stake. So that was the motion on hearsay taken under advisement. We will get that ruling on June the 22nd. June the 22nd, I am not going to be here. I have to head back down to California for my hearing on the exhibits that we will be getting. And I'm pretty confident making that prediction. Anybody is interested in that, I did file my response. I put it up on Substack. So I have to be down in LA for a hearing on that. And so I'm not going to be here. Hey, if I'm going to have to go down to California anyway, and it's camping season, yeah, you best believe I'm going to get some in. So I probably won't be anywhere near where there is cell signal for that. But I will catch up on it when I get back into range. I just won't be able to do it live. So So that is the motion in limine on hearsay. And then we had a little bit more conversation about this certification for the out-of-state subpoena. That is going to be briefed. And that's because, like we talked about, it's come up in these hearings before. They have a very limited right to call witnesses at the preliminary hearing because a lot of it just doesn't matter. The state's case has to be kind of given the benefit of the doubt at this stage. And so they relied. There's this case out there, Lopez, where the defense was trying to call in the victim of a particularly bad kind of assault at the preliminary hearing. And the court didn't allow it, and that was upheld. Don't have a right to call in the victim just for purposes of cross-examining without some kind of showing that this process is going to be material to probable cause. Utah does not do preliminary hearings for discovery purposes. They used to. Apparently, I went down this rabbit hole. Used to be like written in part of the process, like part of the reason why you do the preliminary hearing at all is so that the defense can do some discovery. They can talk to the witnesses. They can explore what their testimony is going to be, the kinds of things that they based it on. It's not necessarily always going to be strictly tailored to the question of whether there's probable cause or not. But then when they did, Utah did all of the kind of legal revisions when they did the victims' rights enactments back in, I think it was the early 90s. It was in most places that did that type of thing. That was part of what they very specifically eliminated, that we no longer use the preliminary hearing for a discovery tool. It is just this bare bones, get the probable cause determination done, and that's it. So Lopez is kind of in the, in that sort of framework where you don't have the right to do general discovery, to take like a pseudo deposition by calling people to testify at the preliminary hearing. But at the same time, you do have some rights. You just have to show that what you would be presenting is material. So here's like the last, I think, kind of clue. I didn't think of this before, but the last kind of clue that Lance Twiggs is not cooperating with the defense calling him in. It's not necessarily something that they are on the same page about or anything like that, is because you have to. We kind of got two ways that this could go, right? Lance testifies consistent with the statement that he gave to the FBI. In that case, what does the defense do? The defense goes after his credibility. The defense points out, you got a deal. You have every incentive to tell these people asking you these questions whatever they wanted to hear so that they didn't take you and put you in jail. And, take away your freedom and threaten you with losing your life and all of this stuff. That's a pretty strong incentive to tell them whatever they wanted to hear. Option, that's one way that it could go. The problem is that's not helpful for preliminary hearing purposes because it doesn't matter. Judge can't take it into account. He's got to assume Lance is telling the truth. Other way it could go, Lance testifies, contradicts his prior statement. Maybe he even says, yeah, the only reason I said that is because they threatened me with going to jail. They said they were going to arrest me and toss my home. And, so I told them what they wanted to hear. Well, that would be pretty material to the probable cause. That's getting much closer into this recantation type of framework. The case where they talked about recanting doesn't necessarily, when there's a good explanation for why a person would recant. There's a great explanation for why domestic violence victims recant, because they do it all the time. It's part of the cycle, and it's also, it's fear-driven. But I don't know that they have a great explanation for why Lance might recant. It's really not the same context. So it seems to me that if Lance was saying, yeah, none of what I told the FBI was true, that's absolutely material to probable cause. And so it wouldn't be hard for the defense to be able to make that showing that, yeah, we're entitled to the subpoena. We're entitled to call him in because this whole class of evidence that the state has and is expecting to rely on, he's going to undermine it. He's going to negate it. Doesn't seem like that's happened. Now, granted, all the motions are under seal, so we don't know for sure. However, I just would think it would be mentioned. I think it would be mentioned. It is material. The state's objection, it's not really an objection, but the judge just cuts right to the point. Are you objecting to this? He's like, well, I can't say yet. We got to think about it. But he points out, Mr. McBride pointed out, that the out-of-state witness's attorney has declined to accept service for the client, so that is not indicative of cooperation. And the rule requires counsel to certify that the witness, the witness's testimony is necessary and critical to the preliminary hearing, the probable cause determination. It can't just be about credibility. There has to be something material there. And so it's kind of implying with this objection, pseudo objection, like it needs to be there and it's not. If it was there, you probably wouldn't raise this. So at the end of the day, state's going to think about, but yeah, they're going to object. So they're going to have to brief this, and it's going to be on short notice. So we're getting a reply, by June 16th is what next? Get my calendar because I'm not good. I'm not a former economist. I'm not good at math in my head. 16th is a Tuesday, and then the reply on Thursday. So we will be getting some memos on that, except actually I take it back because we probably won't get to see them because all of this stuff is under seal. All the stuff relating to the certification for the subpoena is under seal. They'll be doing that. We'll be waiting to find out what the decision is, and we'll get to have a sealing. We'll get to have another one of these closure hearings at some point, right? Because I assume the media is going to object to this being sealed. I hope they do. They should. I don't necessarily have a problem with it being sealed right now, but maybe after the preliminary hearing is over. I don't know. So then we finally concluded with the defense's request to give us even more time to deal with the electronic media coverage request so that we can possibly appeal it to the Utah Supreme Court before the hearing. Propose their deadline. Mr. Ballard's like, we already have a process. Nothing in the rules contemplates appellate review of every electronic media coverage order. Nevertheless, seems that the defense may intend to do that, and in fact may kind of need to do that if the cameras are an important part of their post-conviction strategy. Under the current schedule, they'd be able to do the ruling by July the 2nd. So it would still be, 4 days in advance of when the hearing is scheduled to start. That is going to be quite a weekend though, guys, I got to say that is going to be one heck of a weekend. I'm sure everybody gets Friday off. I haven't even kept track of the federal holidays this year, but I'm sure everybody gets Friday off. Then the 4th is on Saturday, and then we're all recovering on Sunday. And then the 6th is when the preliminary hearing starts. What's 250th anniversary of America, guys? This is going to be a big deal. I can't believe I just said that. I'm sorry, mi chilenos. 250th anniversary of the United States of America. Allow me to correct myself. So anyway, Judge Graf, nah, we're not gonna fiddle with all of this. we've already been over generous with this process. There's plenty of time. We're gonna, this is all a little bit premature and kind of worry-wardish, because none of it's happened yet. Yeah, we all anticipate there's going to be a request for coverage, but we don't know. We don't know when it's going to be filed and all that. So scheduling stuff on it doesn't necessarily make a lot of sense. He is taking the issues under advisement. They are doing the WebEx hearing once again, June 22nd at 9:30 to get the rulings on our order to show cause that we heard today, as well as the using reliable hearsay at the preliminary hearing. I will not be here for that, but I will certainly pay attention to it. I will happily predict what I think the rulings are going to be. One, I think he's going to find no contempt. And this, in my view, today's hearing was a little bit of a step back for the defense from where they were before we had this hearing, honestly. I guess I should maybe finish my recap of this part of the hearing. Sorry if I'm a little... I feel like I'm jumping around a lot today. It really, losing sleep really does affect me major. So I apologize if I'm kind of jumping around a little bit. But we didn't ever get to recap Mr. Gray's testimony, which was just so awesome. That was pretty good. Yeah, we were struggling going through the testimony of Mr. Ballard and kind of all of that, and we were stuck on the bullet is supposed to be, that's supposed to be your gotcha, that he's making comments about this specific testing because he said the bullet when he's saying generally and inconclusive means the bullet doesn't have enough information. This was terrible. This is terrible. I'm disappointed in my Mr. Novak. I really am. I feel let down. I feel let down. Disappointment does happen in a relationship, and it's not whether those things happen, but your ability to work through them, your commitment to writing them out, that really defines the love in a match. So I'm not giving up on Mr. Novak. I'm not. I'm committed. I'm going to work this through with him, but I fucking hated this argument. This was stupid. This is so stupid. They had such better material to work with here. And it just was treated like an afterthought compared to the bullet. The bullet is a terrible argument. But the comments that he'd made about the FBI is going to be giving us more information, that's kind of important. Now he had an explanation for it. He's like, yeah, that was in response to them asking about the underlying data not being disclosed that you guys had brought up in the motion as a reason to continue the preliminary hearing. That isn't what it sounded like, though. Updating their reports is not the same. It sounded like there was maybe a little bit of conflating that with what the motion was to do additional testing. And if they do additional testing, well, yeah, there's going to be new reports and stuff like that. But normally to produce your underlying data, you don't need to prepare a new report. You don't need to update your report. You don't, there's nothing, your report is fine. They just want to see what your report was based on. So I thought, to me, when I was reading through the motions and everything, and to me, that was one of the strongest, I don't love that comment. That one is pretty close to the line for me. And then the other one, that they focused on this argument about he's presumed innocent, but we think we're going to be able to overcome that. We think we have the goods. Don't love the comment. Don't hate the comment either. But it is a little bit more in the gray area. It's clearly the one that Judge Graf was concerned about. He asked the prosecution about it specifically. And you know who didn't say a goddamn thing about it in their whole hearing? Mr. Novak. Mr. Novak. Why didn't you talk about that particular statement? I do wonder, I gotta wonder maybe with capital lawyers, I've never done capital defense. We got rid of the death penalty in Washington, what, around 2010 or something like that. Something like that. I don't remember exactly when. Anyway, a long time. We don't have death penalty here. So I've never done death penalty litigation, but I've, watched a fair amount of it. And there is very much, there is kind of a culture to it, I guess, is the best way to put it. And just, practice norms and expectations and things like that. And very much this expectation that you preserve everything, like far beyond what you do in just even like a life sentence, possible life sentence case for something not capital. In a capital case, you raise everything, you preserve everything. And so I just wonder if that might, after a while, does that make it hard to kind of prioritize, to like interpret your case well enough to be able to prioritize, here's the stuff that's strong and here's the stuff that's weak, and let me focus on the stuff that's strong, just because your focus has been everything. That's like all I can really think of here for Mr. Novak is he's lost the trees for the forest. He had some really good stuff here. Maybe not really good, but he certainly had better stuff than the bullet. The bullet. So yeah, when I read through the brief, I think it put him in I think they were in a better position before we had this hearing, because now we've had this hearing and Mr. Ballard got to explain, I was talking about the data. That's all. I wasn't talking about new testing or additional results or anything like that. I was just talking about your request for the underlying data of what they already did. We didn't have that explanation before, and it really wasn't clear from the statement itself that that's what they were talking about. So this is how, be careful what you ask for when it comes to hearings and stuff like this. It didn't help at all. You just gave him an opportunity to take away probably your strongest argument there, that they made a comment on testing examinations and stuff like that wasn't already part of the public record. Got into that little bit of it's still not anywhere near as bad as Levitt, the case where the prosecutor is like, oh, trust me, we've got the right guy. We have all kinds of evidence. You'll never be able to hear any of it. Most of it won't be admissible in court. But because of that, we're totally positive. We believe, we are convinced we have the right guy. Not that bad. But it's not great. It's not great, implying that there's going to be everything is fine because there's going to be this other reports and FBI is going to do all this stuff. And so just trust me, bro. It's like, it's got shades of that. Not as bad as Levitt, but it's in the same universe. But that's just gone now. You took that away because he's got an explanation for what that was. And it does seem plausible. It's very poorly worded, but I don't know. I don't know who to attribute that to. So we got basically a long bunch of defense predicates, getting the evidence into the record, which is already in the record, and it's not clear that they needed to do that at all. In fact, he asked for clarification at the beginning whether it was even appropriate to be offering these things as exhibits. Instead of focusing on, honing in on, here's the specific things that we think are a violation, and, why, explore how that happened, and then what the penalty should be for it. So he instead, Mr. Ballard, he was, prepared for what was coming. He had his quote unquote talking points, so to speak. He was on message. He knew the message. We were there to respond to misinformation in the press. How many times did he say that? That was our goal, was just to respond to the misinformation that was being circulated about the bullet testing. They thought that just waiting for it in like not saying anything, doing a no comment would be insufficient because that would itself become a story. And I think they're absolutely right. It would. I think it would. Prosecution doesn't deny that case has been destroyed by bullet testing. That's what the Daily Mail's next headline would be. So I do get that. I kind of generally favor, I've talked about this before, I favor the right to respond. I think most of the time it favors the defense because most of the time the information that's out in the public square is the information the state put out there. And then a gag order comes down or whatever, and you're stuck with the state's narrative. Well, what if you have a really good case for innocence? What if, you know, all their charging stuff turns out to have been bullshit? You know, they claimed in their probable cause statement that XYZ happened, but as it turned out, it was fabricated. Or as it turned out, they violated somebody's rights to try to do that. I think it's normally going to be able to benefit the defense when you have the facts, when it's on your side, to be able to go out in public and be like, no, here's the prejudice to my client. The state has put this out there, these accusations and this basis, and here's the truth. People think this because of what they did. Definitely talked about that a lot in Depp v. Heard. Adam Waldman did, quite frankly, in my opinion, more for Johnny Depp just through his media strategy than anything having to do with the trial. Well, the trial helped, sure, but it was from day one, it was always the audio recordings. As soon as Adam Waldman got those audio recordings of Amber Heard in the act of abusing him, talking about abusing him, talking about hitting him, admitting she hits him, that was pretty dispositive, I think, for most people's views of the situation. Oh, that's not a victim. Became real crystal clear. And I think it established it in a way that, you know, was the trial was helpful to the extent that it just allowed that to become even more broadly known and seen. So, yeah, and that was based on right to reply to her accusations that she had made, you know, years and years ago and throughout the litigation and in her public statements and all that stuff. So in general, like I'm in favor of the right to reply. I feel like the reason we don't see more of it is just because the reality is that most of the time there's not a whole lot to say. When your counter argument in the case is, you know, well, but there were extenuating circumstances for why my client did it, or well, but my client had a severely challenging childhood that you know, kind of affected their development and their relationships and stunted them maybe a little bit. Those aren't good responses. Those aren't good responses. And I've said many times that is the bread and butter of defense work. Okay, very few cases are my client did absolutely nothing wrong and the fix is in and all of this is bullshit. Not that they don't happen, but they are rare. Most of the time, you're arguing around the edges. The right of response of, well, yeah, my client tried to shoot the guy, but he was drunk. He was never going to be able to like aim well. You know, he didn't really, you know, come on. Is that something you're going to want to put in the press? You're not. But then we got to Mr. Gray. And boy, Mr. Gray was really something, wasn't he? Because the main thing that he brought out in all of this was guess what? guess what? Part of the reason I thought this was totally fine is because of exactly what oh man, it was a late night last night. Kathy Nestor did exactly that in the Kouri Richins case and invoked this specific rule and was like, yeah, we have to respond to all this misinformation that we hoped the prosecution would have corrected. The argument to hypocrisy is not a legal argument. And maybe, you know, Jeff and I disagree on this one. I find it highly persuasive. I love a good piece of hypocrisy. Jeff tends to find it not really all that compelling. But, oh, I see. Yes, transactional immunity was the word that I was looking for before. Use immunity and transactional immunity. Transactional is the one where you can't charge for anything. I like the hypocritical kind of argument. And so I thought that was a lot of fun. I think Mr. Gray thought it was a lot of fun to be able to describe. Shame Kathy wasn't here for it today. Shame she didn't get to enjoy this one. I have to wonder, I guess she's on vacation. Did she schedule that on purpose? Like, how long has this vacation been scheduled? Did this motion or like the hearing get set? And she's like, I'm out. I have to wonder, because obviously she knows that she did that. And obviously she knows that the position that they're taking here isn't really consistent with the position that she took in Kouri Richins' case, which, by the way, is not against the law and is totally normal for the defense lawyers. What benefits you in this case is completely damaging in the other. And so you take inconsistent positions all the time. Maybe that's part of the reason why it may not be that persuasive, but I loved it. Yeah, if it's good for the goose, it's good for the gander. And I haven't watched the Kouri Richins interview. Still have watched very, very little of the trial. It's been a busy summer. But maybe I need to try to find time to go check that out and see exactly how bad it was. He thinks, Mr. Gray thinks they might have crossed the line a little bit about what they're allowed to do. But generally, yes, responding is okay. Depends on the circumstances, and you have to be careful what you say. I don't think there's really any particular dispute about this as a matter of principle. It's just a question of whether they kept it between the lines, and in this case. We had then the arguments on it. Mr. Novak was supposed to have 8 minutes, but his 8 minutes was a short lifetime. There was some kind of, he does this thing where he sort of tells the judge what he wants to do and then asks the judge if that's what the judge, do you want me to do that? Like this whole long thing about, are we going to talk about sanctions right now? Well, yes, I would assume you're not getting a second bite at the apple to talk about sanctions. That's what this whole hearing is about. Was there contempt? If there was contempt, what's the appropriate penalty for it? So yes, you need to deal with that in your argument. And of course, nothing in the testimony really elicited, what they were going to go for or really the basis for it. But at the end of the day, I think this argument really over-egged the pudding. The violation, it was intentional. We don't have to show intent, but even if we do, it was so intentional. It was so, very least, it's so reckless. It was so reckless that the intent to violate the order can be inferred. I don't see any of that. I really don't. I see an intent to make a statement. Absolutely. No question there was an intentional statement that was made here. But was the intent to violate the gag order? No, I think it's pretty obvious the intent was to stay within the confines of the gag order and the right to respond. Now, whether they successfully did that or not is a question. And that's one of the ways I talked about last time. The judge might come down on all this, because we'll get to the prediction. Nothing's going to happen. The judge is not going to do anything. He is absolutely not going to take the death penalty off the table like Mr. Novak has asked for, just because Mr. Ballard told the press what an inconsistent and inconclusive test result means. That's not going to happen. But yeah, anyway, so he has the possibility to make this ruling where it's like, yeah, okay, maybe there was maybe they slightly crossed over the line or something like that with some of these comments. But was it their intent to violate the order by doing so? He has the out by saying, I'm not finding them in contempt because even if it was bad, they didn't mean to do it. So consider this a warning, because next time, you know, you might not get so much lenience. You might have more notice now that we've had to go through this kind of process about the kinds of problems that this can cause. You would be aware at that point that even if you think you're following the rule, you might not be. So in the future, doing similar behavior could be a problem. But this right here, I don't think it's intentional, so I'm not going to sanction you for it. That's possible. And it's maybe one of the clean ways that he would go. The other option is he says, I don't think these violate the gag order. I don't think there's a scenario where he says, yeah, these violate the gag order and it was intentional, willful, whatever. Therefore, some kind of punitive sanction is required. I just don't think he's going to do that. I mean, talk about the culture of the courtroom again and how nice and congenial everybody is, and the general politics of courtrooms where judges don't like to make findings like that about the people that appear regularly in front of them. You know, find him in contempt, potentially a black mark. What if he's got aspirations to run for governor or something like that? This is the same kind of idea that it's one of my very few and very careful, cautious disagreements with Michael Osbrook about why I don't think the the motion to correct error, space and on the case name, the prosecutorial dishonesty and all that glossip, the glossip issue. That's why I don't think the glossip issue is, it doesn't matter how legally strong it is. The incentives against finding this guy who wants to go be a governor someday and has all his political connections and yada, yada, actually lied and misled the court and violated his ethical duties. You're killing his career, his political career, if you do that. Many of us would be like, well, don't hold me back then. But in general, courts don't want to do that. So I don't think they're going to find him in contempt. I really don't. We'll see. We'll see. Only questions the judge had was after Mr. Ballard's testimony. Or maybe it was Mr. Gray. Now I'm kind of losing track of even what happened and in my notes and everything. Okay, it was during the arguments. I got it now. So at the end of Mr. Novak's argument, the judge is asking, hypothetically, if I found the violation. You can just tell how he's thinking. You really can. sometimes with these questions. Hypothetically, if I found a violation, do the interests of justice require a proportionate sanction? Yes, they absolutely do. That's crystal clear under the law. It seems to me to hint that he is already thinking this whole taking the death penalty off the table, that is not proportionate. But it would require him, if he's going to find a violation, to at least, if not say explicitly, at least think through, well, is it a big deal? Or is it kind of a minor, you tried, you accidentally, inadvertently, whatever. You didn't do a perfect job. So we need to do something, but this isn't a Levitt situation. So that was his question for Mr. Novak. Then after Mr. McBride made his argument, Judge Graf asked specifically about that statement, final page of Exhibit 3. He is presumed innocent, but the final decision is up to the jury, and we believe we'll be able to overcome that presumption. That's the one that, is kind of close to an opinion on guilt, but at the same time, it's not. I mean, I do appreciate the prosecution's explanation for this, that they're like, the statement makes it clear that it's the jury that makes the decision. It's not expressing their personal opinion about guilt per se. It's just saying they predict that they're going to be able to convince the jury with the evidence that they have. Seems to me to be kind of the fairest interpretation of that. And that's not improper. I mean, it is sort of implicit in just having a prosecution at all, isn't it? We believe we'll be able to overcome the presumption. This is just nowhere near the universe of, we have all this secret information that you'll never get to know, which is why we prosecute this guy. So trust us. That's the opinion on guilt stuff that Levitt was concerned with. This is nowhere near that. Nevertheless, I think it is one of the few statements that is probably a little close to the line. And so Judge Graf honed in on that in a way that Mr. Novak did not, like super noticeably did not. Oh, it was painful for me. When you see somebody that you love just struggling and you're helpless. No. Oh man. I hope that gets better. I really do. I hope Mr. Novak is able to tighten up his arguments a little bit better, direct them, focus them a little bit more. Because the just wanting to preserve everything, wanting to have everything as an option, it doesn't work from a persuasion standpoint, because then it means you're arguing a whole bunch of crap. And the judge is hearing you argue a whole bunch of crap. Everybody knows the bullet. He specifically talking. Generally, he's like, that's the literal words he used generally with these tests. Generally, an inconclusive result means this. Obviously, is the point to imply that that's what the situation is with this bullet? Yes. And that's fine, because that's in the public record. That is in the ATF report. The ATF report has it has a page. Like, there's a page of it that I think not everybody reads, but it's got the definitions, it's got the explanations. It explains what that means. It's right there. It's in the public record. Should we find it? No, I don't want to hunt it down. So not really a whole lot there to make a lot of hay out of, even if he was talking about this specific bullet. That's kind of the argument the state was making. This report was public. It doesn't matter. He has the right to correct information about that, and he's not adding anything that isn't already known or knowable. So where I think I'm at is that when we started the hearing, I thought there'd be a decent chance he might find a violation, but do a nominal type of sanction. mainly just because of the incentive to police the gag order. He doesn't want to have to be having these hearings all the time. He doesn't want there to be some kind of implication that you can just go out and rely on the right to respond. Now, does the defense get to go out and do an interview to respond to the state responding to the other stuff? Like, how deep does that go? And he doesn't want to be caught up in that. The reason to have the gag order in the first place is to disincentivize people from talking, even if they otherwise have the right to do so. It's like, it's funny in a black humor haha way to me. That's literally how this order is set up, right? Because he can't constitutionally apply it to the witnesses in the case. Probably. Maybe a little bit of an open issue. Can't apply it to folks who aren't witnesses, but maybe just know things, heard from TPUS or, whatever. I'm not going to be a witness because I'm not in law enforcement, but maybe I'm married to one and I got the whole ins and outs on the investigation. Like, you can't apply the gag order to people like that. And so it's structured in a way to just make it like, well, but we're going to hold you, the parties, the people that we can restrict, responsible if they do. We're not going to say they can't. We're just going to say that if they do and it's really bad, you might have to pay for that. So the whole thing is set up to disincentivize people from talking. That's like literally the whole point of it. So you don't want to just be like, no problem. You gave an interview. It was no big deal. I do think that there is an incentive here for Judge Graf to want to discourage more of this from coming up again. And the only way you do that is by, little bit of a spanking, So I really thought coming into the hearing, that's probably where we're most likely. So they'll get a little bit of a spanking. Look, this isn't the end of the world, but you shouldn't have done that, and you should have known better, and you shouldn't have taken that risk. And, next time they will behave differently. I'm not so sure after this hearing that we're even going to get that. I really don't. Because I'm just not sure they showed a violation. Statements I was most concerned about, those ones about FBI is going to have new reports and stuff like that, explained it pretty credibly. It's the only one I really see as still being kind of on the line, just because of how badly it's worded. It implies there's going to be future additional testing, more evidence, whatever. Even if that's not actually what he meant. So maybe he still gets a little bit of spanking for that. But the explanation, if the judge buys the explanation, then that's not a violation. He wasn't talking about anything improper. Doesn't violate the gag order. And then the only other one, this comment about, we think we're going to be able to overcome the presumption of innocence. I don't love that comment. But I also can't really hate it that much relative to, the awful things that other prosecutors have said that has generated all this law about trial publicity. On the spectrum of prejudicing the jury pool is we think we'll be able to overcome his presumption of innocence. Egregious? No, it's really not. So I'm not sure they're even going to get spanked. I really don't. I have to anticipate that if nothing else, even if the judge at this point doesn't find them in contempt, and I think, frankly, he's not going to. I really don't. I don't think he's going to. No intent. No intent. He's not going to find that they did it deliberately. I forgot what I was saying. Guys, get your sleep. I'm telling you. Days like today reminds me that you can literally die from sleep deprivation. You can literally die. Keep somebody awake for too long. Systems will shut down. It's crazy. Sleep is such a wild thing. One of my it's one of my books I read. This one I read a long time ago, but I'd love to go back and read it again just to kind of refresh Why We Sleep. Anybody in the chat read Why We Sleep? Oh my Lord, I loved it. It was fascinating. It is literally just this book about sleep and the science of sleep and how little we actually know about what sleep is and why we do it and all the different like ways that sleep happens and like differences in sleep patterns between different species and stuff. It's like this weird universal biological thing that animals need to do, but also plants kind of do it too. Did you know plants have circadian rhythms? I learned about that from the bonsai trees because I learned that plants prefer to do their like big uptake of water in the morning when they wake up. They like to wake up, get a big drink of water, and I mean it's not really how it works, but generally speaking, they prep. They do like their kind of storage for the day, and then slow down, less activity and stuff during the night. It's not entirely like a light thing either. It's not like just they're responding to the light cycles because when you like disrupt them, it takes a while for their pattern to reset. So anyway, sleep, guys. Sleep is fascinating and valuable, and get lots of it. So yeah. Anyway, I don't know. I was saying something about contempt, and I don't think the judge is going to find it. Oh, I remember. Even though I don't think he's going to find it at this point, I do think he's probably going to include at a minimum some kind of language in his order that's just like cautionary, let this be a warning to proceed with extreme caution so that we don't end up down this road again. But I do think that might be the worst that we get. Oh, what's going on in the chat? Yeah. Sleep is healing. It's beautiful. It does. This is going to be so freaking morbid, but it does kind of make me wonder about our fear of death. And like, I mean, isn't it kind of like we die every night a little bit? It's probably kind of what it's like. You're there and then you're not. That's the experience of sleep, isn't it? You just out of nowhere, you're kind of not there anymore. And then you come back in the morning, but at some point you're just going to like not be there anymore. And it's going to stay that way. But doesn't that not sound so bad when it sounds like sleep? I mean, sleep, eternal sleep in many ways kind of sounds amazing. I remember one of the little kind of mind blown comments that was made in the book, the Why We Sleep book, was question is, which is the norm actually? Which is like the normal state for the biological animal? Is it the sleep or is it the wakefulness? Is it the part where we're not here or the part where, we have this view of things happening and stuff? I don't know. Anyway, sleep is very healing. I agree with that. We had just a flood of memberships today, didn't we? Thank you so much. Wow, Life is Rough, for your generous gift of all these memberships. Good Vibes Only 1111. Welcome to the channel. Another gift of memberships from Ginger Puff 764. Thank you so much for that. Miss Maga Mandy is now a member. Welcome to the channel, Miss Maga Mandy. That was pretty awesome. That's always awesome. I do notice and there's like a bunch of green in the chat all of a sudden. So really do appreciate that. Thank you so much. Jillybean 911, huge fan since the Idaho trial that never was. It was right up until it wasn't. Right up until it wasn't. And that one is still just incredibly perplexing. Lots of people have asked me for my take on the what's his name? Turley. Is his name Turley? The guy that wrote the book and the defense expert and stuff like that. And guys, I'm not going to get into it. I'm really not. None of it can be proven or substantiated or anything at this point. It's like a one side of the story that we'll never get to hear the other side, because Ann Taylor is bound by confidentiality, as the defense expert should have been also, by the way. To me, that's like an instant. No, you're a defense expert and you're talking about defense stuff. We're done. Like you're nobody. You're dead to me. You're nobody. I don't care if it's not my case. Like, just as a matter of principle, that is so not the thing that is done. That is not the integrity that I require people that I'm going to work with and rely on and trust with my case. So structurally, we're already in a little bit of a problem with is his name Turley, Mr. Turley, with me. But just the fact that there's no way to answer it. So no, I'm not going to get into that particular rabbit hole. I've accepted the kind of ultimate conclusion of the Kohberger case, which is that unless and until he decides we can know more, we already know what we're going to get to know. And that is definitely unfortunate. I put a lot of responsibility on Mr. Thompson for that state of affairs, not requiring any, additional detail or anything like that. Even just a basic explanation. How the fuck did you do this? How did you pull this off? How did you even know who they were? The state never came up with any kind of connection. How did he even identify the house, the victims? We'll never know unless he decides to tell us. Anyway, I'm glad you stuck around. User with a lot of numbers. He asked in order to provoke a slip, not add facts. Yeah, that seems to be the general nature of this defense questioning. That was the same thing that happened at the motion to disqualify. I thought the motion to disqualify, when we saw that, it was just so similar. Like there's no new facts being elicited, nothing that the witness is actually being confronted with. We're just kind of doing that thing where we go back through what they already said and they say it again and then explain why they said it. It's like they strengthen it by doing that. It's not an effective method of questioning. But I do think this is what it is. It's not because they actually have material to confront somebody with. Cross-examination, I mean, I'm going to call it cross because, yes, I realize this isn't technically cross. The defense is calling the prosecutor as the defense's witness. Nevertheless, the prosecution is clearly antagonistic to the defense structurally, if nothing else. So for practical purposes, it's like a cross. The rule of cross that I prefer is definitely as a starting point. You can always branch out as you kind of get your experience and you get your confidence and you figure out what works and you learn how to read people better and just all of the kinds of trial skills that come into play with more experience. But the general rule is you don't ask a witness anything on cross that you aren't prepared to substantiate. That's the whole point of cross, is so that if they lie, you can prove they're lying. And so if I'm going to ask a witness about something, it's because they already said it somewhere and I can prove it. They said it in a report somewhere. They gave it in an interview. They put it in an email. They're on video doing it. Whatever. It doesn't matter. But I build my case and my questions based on that evidence because that way I know what I'm going to get. You're going to tell me what I already have. Because if you don't, I'm going to be able to smack you around with it. That's kind of the just general structure of how to be successful at cross-examination. It's the don't ask questions you don't know the answer to, kind of in practical terms. That's how you do it. And so, yeah, when you don't do that and you just kind of fish around, you run a lot of risks. One, you're not being particularly effective because what are you even eliciting? You're eliciting more explanations and stuff that aren't helpful to your case. But you're not really landing anything either. But it seems to be this idea that, like, if I ask him enough questions, or maybe if I argue with him, or if I ask him those awful, oh, I was almost ready to engage in some violence against my dear Mr. Novak, but I was almost ready to give him that smack for the Kathy Newman question. So what you're saying, if I went to the press and said it's my opinion he's guilty, don't make me hurt you, Mr. Novak. That is terrible. That's terrible. It's terrible. It's transparent. Everybody sees through that now. Of course, he's not saying that. You're just being argumentative. It's not a good example. You know it's not a good example. But it's a way that people can kind of question somebody that they think is maybe intellectually inferior, and get them to, slip up or stuck. Because, like, ooh, I don't want to agree with that. That sounds really bad, but I don't know how to disagree with it. And so then you say something stupid. But I think a smart witness does what Mr. Gray does, who's like, well, I don't think that's the same thing. Sees past the question that you're asking to why you were asking it, and then just answers the kind of why. Well, I know you're asking me that because you're going to try to argue that's equivalent, but it's not. That's not the same thing at all. So I don't find it particularly effective. It aggravates the hell out of me. Those so what you're saying is kinds of questions, unless you're actually trying to be fair. If you're actually trying to fairly categorize what the witness is saying, great. But if you're, just trying to do this gotcha questioning thing, I would love to have maybe I should do that. Maybe I should go find that Jordan Peterson interview. And when he finally called her out on it, I don't remember exactly what he said. Like, I should memorize that, have that as the script of what to say about, like, how incredibly bad faith it is, because it's so obvious that that's not what I'm saying. It's contradictory to what I've been saying. We both know that. Just try to nip that shit in the bud. But I think you're absolutely right. That is exactly what this questioning is supposed to be. Guess that's all they got. Try to get them to slip. But the problem is that if they don't slip, they might make things a whole lot worse for your case. And I think that's what happened today. User, lots of numbers. If Tyler's family hired a PR team to spin the FBI result, could the defense argue, not us, that was the family? A trick unfair to the prosecution. I mean, it wouldn't be the defense. That's true. That's true. It wouldn't be untrue if, somebody that is not Tyler and not one of Tyler's attorneys went and did something. That's not the defense. I think the point here is that it's not clear that it really matters. The defense really wants it to matter what they're responding to and limit what they're able to respond to, so that it can only be if the defense provokes something. So in this type of scenario, that would be the trick, right? The defense doesn't do it themselves, but we, have a little off the record signal chat or whatever with Tyler Robinson's PR team, and they go do it, but it can't be traced back to us, Then yes, that would be a dirty trick if that was required. But the thing is that it's really not clear that it is. It's, in fact, pretty explicitly not that. The rule itself says just that you're responding to prejudicial publicity that you yourself didn't cause. You or your client, your side, didn't cause. It doesn't say it has to be caused by the other side. I think the state absolutely has the right part of that argument. Now, that said, the state has tried to point the finger at the defense anyway, be like, you were the one that was misleading in your briefing. The defense gets their backup about that. I don't blame them. But I can yes see the argument that it was spun. The defense spun it in a way that is to their favor. That's what advocacy is. But at the end of the day, they're responding to the Daily Mail. We all know they're responding to the Daily Mail. And so what or who kind of got the Daily Mail to go down that road, it doesn't matter. The rule doesn't seem to make it matter. So, yeah, I mean, if the judge interpreted the rule that narrowly to be like you only get to respond to things that are initiated by the other side, then yeah, this would be a huge problem. But the issue, I don't think that's the rule. I really don't. So this would go more to like a scenario where we're going to violate the gag order. We're going to put stuff out there that, clearly doesn't fit within the exceptions to the gag order or the professional rule, but we're going to do it through this third party. So our hands are clean and you can't get us kind of thing. It would be quite risky to do that. But it wouldn't surprise me if that happens from time to time in different cases. That wouldn't surprise me at all. WW8599. Novak is arguing this like he's in California, which is very unfriendly to cameras. Yeah, and also in federal court. This guy is in federal court a lot. What was it? 800 and some cases he's got in Pacer. Okay, no cameras in federal court. Dude, you're in a camera-friendly state. Adjust accordingly. I do. I hope he gets in his stride because it's definitely not working. And I don't want him to be performing to the camera. Of course not. It's just that we are a little bit of a proxy for a future jury. And it would be good to maybe read the room a little bit better on some of this stuff. But he's been doing this a long time. He's got his habits, he's got his ways of doing things. Some of it might be pretty fixed. Some of it might still be fairly elastic. I don't know. That's going to be one of the things I'm interested to see because he's got to do better than this with witnesses that matter. Like so far, none of this stuff has mattered. Really, this has just been trial run stuff on things that the defense is probably going to lose anyway, or at least if not probably lose, they're not going to get significant material benefits out of it. What about when it matters? Okay. You are apparently ginning up right now to try to subpoena Lance Twiggs into the preliminary hearing in a situation that makes it look like he's going to be a hostile witness. You better not handle that like you've handled this here with these prosecutors. So what you're saying is, that's not going to be good. That's not going to be good. Got to see how this goes. Everybody can potentially learn. Sarah Moxie 7 with a super chat. Thank you so much for that. Very much appreciate the support. Kang the Conqueror 2025. How big of a deal is the potential plea deal? What potential plea deal? What potential plea deal? I don't know what this means, unfortunately. I'm not aware of any potential plea deal with Mr. Robinson, certainly. If there is plea stuff on the table, then, that's significant. Types of conversations that really should happen. Doesn't mean that every case should plead out or anything like that, but you should at least be having the conversations about whether you can resolve it without a trial. I have no idea if any of that conversation has happened in this case. This might be about Lance. I don't know. I don't know. Lance getting immunity isn't a plea deal, but I think that might be what this is referring to. It just depends on what kind of a case they had against Lance. You know, how big of a deal it is to give somebody immunity just depends on what could you have gotten them for. Letting somebody get away with murder is quite a different scenario than letting somebody get away with, you know, burning a note after the fact and then coming clean about it. So, best answer I can give you on that one. Sarah Moxie 7, Andrea Burkhart, the best attorney in the law tubes, best, most intelligent analysis everywhere. You are too kind. I can't believe you made me read that out loud, but thank you for that. Very kind comment. Made me a little bit embarrassed, but I do appreciate the support. Especially on a day when I am not feeling my IQist. And boy, the day has flown too, hasn't it? Good Lord. Look how long we've been on here already. Guys, I guess it's probably about time to wrap it up. So yeah, a big takeaway today was the Lance stuff, even though nobody explicitly said that's what it is. Pretty clear that's what they're talking about. Pretty clear that's what they're talking about. He got immunity. He got sat down for this leading interview that they videoed, like for the purpose of just getting him on record with incriminating statements. Apparently did this all in front of Tyler, which is like, that's hard for me to think about. Hard to imagine, you know. Entertain the possibility. Okay. I know this is not universal in the chat or in the internet in general, but just entertain, guys. Use your brains. You don't have to accept this just because we're entertaining it, right? That's the sign of intelligence. Aristotle never actually said that. It gets misattributed to him, but it's not a bad insight, right? That intelligence is the ability to consider an idea without having to adopt it. Let's just consider the possibility that all this shit is legit. Okay. The messages are real, et cetera, et cetera. One of the things that I kind of see in those communications and this relationship and kind of how this went down and why and everything, it really looked to me like Tyler is trying to be a hero. You know, he's got this idea that, you know, I had this chance to do it. I'm going to do it. I had hoped I would be able to take it to my grave, you know, kind of thing. He really did. If all this is true, that's what we're entertaining. It really does seem like he thought he was doing a good thing, and he was doing it with like this nobility. And he was gonna carry the weight of it alone forever, type of thing. Except for Lance, you know, Lance, who is like the one person he trusts to talk to about all this, at least at this point. And so just that betrayal. That betrayal, sitting there and seeing that person that you were trying to be the hero for. You really thought like, and went this far to be the knight in shining armor for Luna. And then to see that betrayal right in front of your eyes, it's hard for me to think about. It really is. And that's I wonder, you know, do you see him on the video? How's all this go down? I don't know. I really don't, but it sounds pretty awful. I don't like thinking about stuff like that. Not saying that it's not the right thing to do, not necessary, whatever. Not trying to say that, like, you know, Lance is terrible for doing what he did, if he did it. But it's still just, it's hard no matter what, you know, to have to, it reminds me of like when Tyler's parents, what they go through, the parents of people who commit things like this, just absolutely devastating, absolutely devastating. But then to, potentially have to, cooperate against them, participate in a process that's going to take away their freedom. No, it's really devastating, like even if it is what has to happen. So kind of sad, but yeah, intrigued to see how all this is going to play out. I don't know. Yeah, boy, I don't even know. I don't even know what to think about is he going to be able to testify live or not? We don't know. We don't know. I'm probably not going to be able to find out from the pleadings about the subpoena being all under seal. So if the state objects and says no, there needs to be a showing that it could undermine probable cause, and the defense can't come forward and say something like, yeah, we've interviewed him and he said this and this and this. If he hasn't cooperated with them, then I'm just not sure that they meet that standard. So I don't know if we're going to actually get to see Lance at this preliminary hearing or not. I really don't. Seems like kind of the safe thing to do, of course, in the abundance of caution, but also doesn't really seem like they necessarily have the best argument to be able to do it. So it would be nice if we get to see briefs on that at some point. I'm just interested in the whole kind of legal side of that one. Oh, well, yeah, I guess it's nap time for me. I gotta get some Z's in before I need to be alert for Phillies baseball. I need to be alert. Things have been good. It's like in a good place to watch the ball games. You got to enjoy it while it lasts. Oh man. Donnie Baseball has just been, he's been like fairy godmother doesn't seem like quite the right framing, but it's just the one that came to me. It's just like this magical baseball fairy that came out of nowhere and somehow turned the Phillies around and gave them their energy back, gave them their juice back. And so even Bryce is like, gonna hit a first pitch dinger off of a Hall of Fame pitcher. It's gonna get their clutch back. So I got to be alert for that. But this has been an insightful one. It was not necessarily starting off, wasn't necessarily the most pleasing one to sit through, but we did get some very interesting information out of it, I think. So you guys check out the rulings on June 22nd. I will not be live for that, but I will catch up on it when I get a chance. And then, yeah, getting closer and closer to this preliminary hearing all the time. July the 6th, just a few short weeks away. And that's going to be, of course, a big investment of time and attention for me, certainly, and probably most of you as well. So let's get ready for it, guys. Get your time outside, get your chores done, get your garden all up and cracking, get all of the stuff squared away so that we can just be full popcorn mode. Nothing to worry about when it's time for the preliminary hearing to go down. So with that, guys, I'm going to go ahead and check out now. Thank you. As always, thank you for joining. Thank you for your support. Thank you for making the chat fly. And the chat's always a little more interesting, always a little more flavorful when we have Tyler Robinson to talk about. But that's okay, because differences of opinions are one of the things that make America great. When I say America, I do in this one mean all America. Okay, I don't just mean the United States. Differences of opinion are okay in South America too. At least in a lot of it. Maybe not everywhere. Maybe don't try to say that in Venezuela, but it is one of the things that makes us great is the ability to say what we think and talk to other people about what we think and hear what other people think about that. And when we do that reasonably respectfully, then that's one of the best things that we can be doing with our time. It's one of the most intellectual things that we can be doing with our time. It's just when we're assholes about it that tends to degrade and no longer be so helpful. So really appreciate the mods keeping that kind of thing in line for us, but also all of you who contribute to the chat really, really value what you do. So we'll see what comes next. Keep an eye on the Substack for the archive updates. I will continue to be on that in the coming days. And with that, guys, we are calling it a day. Thank you all again so much, and we'll see you next time.